Good morning, good morning, good morning. It's Thursday, it's July 18th. Lots to talk about in the law today on our live stream because there's lots happening in cases we've been following. And now that we're not in trial, we can catch up on some of those things. Today, we are catching up on not only what's going on in the Rust case, but we are jumping back into the world of reality TV. I'm sure you've missed it. I have too. And if you don't watch reality TV, you're still going to want to keep in the loop with what's going on in this lawsuit because all of the audacity, all of it. So if you're here to get the 411 on the behavior, we're going to talk about that. Plus, I found a little tidbit about Rust in a Deadline article that very much surprised me. We're going to cover that. And on the tail of the podcast yesterday, we're going to talk about the tea behind why the new judge in the Young Thug trial is out, because there's a story there that I covered very, very briefly when we were doing a summary of everything that's gone on in this case, but we haven't really touched on. So I'm sure some of you are just like, wait a second, what? So we have some very dramatic reality show-ish scenarios going on. And there's, people are just hooking up with people they shouldn't be hooking up with. And we're going to talk about it. So we've got lots to talk about today. The new motion from Attorney Bowles is 30 blup pages. So that's going to take us a minute. And then if you don't know all the Scandoval of it all, don't worry. I'm going to give you a summary of the Scandoval of it all. So for those of you that are like, I don't watch reality TV, I totally get it. I'm going to give you a brief rundown, but he is suing his ex for finding out that he was cheating on her. Your question is going to be, who even does that? If you watch VPR, you're going to know the answer is Tom Sandoval. How has Sheena responded? Did Tom Sandoval delete his socials? Sure did. Sure did. So there's some more legal behind everything going on with Tom and Ariana that I think really needs to be discussed, because yes, there's a lot of reality tea in this, but at the heart of the issue with Tom, Ariana, and Rachel is truly consent. That is the heart of the issue. California pushes the laws, especially when we're looking at laws regarding revenge images, regarding sharing images, regarding all of that. When we're looking at those types of laws, California really does push ahead of the rest of the nation. California has a veritable fuck ton of people within the state, and B, within particularly Los Angeles County, you have quite a lot in Hollywood, in public spaces where these types of private images being shared for nefarious and illegal purposes can have large scale consequences. It has consequences for everyone, but it becomes a much bigger issue when you are a actor, actress, public figure. And I think that's part of why some of these things get pushed forward out of California courts faster than the rest of the nation. We see that with laws regarding, pay for child actors. We're going to see, I think, that extend to the digital space, and are seeing that push into the digital space. We're seeing California push forward on laws with regard to AI created images, AI created non-consensual images. We're seeing that push forward with digital harassment. We saw them push forward with stalking. So some of those things, just a volume of people, volume of courts, and life experience, we see these push forward. So we're going to talk about what's going on with Tom and Ariana's case, because the legal side of it is legally very interesting. And then, of course, we have reality show drama playing out in court yet again, because this is now part of the reality playbook. It happens on the show. It happens in court. Sometimes people go to jail. I'm not saying that's happening in the Scandoval of it all. And meanwhile, Ariana's in Fiji running like Love Island. So just like living her best life. And I'm here for an unbothered queen, or at least the appearance of unbotheredness, because sometimes that's even more powerful. And she'll be back on Broadway. So while Tom is busy suing his ex because she found the video he took of his girlfriend while they were together without his girlfriend's consent as alleged, she's on Broadway. So, you know. And for those of you who are like, who are these people? Pretend we're having coffee and I'm telling you about a friend group that you don't know. It's going to be totally fine. We'll get there. But we're going to talk about Rust first before we get into the Scandoval of it all. The Scandoval that... What was I going to say? Emily, you can't do the dramatic voiceover voice and forget what the fuck you're going to say. Damn it. We'll fix it in post. Tape 2. The Scandoval that rocked the nation. When I saw Scandoval headlines on like CNN, I was like, what the fuck is happening? When my mom is like, what is Scandoval? I'm like, oh, Mom. Where do we start? And then it's like, how do you explain Vanderpump Rules to somebody? And where do you start? Because also there's like history there that's needed, but also there's not. She's like, why? My mother says this about everything with reality TV. She's like, but why do we care though? And I'm like, okay, so some of us do, some of us don't. Before I roll the intro, I'm going to tell you a real quick story. We had celebrities come into the courthouses I worked in all the time. Like all the time. It was not uncommon. It's LA. People have things going on. We had celebrity victims. We had celebrity defendants. You have celebrities show up on jury duty. It's not weird. Athletes, whatever. LA is a big county. But I was never more shooketh when somebody popped up to my jury panel to the point where I thought the judge was going to cut off my voir dire, because I was like, these are relevant questions. I swear they're relevant questions. Remember, the time period of this is early 2000, no, mid 2000s. We're not in the 2010s yet. Mid 2000s, maybe early 2010s. No, this would have been mid 2000s. So mid 2000s. And someone pops up on my jury panel and they go through like their jobs. Any of you who've been on jury duty, you've talked about your job. They were head of production for Jersey Shore. And I almost lost my mind. I was like, I want to ask you everything. Did you know Snooki was going to show up with garbage bags? Tell me more. Like, what kind of contracts do you all sign? Because they are getting fall down drunk. Like, what do the lawyers at like, you know, MTV, Viacom or whatever do with these people getting so intoxicated on camera that you're really worried somebody's going to get hurt, get in a fight, get arrested? And like, that's all good TV, but like, how do the lawyers do it? Was it Angelina with the trash bags? Somebody had the trash bags. So like, what is it? I always assume celebrities would skirt jury duty. No, they don't. They don't at all. They get called into jury duty just like everybody else does. Sometimes they get dismissed from jury duty if they're going to be a distraction. But no, they get pulled in. So I was dead. Monica said, Coolio, no big deal. Jersey Shore producer, totally fangirl. I mean, yes, Coolio was also a defendant in our courthouse, so a little bit different than on my jury. We had, Gary Vitti, the trainer for the Lakers, showed up on my jersey. I was like, can I say, like, it's been a great season while I'm doing voir dire, or can I not? So, Emily, when you have peremptory challenges, do you ever use them because you have no fucking chill? So, no, celebrities popped up all the time, like all the time. There's no list that just negates them from jury duty. If they have a driver's license, which is where most of the jury pool rolls pull from, it pulls them right in. And depending on where the courthouse you work at is, the courthouses are adjacent to Brentwood, Bel Air, Beverly Hills. They've got to come in just like everybody else. The people, celebrities and people with jobs in Hollywood did not complain as much. Do you want to know who complained the most on jury duty? Are we spilling? You guys, it's too early to spill all the tea. I normally bury this at the end of 3 hours, so only the most tried and true, dedicated and loyal law nerds hear the tea. But you guys are like, come on, spill the tea. Doctors. It was always doctors. It was always doctors. It was always doctors. Always doctors. And I get it. Married to doctor. I get it. It was always doctors. And it ramped up depending on the doctor. Like ER docs were like, hey, it's really hard for me to get coverage. ER docs, of all the docs, most chill. But as you ramped up into your surgeons and they were like, okay, so I have ER time booked out and I have people's surgeries scheduled for like the next 2 months. And if I miss 3 days here, I have to bump all of my surgeries. And like, I get it. Because imagine you're waiting for, I don't know, what surgeries have I waited for? Spinal fusion. And was in so much pain. Like if my surgeon had called and been like, we need to bump your surgery 2 weeks, 3 weeks, 4 weeks, I would have lost my mind. Like as a patient, I would have lost my mind. I'm like, I am in pain and I have an end date. Like I have an end date. And if you're going to bump that end date, I don't know if I can make it, man. Like I haven't, the end is in sight. So doctors, it was always doctors. And like, I totally get it. Surgeons, judges were a little bit more like, I get it if you have surgeries booked, but doctors who are like, I have a really busy calendar in my office. They're like, yeah. And people who are the sole provider of income for their family also have to miss work. So I know it's super inconvenient for you, but like, it's a financial hardship for this person who's like, if I don't show up at work to, be a stylist, I do not get paid. So, I mean, my job's important too. Always interesting, but surgeons absolutely complained the most. There was one. Girl, stop it. Nope, never. There was one who was just like, but Your Honor, if I miss work, people die. And we're just like, I mean, because there's no other doctors exist in the entirety of Los Angeles County. Sure, bro. So when judges were lenient with doctors, it was normally my schedule is quite complex because I do surgeries of this nature and they're very difficult to reschedule. And I have this many patients. So doctors that were, I'm just letting you know the circumstance and I'm here to do whatever, we're fine. Doctors who were like, if I don't go to work, people die, were not as well received because it's like, okay, I get it, but no one covers you? Surely. So doctors, always doctors. It was always doctors that complained absolutely the most. And it is what it is. And also it's not as if Los Angeles County is a small county that has 3 doctors that can do the thing they do. It's like, okay. Always doctors. All right. We're going to zoom into, well, we're going to talk about Young Thug first. Let me know where you guys are coming in from, what you're drinking. Hopefully you got to watch the podcast yesterday and it was informative. I hope it helped understand the amount of wrong reporting I have seen regarding the Young Thug case is staggering. The news reports I have seen about the judge getting dismissed all seem to say that the judge got dismissed because of the ex parte. And I'm like, don't you have lawyers on staff vetting this stuff? Like, are you not watching? No, the judge didn't get dismissed because of the ex parte. That judge did a shuffle around the topic, was just like, what we're going to like sidestep everything. That's exactly what the ruling was not. So it's really funny to watch all of the reporting on it and see just wrong. And I'm looking at it going, wrong, nope, wrong, all wrong. So if you didn't watch the podcast to go through the judge's ruling that people keep misreporting, it's in there. That judge was very much like the ex parte probably should have been in open court, but I'm not going to rule as to that. The failure to yeet thyself and then to defend thyself is what the problem was. So people have fundamentally misunderstood the ruling, but it is what it is. So y'all, I've got like all of the water in the Law Nerdy tumbler, but there's also still cold brew. Why? Because I slept in a little. Why? Because our 2-hour members only live last night was like XL. We just, things got a little wild at the end and we just can't stop, won't stop. So we ended up with a 4-hour members only. I make no apologies. No regrets. And it's time stamped because we did spend an hour fighting with technology, with the patience of the chat better than the patience of the EDB. So the EDB patience was lacking. The chat patience was on point. And then we got into talking about New Kids on the Block and all the rest of it. And, the creators that I met at VidCon and those experiences, amongst other things. Oh, and we went through Erlinda's interview on News Nation. So if you want to see any of that, guess what? It hasn't had any issues with the music we played. So when we're done here, make sure you watch, because at some point I'm gonna have to fix things, because at some point the music that we played is going to be an issue. But we don't monetize the members only streams, so we're gonna play some music. It's for commentary. Let's roll the intro. Let's get into this very lovely Thursday. Emily, are you in a good mood because it's like 75 degrees outside instead of 105 degrees outside? Makes a big difference in my quality of life. I'll see you guys in a minute.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, y'all. Let's see, what are we going to do first? We're going to do like a quick bitsy sort of a situation, even though QuickBits now has its own, QuickBits now has its where did my article go? QuickBits now has its own channel. So we keep you up to date over on the QuickBits channel, and we make sure you know about those in the Law Nerd app and keep those posted in the Law Nerd app. But we're going to do what is kind of a quick bit segment that we haven't done in a minute, because we've been in trial for 975 years. Like, it's been 84 years. We've been in trial for 100 years. So we haven't gotten to do any quick stories. We're doing a quick stories now on Young Thug. We've talked about the case a bit in the podcast. Some of you may notice that I very specifically did not say who the new judge would be. There is a reason for that, because I was not sure until we get a scheduled court date. I am not sure that the judge that this gets assigned to will stay. Here's what normally happens. Every single courthouse has a procedure to assign cases. It is normally random. Sometimes they go by last number of the case. Sometimes they go by last name. Sometimes they just go by who's up next and like who's on first. But they all have a process, and it is randomized in some way. So it's like, this case goes to this court. So the Young Thug judge got recused, and then the case went back to whatever their central calendar court is to redistribute the case. And it got re-rolled to another, not rickrolled, re-rolled to another case. And that judge was like, look, I can't promise I'm never going to give you up, because 2 days in, that judge absolutely yeeted the case. I think the judge was 100% right in why they chose to do that. So we're going to go through. This reporting is coming to us from Law 360. Appreciate it. 2 days in, new judge in Young Thug trial bails out. I mean, it's a little bit of a harsh headline. I think the judge, nope, that doesn't make it better. Let's see. We'll do it. Emily, there we go. Ooh, that worked so well. Okay. Things are working. You guys, things are working. Things are working. I should say we're in a new subject. So like, here we go, but things are working. I don't know I think the judge bailed for appropriate reason. Just days after taking over the long-running racketeering trial of rapper Young Thug after its last judge was forced out over bias concerns. I think that's a fair way to report that. The case's new judge said Wednesday she was stepping down due to one of her former deputies' romantic involvement with a co-defendant. How many of you remember this from early on in the case? When we've talked about all the people that have been arrested in connection with this case, the court deputy, not the sheriff, the deputy had a relationship with one of the defendants and got arrested for it. This judge's deputy had a romantic relationship with one of the defendants and got arrested. So for those of you that have forgotten the tea, we're going to go through that a bit more now. Why? Because when we get to Scandoval later, because who had inappropriate relationships with the defendants on their bingo card, right? In a brief order, Fulton County Superior Court Judge Ingram, who took over the case earlier this week after Judge Glanville was disqualified for conducting... Law 3... No! Your lawyers! Was disqualified for conducting an ex parte meeting with prosecutors and a key witness. Wrong. Wrong. Even that, wrong. That is not why. Go back and read the order again. My legal writing professor would be like, absolutely fucking night. Wrong, not. Wrong, wrong, wrong. Wrong, wrong, wrong. The judge was forced to recuse. The judge was removed from the case, was recused from the case, if you haven't watched the podcast yet, was recused from the case because the judge defended the recusal motion inappropriately. And the law very quickly says, not only do you have to send it to another judge, but you can't defend it. The judge did not send it to another judge and defended it. That's why he was recused. It's in the podcast. So after Judge Glanville was disqualified, she said she did not think it likely the incident that led to her former deputy's arrest would bias her judgment. But in the interest of avoiding yet another controversy in the trial that had already had more than a fair share, the judge said she would also pass the buck. Quote, because this court's former assigned deputy could be called as a witness in any future proceedings in the case. The court, the judge. The court, I lost my place. The court may be called upon to assess the deputy's credibility or rule on matters related to her criminal prosecution. This may undermine the public's confidence in the impartiality of the proceedings. If you are potentially a witness, yes, it's a problem. Agree. Couldn't agree more. Let's see if we can make this a little bit bigger. There we go. The judge's decision to step aside from the case, the longest running criminal prosecution in Georgia history, continues the string of upheavals in the trial of Young Thug. For a year and a half, 10 months, almost 11 months, was consumed by jury selection. The sprawling racketeering case against the musician was presided over by Judge Glanville. But the beginning of the end for the judge came last month when problems with an uncooperative witness blew up into a heated fight with Williams's defense attorney. We've already gone through that. Let's see. We went through all of Steele's stuff. We went through the judge being released. We went through the ruling. We went through it on the podcast. Matters that appeared set to resume under Judge matters were set to matters then appeared to resume. Can't read. Matters then appeared set to resume under Judge Ingram. Remember, the jury is still like on pause, like a housewife, until Wednesday's announcement stemming from yet another row last year. The incident began when the county sheriff's deputies requested a search warrant for the laptop of defense attorney Eric Johnson. Remember, there are right now 6 co-defendants on trial. There are 28 total defendants. There were 7. One got yeeted out to a separate trial. So there are 6 defendants on trial right now. There are 28 defendants total. Not all 28 of them are on trial right now. 6 is enough. It's a lot of people on trial. But this is one of the co-defendants' attorneys. Defense attorney Eric Johnson, who represented co-defendant Eppinger and allegedly allowed his client to communicate via Instagram during jury selection. Who was he communicating with via Instagram? Who's all up in those DMs? The defendant was accused of messaging with Stanley, a Fulton County deputy, and his paramour. Well, just like Utah. Utah's calling everybody a paramour. I think the media has decided that paramour is the word that is just being used for whatever the relationship is, to just be like, we're going to make it clear. So the defendant was messaging Stanley, the county deputy, and his paramour while they were both in the courtroom. Stanley was fired and arrested over her relationship, accused of improperly visiting his cell and conspiring with a relative to deliver contraband to him. Oh, those DMs have all the tea. The judge, who said Stanley was at one point assigned to her courtroom, wrote Wednesday, while the court does not regard the aforementioned situation as creating actual bias. I agree with the judge on that. For or against any party in the case, the court does view this matter that could cause a reasonable person to question the court's impartiality and reasonably give rise to the appearance of impropriety should the court remain on the case. This judge could end up pulled into this case because of everything that happened with her deputy, with the defendant, and with the defense attorney. Like, the defense attorney's computer was searched. The deputy was arrested. And the deputy was conspiring to bring contraband to the defendant. So could the court reasonably end up mixed in this? Yes. The court could get mixed up in this. This case has been reassigned to the Superior Court. Judge Whitaker, court records show, and I don't know if Whitaker is the assignment court and it will go out or if it will stay there. The state of Georgia is represented by the DA's office, the defense represented, or one of the defendants represented by Steele. I mean, come on now. They're having clandestine meetups in lockup at the courthouse, it seems, arranged by DM, with the defendant using his attorney's communication devices to communicate with the sheriff's deputy, his paramour. Oh, courthouses. Y'all, when I say courthouses are nasty, I mean that courthouses are nasty. I have had coworkers be exposed to tuberculosis, myself included, MRSA, every level of everything that you can imagine. Courthouses. Look, man, bring wipes. If you just bring wipe down surfaces you have to touch. Bring all lawyers carrying hand sanitizers well before 2020. All the courthouses. Oh my. So the second assigned judge to the Young Thug case is out because that judge had worked with the court deputy that got arrested for hooking up with one of the co-defendants. But I'm sure they were meant to be. They understood each other, and sometimes you just have to, you have to go the meatloaf route and say, I will do anything for love. Apparently this one didn't involve a but I won't do that. So we're just stopping with the I will do anything for love. We're just gonna full stop. Are you guys ready to talk about Rust? Some of you are like, girl, I'm eating. Apologies? Also, courthouses are. Yeah, they're their own thing. We're going to talk about Rust. Before we get to Attorney Bowles' motion regarding Hannah Gutierrez, we're going to talk about an article that reported from Deadline, but I have not seen much discussion of this, to which I am very surprised, because this is talking about the wrongful death action from Helena Hutchins' husband versus Alec Baldwin that had settled. But maybe not so much. So we're going to go to this article from Deadline and take a look at what they have to say about all of this. Headline coming to us again from Deadline: Helena Hutchins' widower vows to take Alec Baldwin back to court over fatal shooting of Rust cinematographer. There we go. Thank you, reader mode. So this is interesting, right? Exclusive: Alec Baldwin has today just seen the sudden dismissal of his case. We know that. Almost 2 years after Baldwin and Rust producers reached a settlement with the Hutchins estate and her grieving husband to end the wrongful death lawsuit, the lawyer for Matthew Hutchins today made it clear that circumstances have changed. So the settlement of the wrongful death suit might not be all the way done. This had settled, but we need to go back through and see if it's all the way done. Brian J. Parrish is the attorney for Matthew Hutchins, Helena Hutchins' husband. Quote, "We respect the court's decision," Brian J. Parrish told Deadline. We look forward to presenting all the evidence to a jury and holding Mr. Baldwin accountable for his actions in the senseless death of Helena Hutchins. Whether the court appearance will be a continuation of the initial wrongful death action filed in February 2022 or a breach of contract agreement suit is unclear right now. Hutchins was killed and Rust director Jill Souza was injured. We know that. We know all about Baldwin's charging, recharging, and dismissal. We were there. It goes on to talk about the fact that the agreed upon funds due to the Hutchins estate have not yet been paid by the Rust team as scheduled. And now, months and months behind, this could get very messy for Baldwin. Again, sources tell me. As it is, the early 2022 filed wrongful death suit is actually still open in the New Mexico courts as various defendants and insurance companies continue to bicker on the docket. 2.5 years ago, as Santa Fe law enforcement were in the early stages of what ended up being a pretty bungled investigation. That's kind. Parrish's suit for Matthew Hutchins and the couple's young son was very strictly focused on the corners seemingly cut and the risks taken in the $7 million Western Indy. Quote, defendant Baldwin, the producers, and the Rust production company were aware of firearm safety issues that had occurred on the set of Rust and did not take action to correct the situation and ensure the basic gun safety rules were followed on October 21st, 2021, the filing said. And we went over that filing back in 2021. Back in 2022. Had defendants Baldwin, the producers, and Rust production companies taken adequate precautions to ensure firearm safety on the set of Rust, or if basic firearm safety rules had been followed on the set of Rust on October 21st, 2021, Helena Hutchins would be alive and well, hugging her husband and 9-year-old son. At the time, the Albuquerque-based attorney estimated trial for the unnamed compensation wouldn't occur for another 1.5 years. Actually, it seemed to be solved within a few months, as the parties announced the settlement in early October 2022. The deal would see money paid to the estate, a documentary on Hutchins, money paid to the estate, a documentary on Hutchins. That's the first time I've heard that, by the way, that part of the settlement was a documentary about Helena. That is the first time I've heard that information. So money paid to the estate, a documentary on Hutchins, and the starting up again of Rust with Matthew Hutchins' blessing. And under the settlement, Matthew Hutchins came on as a producer so that he would take part of the revenue from the movie. Under the settlement, Hutchins' now 11-year-old son would see a portion of the payouts made available to him in installments between his 18th and 22nd birthday. It goes on to say, I have no interest in engaging in recriminations or attribution of blame to the producers or Mr. Baldwin, Hutchins said in a statement at the time. All of us believe Helena's death was a terrible accident. I am grateful that the producers and the entertainment community have come together to pay tribute to Helena's final work. The idea was the wrongful death suit from Hutchins would be dismissed once the settlement was approved by the judge, which was formally done on June 1st, 2023. However, Hutchins never received the money they were supposed to in a timely fashion soon afterwards. That sounds awkward. That seems to be in part due to disputes between Rust Movie Productions and the insurance company, which apparently is named Chubb, a topic for another day. The lack of payments for the past year to the Hutchins estate also is connected with the nearly $1.6 million in New Mexico tax incentive that Rust was awarded. Unsurprisingly, with all the bad press and the unwelcome spotlight on the Rust shooting, or that the Rust shooting put on New Mexico and its burgeoning film industry, the state recently pulled the plug on the tax credits. Those tax credits were supposed to be some of the funds for the Hutchins settlement. The denial of the tax credit has disrupted those financial agreements Rust producers, attorneys, Spadone told the AP earlier this month. They haven't paid out the estate. So there is either going to be a breach of settlement lawsuit or they're going to reopen this lawsuit, but the estate was supposed to be paid and the estate hasn't been paid. I had not seen this before any of this. I didn't know that making a documentary about Helena was apparently part of the settlement agreement. And if that's true, when the prosecution, Morrissey, was talking about being upset that a documentary was going on, apparently connected to Baldwin, connected to Rust, why didn't Baldwin's attorney say that was part of the settlement agreement? Like, why wasn't that information known? But according to Deadline, if this is accurate, it was part of the way to honor the work of Helena Hutchins as part of this settlement agreement. But the financial payments haven't been paid, it seems, in the time they were supposed to be. So do I think we will see the wrongful death litigation against Alec Baldwin and Rust Producers reopen or open in a breach of settlement? Absolutely, based on these statements. I absolutely think now that we are done with the criminal, we are going to see the litigation reopen in the area of that wrongful death suit to determine why things haven't been paid. Not all of the wrongful death suit is done yet. There are still entities fighting over that wrongful death suit. I wonder if the reason Baldwin tried to resolve it so quick is so that if the criminal trial went forward, it would look better for him, which feels very Murdaugh. It's like, no, it's all done. Everything's great. It won't come up in the criminal case, but nothing is paid. So Baldwin's legal troubles aren't done. Does this mean that Baldwin himself is going to be writing checks? No, it doesn't mean that Baldwin himself is going to be writing checks. This goes through the production company. It goes through insurance. It goes through others. This is not Baldwin writing out those checks, but he is going to be dragged into this again as a producer, and this is not done. So we'll be seeing more from the wrongful death case that I thought was resolved. Let's talk about Hannah Gutierrez, shall we? We're going to take one moment. I saw a ton of questions. Your guys are like, did he pledge it? I mean, it really was pledged because the settlement agreement would have said it will be paid, and the settlement agreement would have said the amount of time it would be paid in. And they're saying the payments are not made and are now beyond the time that they have to pay it. So the producers are all going to get dragged back into this because it has not been paid in the time that it was supposed to happen. We also had a couple, more than a couple gifted memberships that we need to say thank you for. Vicky Thomas, thank you for the 5 gifted memberships. Lizzie H, thank you for the 40 gifted memberships to the community. That's incredibly generous. For all of you that are new members, go find the Lawnard After Dark episode in the Members Only Live. I think it's hilarious, and it is a member experience that is not to be missed. Binks, thank you for the 5 gifted memberships, you guys. Oh, thank you so much for your generosity back to the community always. I very much appreciate it. So for all of the gifted memberships, thank you so much. We appreciate you. Mia, as I was talking about the spinal fusion, can you imagine? Mia says spinal fusion today, watching from the hospital. Good luck, recover well, and I'm sure it will go amazing and that you will feel better. It is a long journey to healing, but it's worth it. For me, it was worth it. Susan, thank you so much for the 5 gifted memberships. We'll have to give some memberships. I'll give some memberships today. I don't think I've gifted any since we ended this trial, so we'll have to. For those of you asking how you get gifted memberships, Nightbot puts information in, and then the mods can let you know. You've just got to go turn it on in your account. There are very few types of accounts that can't receive gifted memberships, but it'll tell you that in the back end. Emily, please make a shirt that says, I'm not late, I'm in the buffer zone. It's like the danger zone. I'm not late, time is a construct. We'll think about it. We've got new merch coming for you guys, so we'll definitely think about it. I saw a few of you asking if my Metallica shirt glows in the dark. It doesn't. I wish it did. But when I was talking about getting through the Milwaukee airport so seamlessly, because it was just an easy and lovely experience coming back from the Dave show, when I was asking if I needed to take off my giant like travel blanket wrap thing that I wear, they were like, oh no, you don't need to take it off. You just need to show me your Metallica shirt. And I was like, my Metallica shirt is amazing. It's a shortest straw shirt. So at the bottom, it says the shortest straw has been pulled for you, but I'm not going to like Phil DeFranco the thing and lift up the entire shirt. We don't stream like that. If you don't know what I'm talking about, it was on Phil's Instagram. It's a whole long story, but if you don't know what I'm talking about, it's over on Phil's Instagram. Some of you probably know what I'm talking about, but no, it's not that kind of stream. We're just rocking our band tees because music is life. Let's continue into talking about Rust. But I love this shirt, so we don't stream like that. His quote on look, man, the amount of shirtless men I have seen between the New Kids on the Block concert and Phil's Instagram has been substantial. But my husband is just like, oh, it's a thing. I'm like, apparently. And he's like, great, I'm just going to walk around the house without my shirt on, which all of the men and boys at my house do all day long. But Phil said, I'm taking a page out of Hassan's book and promoting my live show by showing some skin. So when I say we don't stream like that, we notify in other ways. So with all of that, let's get back to the Rust case with Hannah Gutierrez. Hannah Gutierrez was sentenced back in April for the wait, what is happening? Why are my tabs crashing? Okay, breathe, Emily, breathe. Streaming is dynamic. Hannah Gutierrez was sentenced back in April to the maximum potential sentence of 18 months for the involuntary manslaughter regarding her behavior or, failure to do her job on the set of Rust. There was a mutual defense agreement. We didn't talk about it a ton because we talked about it in context of other content, but there was a mutual defense agreement between Hannah's lawyers and Baldwin's lawyers. Because there was attorney-client privilege, one lawyer can't just tell another lawyer things without consent from their client. So that existed to allow them to share information. I think that ended up being very, very helpful to Baldwin's team because everything that happened with Troy Teskey, Baldwin's team was aware of. I would suspect they were aware because of Jason Bowles. There is nothing wrong with that. Bowles has consent from his client to tell them what they know. There is nothing wrong with Bowles telling them whatever he knows. If the prosecution had turned over what they were supposed to turn over, it wouldn't have been an issue. What Bowles said to them wouldn't have any impact whatsoever. So they were allowed to share information with one another. After the dismissal of Baldwin's case last Friday, we saw Bowles making the rounds on media saying, I'm going to immediately be asking for a new trial, a dismissal, and Hannah to be released. The standard for Brady violations after trial and during trial are different. So Bowles is not similarly situated in a lot of ways to Baldwin. The Hannah Gutierrez legal fight is a little bit harder because Hannah's got to prove that the jury essentially would have decided something different. And I don't know if we're going to get there because of the evidence about her doing her job. For Hannah to do her job, let me know what you think in the chat. Hannah's job is to check every single thing that goes into the gun. Does it matter how the live rounds got onto set for her? Because she is the safety check. So live rounds are on set. She has to check them to make sure they don't go into the gun. So does it matter where they came from? Because for me, it doesn't matter where they came from because it's her job to check it and to find that round and then to shut down the set and find if there's any other ones. Her job is safety. So does it change the jury's decision about whether she did her job with due caution and circumscription if the weapons came on somewhere else? If someone else loaded the weapon, completely different scenario. But if she has a box that has stuff mixed into it, it's her job to know everything that's in that box and to check it and then double check it. And if she doesn't have time to check it, to stop production and make sure she has time to check it. That's her job. So did she do her job with due caution or circumscription? That's the question for the jury. There's no evidence that somebody else did something with the weapons. If that is the case, if that is the evidence, we've got a different scenario. So this is a first look at Bowles' motion. I have not looked at it yet. I have not read anything about it yet. I want to go over it with y'all first. Here's what I'm curious about. Do they bring up the Troy Teskey stuff? Yes or no? Do they get into the gun expert reports that we heard discussed that weren't turned over? In cross-examination of Kari Morrissey, Baldwin's attorney Spiro was asking, didn't it seem odd to you that this witness wasn't being cross-examined on those reports? And she's like, well, no, that wasn't the point here. But it seemed that those reports were turned over to Baldwin late and were also a Brady violation and weren't turned over to Hannah's attorney at all, period. So I'm curious about those two things. The Teskey stuff, the Hague reports. That is what I'm really curious about as we get into this motion from Bowles. That's what I'm looking for, because what I don't think we're going to get is any explanation of where Bouillon went. Like, do I want the tea on that? Yeah, I do. I want to know where Bouillon went and why. What happened between him and Hannah? Like, shit we're never going to know. I want to know. I want to know. What went on there? Tell me. Tell me why. Okay, let's get into the motion with from Bowles regarding Hannah. All right. This is from July 16th, 2024. Let's see if we can make this. No, that makes it harder to read. All right, let's just do it. No, don't do it that way. Can I move this? Not at all. Oh, sometimes documents are harder than everything else. And we're new setup. We're just new setuping. Defendant Hannah Gutierrez, we're back to using Reed. Like, sometimes she's using Reed, sometimes she's not using Reed. They made a motion to not use Reed. Then there was a motion to use Reed. I don't know what they're doing, but sometimes yes, sometimes no. Defendant Hannah Gutierrez's expedited motion for new trial or for dismissal for discovery violations under the court's inherent power. Let's see if we can make this just a little bit. Can we make this just a little bit bigger? No, we can't. Oh, there we go. Wait. I don't want to cut off the words because that would make me crazy looking at it, and it's going to make you crazy looking at it. Oh, there we go. We're just gonna do it. Look, man. Having to deal with switching all of our tech setup last night made me want to scream. So when things are working today, we're just giving ourselves all of the praise. We're just sitting here and my brain just being like, you did it, bitch. Let's keep going. Chat's like, good girl, Emily. Thank you, everybody. Thank you, chat. I appreciate it. We've got it like an adult professional streamer here. We've got it figured out. We are professionals here. So this is either new trial or dismissal. Dismissal, unlikely, but let's see if my mind changes. We watched me change my mind all day long on Friday. New information, new opinion. Law, it's like, well, what if this? Well, then a different result. What if this? Well, then a different result. I don't know. We can only decide what we can with the information that we have until that information changes. Baldwin's trial exposes extreme misconduct. Special Prosecutor Morrissey lies to this court under oath. So, whoop, there it is. I guess we're starting with Morrissey under oath. Did everyone tell Kari Morrissey this was a bad idea? Yes. Did the court strongly signal to Morrissey that this was a terrible idea? Yes. Yes, they did. They 100% did. In a hearing on July 12th in Mr. Baldwin's case, Ms. Morrissey took the stand calling herself as a witness and lied to this court several times. Corporal Hancock testified Miss Morrissey was in on the decision to file the Teskey rounds in a separate file. Yep. Yeah, she said that. On direct examination, however, Miss Morrissey stated she never knew it would have a separate file number. I don't know if you can count that as a lie. I don't know who's correct in that scenario. I really don't know who's correct. So he's going to go with, obviously, Hancock is correct, but I'm not yet convinced without further information. But anyway, Morrissey alleged in response on cross-examination that Erlinda Johnson had resigned that day because Ms. Johnson didn't want a public hearing on the Brady violations. This was false. In a media interview the same day, Ms. Johnson explained that she resigned because of her ethical duties as a prosecutor and that she had argued that the case should be dismissed by the state because of the late disclosure and that she was overruled, obviously, by Ms. Morrissey. Well, she said she was overruled by Morrissey and wasn't listened to. And Erlinda Johnson was like, no, this is late discovered. You have to dismiss the case. Morrissey apparently said no to her. She walked off the case mid-hearing. Morrissey very much parsed her statements very narrowly on the stand about this. I'm wondering, let's pause real quick. Shall we go take a look at exactly what Kari Morrissey said? I feel that maybe that's what we need to do and just take a look as to Erlinda Johnson, exactly what Morrissey said. So we're going to just take a pause for a moment and go to court real quick and take a look at that part of Morrissey's testimony. So that was right on the beginning of cross-examination. So we're going to see, y'all, cross your fingers for me that this works with audio. We're going to be optimistic together, but this is where things weren't working. And we're going to hope that, in fact, they are working today. So let's go to court real quick and take a look. Did I plan on doing that? No. Do I think it'll be helpful? Yes. Do we love a moment in court? Of course we do. Of course we do. So let's see. This should be the beginning of cross-examination. And let's go take a look at exactly what Morrissey said about Erlinda Johnson, because I think this is an interesting thing given all of Erlinda Johnson's statements since.
Said in response was, great, do that.
That is not the part we were looking for. Let's see. This is her on the stand. Is this cross-examination?
You can hear on the video that the court...
That is not cross-examination yet. Those are the photos.
Sheriff's Department, but you are right.
And you concede that they are Starline brass.
Nope, that's still cross. Let's see if we can get to the beginning of cross-examination. There we go. I hadn't gone far enough.
I don't think it's necessary, frankly, for this.
All right, perfect. That's the beginning of her testimony. Where is the beginning of cross? I hate it when stuff's not time-stamped. This is why we timestamp everything. It's so frustrating.
Have hurt the case.
Served a certificate of compliance with 550.
There
Yes.
we go.
So when Ms. Russ...
No. Hopefully you guys can hear it, though. Let's just find where we need to be in this testimony. I am trying to get to Spiro's very beginning of cross-examination, and that isn't it, because she talks for a few minutes. Let's see, before he comes up. So let's try to get us I'm just trying to get us exactly to the beginning of cross. And I think this is all right. I think this is exactly the beginning. Fingers crossed.
And that's all of the information that I can give the
There we
court,
go.
but I'm happy to answer any questions.
Thanks, chat. Yay, audio.
When you took over this case,
Mark, you're not alone. I did an interview with Sir Mix-a-Lot. At the end of the interview, we discussed this, so you are welcome. And Mark said in his chat, I've gotten addicted to Emily D. Baker. I I know it. Look, court is a habit. We need to know all the things. And now we want to know everything, right? I want to know everything. Never underestimate curiosity. Maybe if these investigators had been curious a little bit more, we wouldn't be here.
Investigator handling.
How hard chat? I'm going to let him finish. How hard is it to be nosy? How hard is it to be nosy? Like, what are you doing? Why are you being so helpful? How hard is it to be naturally curious and nosy? Come on now. Don't you want to know everything that fucking Seth Kenney was up to? Don't you want to know every single detail? Why are you talking to Sarah Zachary so much? What are you two doing? What's going on? How hard is it to be nosy? Not at all. Don't you want to know if somebody's going to give you everyone's text messages? Don't you want to read all of them? People ask, Emily, why did you like white collar cases and fraud? Dude, you learn all the tea going through people's bank records, their DMs and their Facebook, and you get to do it for your job. Your job is to read through people's DMs and be like, oh, what are you up to? All you have to do is be curious and ask questions. And then you can write search warrants to get everything. All of it. How is there no curiosity? Just lean in.
The case, Mr. Schilling left the case, correct?
At my request, yes.
The paralegal that was handling this case with you left the case, Mr. Tatt.
At my request, yes.
Well, the first prosecutor that was working with you on this case, you selected, correct?
I did.
And he resigned too?
I wouldn't say that he resigned, no.
Okay. He didn't stay on the case for the Alec Baldwin trial, correct?
No, and he indicated that that was because he represented a labor union that's a national labor union, and he was not expecting the trial to be set so quickly. He wasn't expecting it to be set in July. So when he realized that the trial was going to be set in July, he was going to be in collective bargaining agreements for his national labor union, and he wasn't going to be able to have enough time.
Erlinda Johnson, the next prosecutor selected, resigned from the case today.
She did.
There it is. Erlinda Johnson resigned today. Look, the way I was so shook when this went down on Friday, you guys, this is at 720p, so there isn't anything else I can do. I know it's a little bit grainy. This feed was grainy, but it doesn't have stuff scrolling across it, which always makes my eyeballs hurt. So that's why we've got a little bit of grain in the feed, but we also have subtitles on this one, which a lot of feeds don't. So we went through this on Friday, and I was so shook that this was happening that I don't think I processed all of it. So now going back and taking a quick look is really, I think, helpful. So let's see exactly what she says. You know what? And maybe if I make this a little bit smaller, it will not appear as bad as it appears. Fingers crossed, but it is not. Getting feeds out of court and getting the data to get feeds out of court is a whole separate situation. And so I'm not surprised when networks put crap all over the feeds. It's just so frustrating.
Based in part on the conduct we're here discussing, correct?
I believe that Ms. Johnson...
I'm going to back this up. Look at her shaking her head. He says, based in part on the conduct we're here discussing. Erlinda Johnson says, abso-fucking-lutely. My words, not hers. She would literally never on television say abso-fucking-lutely based on what's going on here. What she said was, no, I left because I have ethics and, morals. That's what she said.
Erlinda Johnson, the next prosecutor selected, resigned from the case today.
She did.
Based in part on the conduct we're here discussing, correct?
I believe that Ms. Johnson has Ms. Johnson didn't want there, my understanding is that she
started that sentence 4 times. Started that sentence 4 times. I believe Miss Johnson, my understanding, and immediately was like, no, not based in conduct here. Yes, immediately based on conduct here.
She did.
Based in part on the conduct we're here discussing, correct?
I believe that Ms. Johnson Ms. Johnson didn't want there, my understanding is that she didn't agree with the decision to have a public hearing.
Didn't agree with the decision to have a public hearing. Here's the thing. This Kari's under oath and also owes a duty of candor to the court. Didn't agree with the decision to have a public hearing isn't 100% wrong, but it leaves a wrong impression. But it's not 100% untruthful, because Erlinda did disagree with having a hearing, public or no. Erlinda disagreed with having a hearing. Erlinda said the case needs to be dismissed. Kari is parsing it to leave a wrong impression, but is not, which is a problem, I think, for her duty of candor to the court. Would it be an issue where law enforcement is going to look at that narrowly parsed, I believe, I think statement and go down the route of like perjury? A lot of you have asked. It's very hard. So do I think it's an issue for duty of candor to the court? I absolutely do. I think that leaves the wrong impression. Erlinda did disagree with having a hearing because Erlinda thought the case should be dismissed. Kari left that part out, right? So the wrong impression is a problem, but it is a very parsed, and you could see her parsing. You could see her parsing at the beginning. So leaving that impression is not great. We'll see what the court does. But Erlinda was very, very clear. Let's see the end of this sentence, and then we'll move back to the motion.
On July 1st in this matter, you served a
that's the end of it.
certificate of compliance.
So we'll probably come back to this because when they talk about the certificate of compliance, they also talk a bit more about the Hague reports in that. But Erlinda very clearly said, I learned about it when the public did. We have a duty as a prosecutor not to get convictions, but to present a case to the jury and to do justice. And based on the evidence I learned of, it was our duty and obligations. It was our ethical duty as prosecutors to dismiss the case. And I was overruled, and so I left. That's what Erlinda said. So with all of that, we're going to get back to this motion. So, C, Baldwin prosecutor resigning, Erlinda interview with Chris Cuomo, available on X, Twitter. Ms. Morrissey instead decided to plow ahead and continue to win at all cost. Plowed ahead in her continued win at all costs attitude in the Russ case, which is not the role of a prosecutor, right? The role of a prosecutor is not to win. The role of a prosecutor is to present facts to a jury and let the jury decide if those facts match the crime that's been charged. These are the elements of a crime. Do these behaviors, do these actions, do these facts meet? Do they match up? And if they do, crime. If not, no crime. That's the job of the jury. Crime, no crime. The crime, and the defendant's connection to the crime. As one of my mentors would always say, keep it simple. Second, Morrissey represented in response to questioning that she asked her prior paralegal to resign. That was factually untrue. The paralegal decided to tender his resignation unilaterally after sending several emails to the DA's office about his working conditions and the conduct of Morrissey that led to his unilateral decision to resign. The paralegal emailed this to undersigned counsel and executed an affidavit. Wow. Third, Morrissey represented that undersigned counsel did not want the Teskey rounds and believed they inculpated Miss Gutierrez Reed. She did say that. This is an absolute falsehood. Oh, Bowles is going to have his moment. Lies, he says in this motion. Lies. Some background is necessary on this point. The state had been aware and had access to Teskey for years. Seth Kenney, we're relitigating. The court knows this. We know this. We watched all this go down. But for the sake of everyone whose brain on Friday was like spent in a swirl of wait, what the fuck all day long, maybe the recitation will be helpful. Seth Kenney called Teskey during a November 1st, 2021 interview with then Detective Hancock, after which Teskey sent a picture of a sampling of ammunition, and the sampling had bronze primers and didn't match the live rounds on set, which had nickel primers. Yes. There was no further follow-up by the state, even though undersigned counsel texted Detective Hancock asking her to contact Teskey. Hancock also misrepresented at the hearing. Hancock misrepresented at the hearing by saying she called Teskey multiple times with no response. Hancock in text messages told undersigned counsel she had already talked with Teskey. Ooh. If true, that's not good. Because Hancock absolutely the fuck said that. On and on in cross-examination, Hancock was like, I mean, I can't write a supplemental report if people don't talk to me. On and on and on and on. What am I going to report? There's nothing. I can't report nothing, and never wrote a report that there were no callbacks or anything. I don't know what phone I called on. And didn't the defense say, but Teskey has no missed numbers from New Mexico? And she said, well, it would have been unlisted. On and on and on. Like it was a central part of why is there no report was Teskey didn't call back. Hancock in text responses told counsel Bowles that she had already talked with Teskey. Quote, yes, I've been present for most of the phone calls and have spoken to him. To be fair, arguendo, we don't know the timing of this. Sus, but we don't know the timing. Would I want to know more? Yes. Also saying, I'm aware I've seen them and spoke to Troy. I wonder if that was... There might be a timing issue here because these statements to me, and this is me going arguendo, right? So I'm not saying what Bowles is saying isn't true. I'm saying, could it be interpreted differently? Here's what I'd want to know. Is this text exchange at the point of time when the photos were sent in November 2021? Because if these text messages are around November 2021, then that was true. But did she talk to Troy Teskey after March 2024 when he brought the rounds to law enforcement? If these responses are after 2024, then it is inaccurate to what she said on the stand. If these texts are around that 2021 conversation, then they are accurate at that point in time. So there's a timing issue on this, and counsel does not clarify, which leaves questions for me as the reader. And as we're going through this again, I'm going to raise the questions as I see them. It doesn't mean I disagree with Bowles' assessment that this behavior shouldn't have happened. I just want to know the date of those texts. Because I don't necessarily, I don't know that this representation is, I don't know that this representation is in time to after the bullets were dropped off. That's the relevant time period here. After the bullets were dropped off. And here's what frustrates me about leaving this vague. There is so much to attack on what happened with the prosecution and law enforcement. If the defense leaves impressions that can easily be refuted, it allows Kari Morrissey, who is the attorney that's going to be responding to this, to attack these inaccuracies and not address the bigger points. Do not give them any room to say, this is misrepresented. None. Give them no room. Dude, nail this down tighter than, I don't even know where that analogy is going. We're going to back right up. Close it tighter than Dracula's coffin or whatever. No light. Just, it needs to be so irrefutable that they have to address the key issues. Because Morrissey does this in motion after motion after motion. Stephanie in the chat said tighter than Linda's clam. Yes. If you're not a member, that makes no sense to you. It's in the members only live streams. Yes, this. So don't leave the wiggle room. Just, there's so much here. And we've seen Morrissey do it in motion after motion after motion, where she will address a few points that she wants to address and be like, they're fucking lying. And then she'll be silent to everything else. Don't let her do it. Zeke, it's good to see you, friend. Don't let her do it. Don't let her do it. Zeke, by the way, for those of you in the chat, Zeke is on Team Baker as part of our content and production team. So say hi to Zeke in the chat, y'all. I know you guys make Reed internet famous. So Zeke too. Internet famous in his own right, but Zeke too. So the timing on that I want to know about. In a November 2nd, 2023 partial interview of Teskey, the rounds were again discussed, this time with Morrissey. She talked about that on the stand. During the interview, Morrissey specifically asked if Teskey would give her the ammunition from the batch that Reed and Kenney had taken to the 1883 set. Teskey agreed he would preserve it and provide it to Morrissey, and Morrissey indicated he should, and that she would work with law enforcement to collect it. That's what she said on her testimony too. Thereafter, Teskey was afraid to do anything with the rounds except preserve them for law enforcement, which he did. Fair. Morrissey never followed up. The undersigned, Bowles, sent an email to Morrissey on January 8th, 24, asking if the state was going to retrieve the rounds and test them. Because the defense attorney and Teskey were in communication, and so the defense would have known that Teskey's like, dude, I'm still holding on to these. What am I holding on to them for? Counsel stated in an email that testing was important to compare the powder of the Teskey rounds to the powder of the live rounds found in the set of rest. The prosecution made much about that in Hannah's trial. The motion continues to say this had been done by the FBI through the state, as the FBI had done the original testing and analyzed the powder, the difference between like the shoot loops and the discs. It goes on to say undersigned counsel had repeatedly told the state that it needed to test the Teskey rounds and make the comparison. The same day, however, for the first time since November 2nd, Morrissey emailed back that she did not plan to retrieve them or test them because she found them visually dissimilar and not relevant. Astoundingly, Morrissey told this court in the July 12th, 24 hearing that she had never seen these rounds until July 2nd during the evidentiary hearing. I think that's true. I also agree that it's stunning, but I think that's true. I think she never saw the physical rounds. I don't disagree. I think she should have. It was her job to know because police had them in, because law enforcement had the physical rounds in their possession. The law assumes that the prosecutor knows what's in the bag. It doesn't matter that she doesn't actually know. That's why as a prosecutor, it is critical that you have to know. And you have to know what you don't know, which means you have to ask the questions, back to being nosy. I can't believe Morrissey doesn't know this. I would imagine she's acutely aware of this. So if law enforcement has it, it's as if the prosecutor knows it. If one member in law enforcement knows, the law assumes the prosecutor knows, even if they don't actually know. I know that sounds confusing. Hopefully that's clear. It is to stave off somebody going, I don't know, like the willful ignorance. You can't have a prosecutor come into court and be like, I had no idea that was in evidence. Oops. No, still a Brady violation. So that's why the law allows for that assumption, because you're all part of the same team. And so it doesn't matter if you didn't ask, you're still responsible. And you know what that does? It makes prosecutors ask, because they don't want to be caught off guard. It makes them ask. So it was clear in the hearing that 3 of the rounds were visually like the rust set rounds. Accurate. Which contradicted Morrissey's statements in her January 8th email to undersigned and Miss Morrissey's in-court statements from July 11th. Honestly, with that, I think she didn't know. It doesn't matter for the Brady stuff, but I think she didn't know. She might have chosen to not know, but I think she didn't know. I think she saw the pictures and assumed, I believed her in this. It's not appropriate. It's not her doing her job, but I think she saw the pictures and assumed what was turned over to police was the exact same thing in the pictures. And she was like, I don't care. They opened it in court. I can only imagine that, like, she got bubble guts. Like, how do you not? Looking at those going, oh, fuck. Like, how do you not? How do you not? So in her emails, she said they were not the same as the set. In court, she said they weren't the same as the set. And in court, she said she never saw them until in court. It said, see also the Erlinda Johnson interview, and the Erlinda Johnson interview said she had never seen them either. Further misconduct by the state unearthed in the hearing was that CST Popple had been... Y'all, I apologize. This is the doctor. Give me 30 seconds to see what he needs. I'm going to put on your music. Give me 1 sec, B. I am streaming. Give me just a second. Let me put on music real quick. Chat, I'm going to mute myself. I will be right back to finish this motion. Well, that was critical. That was critical need. And that was absolutely my fault. Apologies to Dr. B. I updated the password for our Chipotle app. And T and Dr. B are trying to order Chipotle for pickup. And I am apparently the keeper of the keys in this, so I need to send them the updated password, because they are like, we need when you need Chipotle, you need Chipotle. So summertime, can't stop, won't stop, and I need to pull that up and send that to them, because how do you deal if you don't have the Chipotle password? So I have caused critical error in the day of my family. So let me message them what I think it is, because apparently they are also locked out of our password manager, which is probably also my fault, because yesterday when we were dealing with all of the tech stuff over here, part of the dealing with all of the tech stuff was also doing new browsers had locked me out of all of our password managers. And like, the thing about digital security, as we soliloquy from this for a minute, the thing about digital security is it's so needed, but there are times when it can be such a hassle, which is why people don't do it. But it is so frustrating. It is so needed, but it is so frustrating. So digital security, so needed. If it's not inconvenient, it's probably not secure enough. So, and then I'm going to have to get them all into their password manager. So with that, let us continue. let us continue. For all of you asking which password manager do I use, I would love to tell you. However, I think it makes it easier to figure out on the internet how to try to get into that. And I have had enough issues with people trying to get into all of my accounts. We can talk all about that another day. Sometimes working on the internet's delightful. It's been at moments unexpected, but so I'm not going to, but thank you. But no, there are several options. Everyone that does, there are several options for them. So I don't want to make it easier for anyone to try to figure that out. So thank you for understanding, because I think that is the wise thing to do. So that Amber in the chat, Amber Waves in the chat says, as someone who works in security, yes, if it's not inconvenient, you're not secure. But yes, let's see. They are still messaging. Y'all, I am streaming. Yes. It's not helpful. They're not watching me stream, so I can't just answer out loud. Me answering out loud doesn't help them at all. Let's see. Yes. Oh, I am not trying to make things hard on them. So, sorry, chat. Like life things at the moment and all the things. So, we're not going to do that. All right. Let's get back to the real things. Let's get back to the real thing, the real court things. I mean, the real thing is getting Chipotle. So, it is what it is. Real life. Also, Travis has, oh yeah, I'm sure he's getting food before band. Yeah, that Chipotle absolutely makes sense before band. Sometimes you need the meals that are going to stick. Our athletic endeavors normally landed us in the summertime at Taco Bell because food was so inexpensive and it was like quantity over quality. So our water polo team ended up at Taco Bell before practices, and they still had the like the doorway at the Taco Bell we were at had a like a height monitor, which is, I imagine, a security feature. So if somebody goes running out the door, you can be like, they were about 5 foot, 6 foot, whatever. So it had the markers on the door so you can estimate height. The way I got clowned on, especially my senior year, the way I got clowned on for being the shortest one on my water polo team, I mean, always, but the way I got clowned on for being the shortest one, I would walk through the door and they're like, oh, baby, you're not even on it. And I was like, shut up. I'm not 6'4". It just is what it is. So speaking of that, we've got to address Bridget's amazing super chat that says, did you see that Flavor Flav is the hype man for Team USA Women's Water Polo? The way I fucking love that Flavor Flav is the U.S. Women's Water Polo Team hype man. We're going to digress for just a second. I love the different relationships and fascinations that the Olympics brings together. Like, if we don't have Snoop Dogg commenting on like show jumping and dressage, I don't want it. I love all of it. I played water polo. I played water polo in college. I love water polo. I need them to be on camera when they explain to Flavor Flav what happens under the water. I need to see it. I need to see it with my eyes, right? I need to absolutely 100% see it. Heather Lamb in the chat said that horse be crip walking. That's exactly what Snoop said. And also no lies. I need Snoop commenting on all the Olympics. It's hilarious. The way I'm going to be watching Amy Van Dyken's Olympic commentary and the others, but Flavor Flav showed up in Arizona when we went to see Dave around the Super Bowl and was doing stuff before the Dave Matthews Band and then had pictures up with him in the Dave Matthews Band. I was like, this is the crossover I didn't know I needed and I love the most. But Flavor Flav has helped financially sponsor the women's Olympic water polo team because it is quite an endeavor and they do not get nearly enough financial support. And the U.S. women's Olympic water polo team dominates. Like, sorry, gentlemen, but the women have won gold since 2012, and they are not only the top of the top in the world, but they have like 4-time Olympians on their team. Like they have legacy players on their team that are absolutely incredible. And so all of the social media crossover between Flavor Flav and US Women's Water Polo absolutely makes me delighted. I think it is absolutely delightful. I love it. And I love him learning about a sport that is kind of unhinged, but if you don't know the sport, you don't know how unhinged it is. So I love it. I can't wait. I'm ready for all of it. And yes, I enjoy the Olympics. I enjoy it. Whatever. I enjoy whatever. John K said, and you would never beat the men's team. I mean, they beat them at the Olympics all the time. So there is that. The U.S. Women's Water Polo team has won since 2012. John, go ahead and let me know the last time the U.S. men's team won gold. I would love to know. So this, you're going to love this chat, buddy. Let us get back to law. Erica said, wait, what does happen under the water? All the things, water polo, rugby in the water with more drowning. So the game of water polo is 2 games. One that is played that the refs can see and one that is played that the refs can't see. So we will talk more about water polo another time. I do want to finish. We're on page 3 of like 35 of Bowles' motion. It is a difficult and brutal sport. So Charlene, don't give him the answers. You guys are helping. You weren't meant to help. So, no, the reason you don't drown is because when you're playing water polo, your lung capacity is good enough that you can be underwater for periods of time without drowning, but it takes a little while to work up to the fact that you can be underwater for periods of time without drowning. It's a skill. So water polo is great. Look, I played water polo. My brother played water polo. My brother tops in the 6'++ category. I do not, but he played at UCLA. I played at UMass Amherst. Why? Tell me you're 5'6" without telling me you're 5'6". And in the world of water polo, 5'6" is sad. It's just like, oh, baby, you tried. Wah, wah. Unless you're Brenda Villa. And Brenda Villa is legendary. Are you Miss CC asked if I'm an Ashley Johnson fan. No, I am an Ashley Johnson stan. Not fan. Stan. She is an absolutely incredible and formidable goalie. So we're gonna get back. We're gonna get back to water polo. No, not to water polo. Damn it. Separate from Marco Polo. No horses were hurt in the playing of the water sports. We're going to get back to Bowles' motion now that my family has successfully ordered Chipotle and all is right with the world. So we had a great little Chipotle break, and we got to talk about Flava Flav, running around with the U.S. Women's Water Polo team as their hype man. He's got the whole like USA clock. He was in the pool on social. It's just fantastic. And I think that happened because Maggie Steffens reached out like on social. Miss CC, yes, 100% yes, all of the yes. So I think it's because the team captain reached out on social. We can talk Olympics another time, or we're never going to get through everything today. But as we get into Olympics, I will be keeping you posted on water polo because it's really cool. And if you have never watched the U.S. Women's Water Polo team play, they are absolutely phenomenal. Absolutely phenomenal. So it's the only sport I know. Well, no, do they do it in basketball where they actually check your fingernails to make sure they're not weapons? Water polo checks your fingernails and toenails to make sure that they are not weapons. And if toenails do not get checked, you can see it when people get out of the pool because they have bloody scrapes all down the backs of their back, their legs, thighs, and the rest of it. So water polo. Someone tell Flava Flav about the under the water. Yeah, lots of blood in water polo. So, I mean, is it really a sport if it doesn't make you bleed? I don't know. Maybe, maybe not. So, the toenail check is brutal. Not to toenail check is brutal. Not to toenail check is brutal. Brutal. It is a... I love that sport so much. You guys are like, that's horrific. And I'm just like, I can't smile anymore. I can't smile. I can't smile anymore about how much I love this sport. Okay, let us continue. We're going to go back to law, another blood sport, but they don't check your toenails. It's just the violence all comes in writing, the audacity. It all goes into the motions. Honk banana no. EDB, we're gonna stop talking about water polo, also EDB. So all about toenails. No, the referees line up the teams and check their fingernails and toenails to make sure that they cannot injure anyone. So let us continue. Let us continue. I am Ken Ross said no blood in bowling. I bet I could probably make that happen though. I'm pretty clumsy. And the balls are heavy. Sometimes when the ball play goes badly, injuries can happen. All right, chat. I'm sorry. Emily, we're not on members only live and it's not after dark. Stop it. Lavender said, do y'all carry clippers in your bags? Tons of them. I think I probably had 7 or 8 fingernail clippers of different sizes in my team bags. Members, remind me to tell you about my water polo team bag in college. There is a story there that we will get to another day. But we will get to that next month. Let's continue about misconduct from the state in New Mexico. I should probably swoop as we get back to it. Emily, back on topic. This is the ADHD swoop. We're back on topic. Come on back. We're back on topic. Further misconduct, it says, by the state unearthed in that hearing was that CST Popple had been directed to place the Teskey rounds in a separate case file with a separate number, not Rust. She was not quite that clear about it, but yes. And create a report that was also filed in the separate case file so that those would not be disclosed to the defense. That's not what she said. That's what everybody assumed. But do you think that assumption is fair? Let me know. Corporal Hancock, they say, testified that Morrissey was present for the meetings and decision to place the rounds in a separate case file. Yes, Morrissey said no. The court believed Hancock on this. I am interpreting that based on the court's face. In other words, Special Prosecutor Morrissey was in on the decision to hide the rounds and report on them in another file. Moreover, CST Popple and Morrissey misled this jury. Well, that jury. It's not this jury. It's not your jury, Bowles. It's that jury or the jury. Misled the jury in testimony on July 11th, 2024, indicating that the Teskey rounds were visually dissimilar to the Rust set rounds. That 100% fucking happened. CST Popple said none of the rounds brought into the station, and CST Popple saw them, which is why this is the worst of all of it, because Hancock never looked. Morrissey never looked. Popple took them in and saw them. And Popple said none of them were the same. Wrong. Moreover, CST Popple and Morrissey misled the jury in testimony on July 11th, indicating that the Teskey rounds were visually dissimilar to the Rust set rounds and therefore immaterial. That was proven false a day later when this court opened a box bag. It was an evidence bag and inspected the Teskey rounds. Yeah, the court put on gloves and was like, I'm going to figure this out. We're getting to the fucking bottom. The only person curious in that courtroom seemed to be the court. Well, and the defense. Everybody else was like, oh, they sent me a picture. They weren't the same. Far from distancing from the Teskey rounds, defense counsel recognized their potential exculpatory value and had the state tested them. However, by the time Morrissey indicated that she did not plan to retrieve them on January 8th, it was too late to utilize these rounds and impossible without the FBI comparison on the powders. The court had also made clear in one of the motion hearings around that time that there would be no continuance of the February 28th trial date for Miss Morrissey. Well, you didn't ask, though. Regardless, without the state testing the rounds, counsel for the defense was unable to utilize the powder comparison. Did you tell the court any of that, though? I really want to know. Did you tell the court any of this? Teskey then turned the rounds over to the sheriff's office on March 6, 2024, and the defense hoped that the sheriff's office would finally test and analyze these rounds. Dude, I don't think there's any hoping that they're going to just do stuff. You know? The defense hoped that the sheriff's office would finally test and utilize those rounds while Ms. Gutierrez Reed pursued her appeal. Instead, the state placed them in a separate case file and attempted to hide them. But Bowles knew they existed, and Bowles knew law enforcement had them. Different than Baldwin, because Bowles was in direct communication with Teskey and knew all of this. Erlinda Johnson recognized the import of the rounds, as she stated in her interview, as soon as she saw the 3 Silver Palmer Starline brass rounds on July 12th when the court took the rounds out of the evidence bag. Johnson indicated that it made the theory of sabotage a possible defense theory. I mean, her statement to Cuomo or Court TV or whoever, because she gave several law and crime, I think she talked to Anjanette Levy as well. Those statements don't really matter. It matters what the defense thinks, not what Erlinda thinks. They're arguing what Erlinda thinks matters because Erlinda then knows it's a Brady violation because she knows it's material. It's a different standard here. We're not going to go through all of that, but Johnson indicated the theory of sabotage would be possible. I think there's other options too. The import is that Ms. Morrissey and CST Popple made misrepresentations to the court and jury regarding the Teskey rounds. Yes, in Baldwin's case, I agree. Let's see. Moving on, it says counsel for Ms. Gutierrez knew that Teskey had some rounds from the same batch, not a bad batch, from the same batch, and is not making that failure of disclosure the sole basis for this motion. Good. I think that's wise. Except to the extent that they show ongoing misconduct of the state and failures found by the court. I think that's wise. I think that is a solid approach to this motion. Let's see what else is here. These additional acts by special prosecutor should inform, however, the egregious Brady violation regarding the Hag report. That's where I thought we were going to go with this. And the Giglio violation regarding the Seth Kenney interview that was disclosed only after trial. What now? What now? There's another Seth Kenney interview that was disclosed after trial. I think this is a smart approach from Bowles. Your Honor, I'm saying that there's a pattern here. We knew about the rounds. The rounds aren't what we're arguing. We're just showing you that where there's fuckery, there might be more fuckery. More fuckery. Tell me more about a non-disclosed Seth Kenney interview, please. The court stated July 12th that the integrity of the justice system demanded that the court dismiss Baldwin's case with prejudice. How can it be any different with Ms. Gutierrez Reed's case with this proven litany of serious discovery abuses? It's a good argument. The intentional withholding of crucial evidence, the Brady and Giglio violations by the state has compromised the integrity of the entire judicial process. Justice demands that Hannah Gutierrez's conviction be overturned immediately, ensuring that the legal system does not perpetuate this core affront to our system that has been watched all over the world. I mean, that part's irrelevant. Introduction and factual background. We know what happened on July 12th. We know the court dismissed. We know the standard the court found. Let's see. I love that he cites back to YouTube. See YouTube. Where's the link to the channel? Sir, if you're citing to YouTube, you have to include the link to the video. See YouTube. Quote, see moment judge throws out case against Alec Baldwin, July 12th. That is not a proper cite to you. Emily, don't get distracted in the details. They go on to say This is, of course, the same prosecutor in the same sheriff's office that handled the Gutierrez Reed case. In the same way as in Mr. Baldwin's case, the state represented to counsel in this court that it had complied with its obligations under Rule 501. Please see state's certificate of compliance filed February 12th. The state said, we've turned over everything. Yet after the trial concluded, the state continued a pattern of discovery misconduct, disclosing a completely new interview of Seth Kenney and a third expert report of the state's expert Lucian Hagg. Please see Exhibit A to Hannah Gutierrez Reed's motion. That should be attached here. On April 8th, a full month after Hannah Gutierrez Reed's trial ended, Morrissey called counsel for Reed, OT. Morrissey called counsel for Reed and disclosed an entirely new Seth Kenney interview and statement that contained numerous points that could have been used in Kenney's cross-examination. Why wasn't this brought up sooner? Also, the state withheld bombshell exculpatory evidence that the state withheld bombshelled and exculpatory evidence that it had a constitutional obligation to disclose and that would have resulted in a fundamentally different trial and likely a different outcome. That is the standard. So this is Bowles acknowledging the standard for post-trial violations or violations discovered after trial would have resulted in a different outcome. As the court is aware from ongoing proceedings in the Gutierrez Reed case and Baldwin's case, despite having in its possession a report from its own experts stating that the firearm used on the set of the Rust film contained unexplained tool marks of critical surfaces of the trigger and sear, which one, likely were not the result of damage incurred during the FBI's impact testing, and two, did not appear to be the original manufacturing marks or use and abuse tool marks based on their irregular orientation. The state buried this information and never disclosed it to Miss Reed. Let me say that again. There is a report from the state's expert saying that the tool marks on the weapon were not the result of the damage incurred during the FBI's impact testing, which is what the testimony was. The testimony from this expert was that there was no signs that the weapon or the cock notches were modified in any way. And they are saying there is a report that damage did not occur during the FBI testing. That is a big deal. And did not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation. That's a big deal. That's a very big deal. Would that change the outcome here? Maybe not. Because let's just talk about this real quick. Would it change the outcome? I think it's something they would have cross-examined on, 100%. But would it change the outcome here for Hannah Gutierrez? Let's talk about why I don't think it would on first look. I might change my mind as we get further into the motion, but we're talking about it as we go. One, if the weapon was modified and Hannah Gutierrez didn't catch it, it further goes to Hannah not doing her job with due caution or circumscription. If the weapon's modified and Hannah doesn't know, she has further failed at her job. So do I think that information helps Hannah? No. Do I think it's a problem? Yes. Because the sabotage theory of it all for Baldwin is, I shouldn't have known this was dangerous. But for Hannah, she still has to catch it. You're not supposed to be able to pull anything past her because she testified, no, she told law enforcement that she was inspecting these weapons and taking care of them. It was still her job to catch it. So this failure to disclose is probably a Brady violation. But For the Brady violation to result in a sanction against law enforcement or the prosecution here, it has to have likely resulted in a different outcome. Does this information likely result in a different outcome? Maybe not, because it's her job to know this. This is not Baldwin's job to know. This is Hannah's job to know. And were the weapon modified, I think it's worse for her. Do you think it's worse for her? Because then she didn't catch that either. And it was her job to do so. Should this have been disclosed? Yes. Does this change the outcome? Possibly not. Does it look bad? Yes, it does. How can the defense know that, though? The defense can't choose to cross-examine or not cross-examine if they don't know. And that's a problem. It might not have changed the outcome, though, so it might not happen with the same result. Had this been discovered during trial, we might see the same result as Baldwin, but it didn't. But I think it would have changed their cross-examination. But the defense has the right to make that strategic decision. The defense has the right to see all the information and choose what to ask and what not to ask. And they can't do that if they're not given all the information, and that's the problem. Let's continue. So they're saying the state buried this information and never disclosed it to Gutierrez Reed. But not only that, the state then called the expert at trial and sat idly by as he perjured himself during cross-examination. Let's hear more about that. In doing so, the state suppressed exculpatory material. I think it's relevant material in violation of the U.S. and New Mexico constitutions. I mean, it's potentially suppressed a testifying witness written statements. That is an issue in violation of Rule 501A5 and committed additional violations of the constitutions during trial. This conduct is beneath what the court should expect from a duly appointed officer of the state tasked with doing justice. I don't disagree with that at all. These late disclosures occurring after trial had concluded to violate Rule 501H, and there is a reasonable probability that the outcome of the trial may have been different had the state complied with its obligations. I don't necessarily agree with that. They have to argue it. I don't know if that's true. Let's talk about the suppressed Seth Kenney interview, folks. In the Seth Kenney recorded interview conducted well prior to the trial of Gutierrez Reed, there is no date contained in the interview, but it occurred before her trial. How do you know that? And what do you mean there's no date? You guys know how I feel about Seth Kenney. Kenney makes the following material statements that counsel for Ms. Gutierrez Reed would have used in cross-examination. This might be more relevant. There is a standard that the prop master, Sarah Zachary, is the boss, and if something goes missing or stolen, she must report it. She is managing things, which allows the armorer to focus on guns and Sarah on everything else. Does that statement help? Probably not. Hannah grew up on the set of movies and has a lot of immersion in set industry. She has more experience in Westerns than Seth did up until 1883. Interesting. He said that prop masters who handle guns won't call out armorer to test bullets. Weird. Mentioned, and that would contradict what Hannah's job was. That might be very relevant here, because that would contradict what Hannah said and what the expert said. The expert said that it's the armorer's job only. If Seth is contradicting that, he should be cross-examined on it. Mentions that the sheriff's confused replica gun with a real gun. That would be good to know. Sarah told him, but I mean, there were non-working guns on set, so maybe some of the replica guns are also real guns. For those of you saying Hannah wasn't alive in 1883, 1883 is a movie. It's from the Yellowstone, or part of the Yellowstone franchise. Seth said nothing but good things about Hannah's skills. That would be good to know. All the stuff that came out about safety he hadn't heard. He felt like people were piling on after the fact. That would be good to know on cross. These are all matters for cross-examination. The question is, does it change anything? He mentions the anonymous hotline and if there was something going on, why nobody called the hotline. He said Alexa Hancock had been cool, but I busted her chops on the search warrant. Yeah, we heard about that, didn't we? He was just like, oh, come on, man. Why are you searching for this and that? It was something. Says he got 325 rounds from Thel Reed. Says sabotage could be anyone on set. Quote, it's a boys club. Alec Baldwin trusts AD because he's a man. That would have been something to cross-examine about. If she said she got pushed around, no one would disagree. She's got the experience. If she ever came up with that kind of defense, then I'd think you're going to be real about this thing. Awkward sentence. If the camera crew didn't feel safe, call the hotline. It's kind of suspicious to me. If they got their hotels, would they have stayed? Would they have said they didn't feel safe? He talks about Sarah's accidental discharge. That is of the weapon in the days leading up to this shooting, with Sarah handling the guns as the prop person, not an armorer. Sarah was super responsible and apologized to everyone. Hannah was trying to punch down on Sarah for accidental discharge. Accident discharge happened. Mentions Tim McGraw, Daniel Craig, and Denzel having them every single time. This man is gonna name drop. He told Hannah to let it go about Sarah's accidental discharge. As to Hannah, says AD and Baldwin, quote, how are you not making sure a 24-year-old armor has every ounce of support? She's got the experience in history. She has more set time on Westerns than I did before 1883. Sarah was collateral damage. He told her he would find her an adult armorer. Weird statement. Hannah came out strong. She was pushed around by Baldwin and AD. Prop department needs every ounce of support. Says sabotage is bullshit. Again, does any of that change the outcome? The court's going to have to weigh it, but that's it. Slightly me, when I said name dropping, I'm not talking about Bowles. I want to make it very clear. I'm always talking about Seth Kenney. Seth Kenney name drops when he opens his mouth. Every time we've seen anything from Seth Kenney, there is name dropping every single time. Emily, are you hypersensitive to this because you grew up in Los Angeles? Possibly. It might annoy me more than your average human, but I'm definitely talking about Seth Kenney. Several of the statements are new and different and would have been critical to cross-examine Mr. Kenney on. I think this is, of the arguments we've seen so far, one of the strongest ones, because how the jury feels about Seth Kenney could have changed how they felt about Hannah's ability to do her job and potentially intervening cause. I think of the arguments we've seen so far, this one is their strongest one so far. Let's keep going. These statements are different and would have been critical to the cross-examination of Mr. Kenney, including to show Gutierrez Reed's experience. The allegations of her being unsafe were not something Kenney ever heard. And a lot of the witnesses really said, we knew she was unsafe on set. Kenney was supposed to be the armor supervisor. Kenney saying something different might have impacted how the jury saw things. Most critically, he said he received 325 rounds from Thel Reed, which is important because the ammo can be found in his shop. Because the ammo could be found in his shop, PDQ was found empty during the search warrant. Oh, the ammo can. Comments are helpful. The ammo can found in his shop. Okay. Kenney also represented in the Friday, July 12th hearing that he brought back 5 to 100 rounds with him to New Mexico and no explanation as to where they went. Agreed. The state also made repeated points at trial about guns being left unattended. Yet in this previously undisclosed interview, Kenney said that the sheriff confused real and prop guns. Kenney also made conflicting statements on sabotage. This is favorable giglio or impeachment information that the state suppressed, and that was material. I do think it's material. So That, I think, so far is their strongest. Let's continue. Suppression of the Hague report. The accident involving the firearm that led to the indictment of Gutierrez Reed occurred October 21st, 2021. The state first charged Gutierrez with involuntary manslaughter January 31st, 2023. Trial commenced February 28th, 2024. We were there. Gutierrez's principal defense theory was that no one had committed a crime and that this was a tragic accident, and if there was any negligence, it was on the part of producers as found by OSHA. This defense would have been immediately bolstered by a legally unforeseeable intervening cause, such as a firearm malfunction. I don't know if that would have changed the juror's mind, but I see where the argument is, and I understand the argument to be made. It is an argument. Sometimes we look at these motions and are like, good luck with that. This is an argument. His only argument in closing on intervening cause was the actions of medical personnel. Having a report that said the firearm might not work properly, could that be an intervening cause? It's hard when she's the one responsible for the working order of the firearm, though. That's the counter argument. But it is an argument, which, when this goes to hearing, will be interesting to see how it gets argued. I'm interested to see how Kari Morrissey responds, or if Kari Morrissey responds, because it seems Kari Morrissey's still on this case. But now Kari Morrissey's a witness in this case. Like, it's such a fucking mess, because half of these things are Morrissey said this. Morrissey's now a witness. Another attorney should handle this, but who? Erlinda Johnson walked. Who handles this if Morrissey doesn't? Mess of mess of mess. Continuing on with the motion, it says this is perhaps the most important unforeseeable intervening cause. Indeed, post-trial, one of the jurors called What now? One of the jurors called undersigned counsel and said the jury was split and that they ultimately thought the tragedy was foreseeable and there was no intervening cause that broke the chain of causation. In short, the report is critical new evidence. Interesting. I mean, that jury came back real quick. They weren't split for very long, though. It's not, they deliberated for a handful of hours at best. I didn't even have time to pick up my kid by the time that jury came back. On March 6th, the jury returned a verdict finding Gutierrez Reed guilty of involuntary manslaughter. The court entered judgment on the 18th. She was sentenced to 18 months. But what neither court nor jury nor Gutierrez Reed knew was that months before Gutierrez Reed's trial, the state's two firearm experts issued not just the one report that the state disclosed, but two subsequent reports. Two? Specifically, the results of the initial examination of the firearm performed July 3rd, 23 were published in a report dated August 2nd, 23. The result of the second examination performed on August 24th were published in two separate reports, August 26, 23, August 31st, 23. The third report found the firearm contained unexplained tool marks on the working surface and sides of the evidence trigger and sear that one, it was unlikely that those tool marks were a result of the damage incurred during the FBI's testing. And two, the tool marks did not appear to be the original manufacturing marks. Put another way, the state's experts concluded that there were unexplained alterations to the firearm trigger and sear, I think is what he means. A critical conclusion given that Gutierrez Reed's co-defendant Baldwin had claimed that he never pulled the trigger and that the gun prior to its firing the bullet never pulled the trigger on the gun prior to firing its bullet that killed Helena Hutchins. It's an argument. I think the Kenney one's stronger, personally. But is that a Brady violation? Yes. Would it have changed the result here is what the court's going to have to work through. The state did not produce the third report prior to the commencement of the trial. Instead, the state produced them only to Baldwin and only weeks after the jury had convicted and the court had sentenced Gutierrez Reed. It's going to get confusing if I just say Reed because of the other Reed trial. It was only on May 31st, 2024, by which time Gutierrez Reed was already at the Western New Mexico Women's Prison for intake and classification. The special prosecutor admitted to Baldwin's counsel that the state, quote, failed to disclose the 831 supplemental report. When she testified, she agreed that that was a Brady violation. The timeline of the state's discovery disclosure in Baldwin's case is important to understand the purpose of this motion. for the purpose of the motion. On January 24th, 24, Baldwin made his initial discovery demand between April 22nd and 29th. Baldwin repeatedly raised concerns that the prosecution about missing expert materials and other missing discovery. They did. On April 29th, Baldwin apparently learned of the second expert Hague report when the witness referred to it during his pretrial interview. Woof. Well, now we know how they discovered it. And it was more than a month later, on May 21st, that Baldwin's defense learned of the existence of a third report during pretrial interview. Yikes. Fuckery. Meanwhile, the state was actively prosecuting Gutierrez Reed. Yeah, her trial hadn't started yet. No. That was after she was sentenced. So these things were April 22nd and April 29th. She was sentenced April 18th. This is like immediately after she's sentenced. Meanwhile, the state was actively prosecuting Gutierrez Reed. Her trial began on February 28th, and the jury delivered a verdict on March 6th. Right, but these things are happening in April and May after March 6th. The reports were written before. They were discovered by Baldwin after. Yikes. And during Ms. Gutierrez Reed's trial, her attorney examined Lucian about the precise exculpatory issues raised in the third report. Bowles. Okay, sir, and in your inspection of that weapon, the Baldwin revolver, did you see any modification that would have changed the firing characteristics of that weapon? Hey, no, not at all. Well, you asked if it changed the firing characteristics. Maybe that doesn't change the firing characteristics. Nothing that you cited in the report says it changed the firing characteristics. So, Sherlock Mom asked Emily, important question to your review. Have you seen that defense level of burden does not require it to show that it would change the verdict unlike other states? Sherlock Mom, that is true as to Baldwin's case. That is not true post-conviction. So post-conviction, they have to prove, and he said it in this motion, post-conviction, it's different. During trial, it's not. And during Baldwin's ruling, the court actually addressed it. The court said, at this stage of the proceedings, unlike after trial, we only have to find its material. After trial, you have to find that the result would be different. So it's two different stages. So Sherlock Mom, you are right. It is different. It is friendlier the more when you find it earlier. Big question for the legislator in the state of New Mexico. Does that encourage these things to be discovered after, or at least covered until after trial? Should the standard be the same? Those are questions for the legislature. But it's a different standard and much friendlier to the defendant standard during trial than it is post-trial. So there's that. Bowles said, okay, sir, so other than the FBI testing, and Sherlock Mom said, thank you for the clarification. Thank you for the question. If you've got the question, other people have the question. I'm always happy to answer. So when I know the answer, when I don't, I'll just tell you that I don't know. Mr. Bowles said, okay, sir, so other than the FBI testing breaking those components, you didn't see any other evidence of modification or damage? That's the question. That's the impeachment. I did not. And then you impeach with the report, right? It goes on to say, at the same time that Lucian gave his sworn testimony, the state possessed a report stating the exact opposite, specifically that the firearm contained unexplained tool marks. What is the answer there? That the tool marks aren't evidence of modification or damage? He could have been impeached or at least questioned about this. Although Lucian Hague's trial testimony directly contradicted his conclusions in the third report, the state continued to withhold the report and its contents. With the third report, Gutierrez Reed would have had a sufficient evidentiary basis from which to argue that unexplained alterations on the firearm caused it to fire without anyone pulling the trigger. Would that have changed things? We'll see. This was a critical factor in the jury's decision under the instructions as given. True. Suppression of additional material. This week, the defense became aware of another possible 9... What? That's not enough. $900 or so pages of material related to the state's witness, Brian Carpenter, that was not and Haig, that was not disclosed to undersigned counsel. 900 pages? Stop it. This week, Gutierrez Reed became aware of another 900 pages of material related to the state's witnesses, Carpenter and Haig, that was not disclosed to undersigned counsel. This material was disclosed to counsel for Baldwin shortly before his trial. Oh, the rage.
The level of fuckery. The pattern of behavior is just absolutely wild.
I'm going to take a minute to remind you the ongoing discovery obligation. Shakira said, what was that about morals again? This is the kind of reason that Erlinda Johnson left the case. This stuff. When Erlinda found out about one of those things, she walked. Well, no, she didn't just walk. She confronted Morrissey. And when Morrissey would not acquiesce, she walked. Based on her ethical duty. She did everything she could to do the right thing. And Erlinda was not part of this case. So what was that about morals? I impugn none of this to Erlinda Johnson. This all goes directly to Morrissey. All of this. Erlinda was like, peace. And we see a paralegal that quit as well. So people seemingly brought this, and I say seemingly brought this to Morrissey's attention. And Morrissey was like, full fucking Cartman. I do what I want. That's not how the law works. There is a ongoing discovery obligation. Even if you find something out after trial, you have to tell the defense. And then whatever happens, happens. You don't go, well, conviction's done. Oh, well. That's not how that works. That's not how that works. So when these things, and this is part of the issue, when these things were turned over to Baldwin, they should have been turned over to Bowles at the same time so that Bowles could make the motions he needed to make. The things that were discovered to Baldwin like a month after the conviction or the month after the sentencing or weeks after the sentencing should have been turned over to Bowles then. Ongoing obligation. Oh my God. Bowles must be both like outraged and like giddy, right? Because he's got to be like, this is amazing for my case, but also like, fuck all of this. It's that like that complex emotion. Like this is such fuckery, but also this might be good for the case, but also his client's been sitting in prison since March. Rage. This week, the Gutierrez defense became aware of 900 pages of material. Well, at least they have it now. Counsel are still reviewing these at the time of filing the motion and may supplement with exhibits in the reply. That's fair. It is too important for Ms. Gutierrez Reed to have her motion filed immediately, given the July 12th hearing and findings. As just one example, attached as Exhibit E are numerous emails, approximately 36 pages, involving Brian Carpenter and the state's prosecutors. In one dated July 18th, between the state's prosecutors and Brian Carpenter relating to the drafting of Baldwin's probable cause statement. In that email, Carpenter says in part, "Team, first off, excellent job, Robert. Very compelling document, well written. I have redlined anything I found notable." In another, towards the end, he appears to email additional thoughts regarding Gutierrez Reed's probable cause statement. As this court may recall, Brian Carpenter was the state's expert witness in the Gutierrez Reed trial as well. This email is one that counsel has located in cursory search demonstrating the expert's bias towards the prosecution, a fact that he is involved in helping draft the probable cause statement supporting the charges he should have been able to be cross-examined on. In yet another, he states that Sarah Zachary knew nothing or next to nothing about firearms. He goes on to state that her hiring was for low budget reasons, and the only thing to mitigate that was to hire an experienced armorer, but that didn't happen, again, more than likely for low budget reasons, again, blaming production, which was part of the defense's case here. In another email dated November 17th, Carpenter writes to prosecutors that he has talked to one of the top 3 prop house owners in the U.S. and a very well-known prop master, and both of them, without hesitation, felt a major amount of responsibility fell on the prop master. Who agrees? Who agrees that a major amount of responsibility falls on the prop master? He goes on to believe that Hannah is very accurate in saying in her statement that production were jumping her ass for not working hard on props and that they wanted more done in the props area to save money. He states that Gabrielle Pickle was the one from production who stonewalled all the training and armor day requests. He references people believing Gabrielle Pickle and members of production being responsible. He notes further blame on production in bringing the prop master and armorer in late, not giving them a props truck, and having locations working out of the same truck as being completely wrong and the fault of production. Part of the defense's argument here. These were all themes that Ms. Gutierrez Reed espoused at trial. Yes, very much agree. And she never had access to these statements to cross the government's expert on. That is a problem. That is a very large problem for the prosecution. In another email on February 6, 2023, Carpenter states that he is reviewing something that appears to reflect a total of 86 live rounds, which is a, quote, big thing as they were scattered throughout and found at PDQ. What now? 86 live rounds found at PDQ? What? This is Seth Kenney's business, we know, and the number of live rounds found at his business was a source of major contention at trial. Yeah, it was. Again, all of these statements required to be disclosed under 5501. The repeated discovery failures are certainly beneath what Gutierrez Reed deserved. I agree. Again, the job of the prosecution is to put forth legally obtained evidence against a person and let the jury decide. It's not to win. It's not to protect other people. It's to let a jury decide what happened. That is the only way the system works. You cannot have outcome determinative prosecutors. If you do not like the result of the evidence, you don't bring the case. You don't hide it. That's not what you do. Legally obtained evidence, and you show the jury, and you say, this evidence shows you that this crime was committed. And if the jury goes, no, then that is the result. And if the jury goes, yes, then that is the result. And because I am angry, I'm going to disassociate for a moment and say anything less than the best is a felony. Because we're just going to have to quote Vanilla Ice to... I'm so mad. I'm so mad. I'm so mad. Again, these are all statements required to be disclosed under 5501. The repeated discovery failures are certainly beneath that that Miss Gutierrez deserved. And for her, the impact has been devastating. Yes, she now sits in prison serving an 18-month sentence based on what we now know was a proceeding that was rendered unfair and unconstitutional by the state's conduct. The court should not countenance the state's deplorable behavior. I don't disagree. We can go through the law and argument briefly. We are 15 pages in. A lot of that's emails. We're not going to get to all of those because we need to get onto the Scandoval of it all. But I'm going to go through their elucidation of the standard. I think I've been arguing that throughout their factual arguments. Anthony said that was not lawful law. Agreed. Jacqueline said, Emily, we're beyond code red. I was so fucking engrossed. I didn't see. Did chat request code red? Did I miss it? I might have missed it. At the 900 pages. I bet you guys did. My apologies, chat. You're right. And motion granted. I think we must go to code red. All right. Let us do that. Chat, for those of you that are new, hi. If anyone's new finding us on a non-trial day, I mean, I'm fascinated that happened. Also, welcome. We're glad you're here. We've got live court again on Monday, so don't worry about it. Let us go to code red. So for those of you new, code red is a bit flashy. I love it. But if your eyes, because all of our brains are different and often spicy, do not love the flashing, it ends when the music ends. It is 8 seconds long. So here is your warning. We are going to code red. Wait. We are going to code red. In 3, 2, 1. We are now at red. All right. DEF CON, what the fuck? So, for those of you asking, what court are we going to Monday? Karen Reed on Monday. Karen Reed on Monday. So that's what we're doing then. Let us get back to this motion. We're going to go with the brief legal argument. Thank you. I thought the microphone was needed. I might go with less reverb on it, but I thought it was needed. Because seriously, what the fuck? We might shift that one around a little bit, but do I love the voice changer? We gonna do it all the time? Is it starting to feel like a morning radio show over here? It is, and I love it. The longest morning radio show ever with no music breaks. God, if we could get music breaks, can you imagine? But I digress. 30 seconds. 30 seconds. You guys? Okay, shh. It's just for us. Don't tell anyone. It looks like we might be able to work out some Law Nerd playlists in the near future. And I'm so excited about it. I cannot wait to bring us Law Nerd playlists that we can all contribute to. I'm ready. So Law Nerd playlists are in the works. So we have the musical expression of the live streams in a playlist for all of us together. And I can't wait. Let's continue. The defense motion says the state violates a defendant's due process rights when it suppresses evidence favorable to an accused upon request. Where did that go? Sorry, things moved. Where the evidence is material either to guilt or to punishment, irrespective of good faith or bad faith of the prosecution. That's from Brady. See also Giglio. Evidence that the rule, clarifying that the rule stated in Brady applies to impeachment evidence. So the Giglio case expanded Brady a little bit to say that impeaching a witness counts, which is why sometimes it's called Brady Giglio material. Sometimes it's called Brady material. Sometimes people parse that down to Giglio material, but it's saying it's not just exculpatory evidence. It is also evidence that can be used to impeach witnesses. So it kind of expanded, they say clarified, but kind of expanded that ruling to make it clear that it included both. Evidence qualifies as material when there is any reasonable likelihood that it could have affected the judgment of the jury. I agree that this was Brady evidence. What happens next is going to depend on, does that evidence change the result? To prevail on her Brady claim, the defendant need not show she was more likely than not would have been acquitted had the new evidence been admitted. She must show only that the new evidence is sufficient to undermine the confidence in the verdict. We'll see how the state reiterates that, because it's worded different than what the judge said on the stand, or the judge said from the bench on Friday. However, we're going to go through the state of New Mexico's, right? The state of New Mexico imposes heightened obligations under 501. And by heightened, they mean the prosecution has to go above what the case law says. Like, the case law is like the foundation, and states can ask for more, and they can build more and say, this is the base level, this is your minimum responsibility, but actually in this state you need to do this. The state of New Mexico, however, imposes heightened obligations under Rule 501, noting that 501 creates disclosure obligations beyond those required by the Due Process Clause. In particular, the state must disclose any statement made by any witness whom the prosecutor intends to call. And remember, the prosecutor also clarified that they had done that. So, when a defendant has been found guilty, this is the part I was looking forward to getting to. When a defendant has been found guilty, the court, on motion of the defendant or on its own motion, may grant a new trial if required in the interest of justice. Chat, could the court find that here? Could the court find that, based on everything that's happened, that this is an interest of justice consideration? That this has to be the result? You let me know what you think. Could we get there? So, for those asking Code Red, we're already Code Red. We can't get any redder. Unfortunately, it's daytime. If I got automatic blinds in the office, if I got automatic blinds in the studio, I could actually close the blinds and go code Death Star. Interesting thought. Interesting thought. So with that, let's continue on. Thank you, Miguelina. I got my app notification that we went to Code Red, reminding people that ultimate fuckery is afoot on stream. We should probably send one when we change topics, when we finally get to Scandoval. Thank you for sending that. And thank you, everybody, for mentioning it. Okay. So, when a defendant has been found guilty, the court, on motion of the defendant or on its own motion, may grant a new trial if it is required in the interest of justice. A motion for a new trial based on newly discovered evidence is appropriate where the evidence, 1, will probably change the result if a new trial is granted, and 2, was discovered after the trial. 3, could not have been discovered before the trial by the exercise of diligence, and is material, is not cumulative, is not merely impeaching or contradictory. That prong might be a fight. I think there's a fight to be had, but that prong might be a fight. It's not merely impeaching or contradictory. That's what the state's going to argue. So I like the way Bowles set out the law here a lot. Very clear. This is the law we're working with. And then we'll go down and argue why Gutierrez is entitled to a new trial. I want to see what he says about dismissal. Let's see. There can be no legitimate dispute that the state of New Mexico violated Gutierrez Reed's due process rights under Brady, given that it is now stipulated that it failed to disclose evidence that is both favorable to Reed and material to her guilt. As to the first factor, the third report is favorable to Reed. It corroborates a defense theory that exculpates Gutierrez and would have changed the jurors' weighing of the evidence in essential ways. I think there's room to argue that. I don't think it's black and white on that. I think there's a lot of room to argue, but with this pattern of conduct, I think the court is going to be more inclined to look at these arguments favorable to the defense, because this isn't coming out of thin air, and this isn't one thing. Whenever conduct of the state alleged against Miss Reed, that conduct was not legally responsible for Miss Hutchins' tragic death, because no one could have foreseen that unexplained alterations to the trigger, I thought it was sear, he's saying seal, would leak would lead to a freak malfunction causing the gun to fire. The reason I say there's room to argue there is because even if the gun, if no one could have foreseen the gun firing, isn't that her job though? She's charged with not doing her job as the armorer with due caution and circumscription, and doesn't not knowing if the gun's in proper working order make it worse for her. Because not knowing the gun's in proper working order is her job. And she told law enforcement in her interviews repeatedly how much she checked the weapons to make sure they were safe, to make sure they didn't have debris in them, to make sure they didn't have dirt in them, and to make sure they were in good working order. I don't know if this changes things, but that doesn't undermine how bad this is. Would it change the jury's mind? I don't know. This part, which is why I said the Seth Kenney stuff might have been the stronger argument, because I think the Seth Kenney stuff is the stronger argument here, my opinion. But I also can see how this part's going to be argued. It says, Gutierrez Reed was not able to pursue that theory because the state buried the evidence in its possession that was necessary for her to make that case to the jury, nor did she fail to ask the right question. That's true. He did ask that question specifically as to that Hague report. She asked specifically and repeatedly that the state produce all evidence, and asked about it in trial. And then at trial, keep reading. Even without knowing that Lucian Hague had opined in the writing in the third report that there were modifications or damage to the firearm other than what resulted from the FBI, Gutierrez Reed, through attorney, asked that specific question, and he reiterates what he stated before. The fact that Gutierrez Reed asked the question and Hague, they say, perjured himself in response should not dispel any suggestion that the truth memorialized in the third report would have been exculpatory to Miss Reed. I think this is the most thorough motion so far we've seen from Bowles, and I can understand why. The facts of this case far surpass that low threshold. They're saying the state's entire theory of guilt was that Miss Gutierrez's negligence in mishandling the gun caused the death of Helena. Disagree. I understand why they're framing it that way, but I disagree with that framing. It was not just the handling of the gun, it was the loading of the gun and the failing to check the ammo was their theory, but they're going to frame it in the light most favorable. That's what legal writing is about in advocacy. Had the state disclosed the third report, Gutierrez could have used it to sow reasonable doubt as to the causation and foreseeability. Gutierrez never got that chance, and that is a problem. Absolutely. They're saying the fact that the witness perjured himself on this very subject when he testified at the trial, and that the state continued to disassemble about the third report for months. I don't even know what that word means in this sentence, but continued to fail to disclose the third report for months when Baldwin continued to press only underscores how important the state views the evidence. I don't know if the state viewed it as important or if the state was just completely negligent. It doesn't matter. Whatever the state's intentions, there is no dispute that it failed to disclose the report. Agreed. She testified that she didn't, and Kari Morrissey testified she knew it was Brady and didn't disclose it. While the violation of Reed's rights under the Constitution is sufficient to vacate her conviction and order a new trial, her rights under the New Mexico Constitution are more expansive. Under New Mexico law, Reed is entitled to a new trial because the state violated its duty. The evidence was material, and thereby it prejudiced Miss Reed. So we're not going to go through his balancing of those three factors. The court is going to do that. We're going to hear argument. I might go back through this when we get to the state's reply. Let's see. The court should grant Ms. Gutierrez release pending appeal. In the alternative to an outright dismissal or at least a new trial, the court should grant Gutierrez's already filed motion for immediate release pending appeal. A defendant convicted of a nonviolent offense is entitled to release on bail pending appeal if the court finds, by clear and convincing evidence, that the person is not likely to flee or pose danger to the safety of others, to another person or the community if released, that the appeal is not for the purpose of delay. I agree that it's not for the purpose of delay, and raises a substantial question of law. There are substantial questions here. Whether or not she will get released, though, the court deemed this a serious and violent offense. So even though it is not by nature, the court did deem it at sentencing a serious and violent offense. Okay. To the conclusion, for the foregoing reasons, Reed respectfully requests this court to order a new trial or dismissal of the case for egregious prosecutorial misconduct. The court should also order Ms. Gutierrez's release. Finally, the court should order under its inherent power that Ms. Morrissey be removed as special prosecutor for the misconduct that has been found and the violations committed. I don't know if the court's going to do that. Right now, Kari Morrissey is still the special prosecutor on this case. The defense actually asked for or made a motion to exceed page limits here. And Ms. Morrissey had no response to them, like no objection to them exceeding page limits, but Morrissey is still the attorney here. So there are some arguments here that the court is going to have to weigh through on those findings of fact. I think the pattern of behavior is going to be hard for the state. I don't think she's going to get released pending this, but I don't know. The court is not happy with Kari Morrissey. So when the court has seen this pattern of behavior, the court is in a position to, make that right. And when the appeal process and this process can take a minute, the court is in the position to release her. If the court is going to hear this quickly, the court might not release her on hearing it quickly. So we'll see. But when this is set for hearing, we will absolutely be covering the hearing. Kari Morrissey is going to have to respond. When she does, we'll go through the balancing of those prongs with the two arguments. The defense has a lot of points here. The 900 pages of additional information is a huge issue. The third report is a huge issue. So there is room to argue this, and there is room for the court to decide what's going to happen. A lot of these motions, you're like, I mean, I applaud the effort. Good luck with that. This is not one of those motions. This is a motion that gives room for the court to potentially find this here. And the court's already mad. And Kari Morrissey's a witness to this motion, so I don't know how she can be the attorney on the motion. This is not done. This is going to need to be evaluated by the court fairly thoroughly. Again, a lot of these motions have no meat on the bones. They are a kind of pro forma motion. That's not here. There are some real issues here. It's going to boil down to whether or not this would have changed things. The report from Haig is less persuasive to me because it shows that Hannah further failed at her job. If the gun's not operating properly, that's on Hannah more. But as to the Seth Kenney stuff, I am more persuaded. Because as to the Seth Kenney stuff, we've got more issues to have a conversation about. And all of this not being brought up impeaches those witnesses. So I'm very interested to see what happens here. I don't think this is going to be a quick decision for the court. And I think the court's going to be pissed. I think the court is going to be absolutely pissed. Absolutely pissed. G Mommy in the chat said, if she's now a witness, how is that not a conflict? It's an issue. I don't know what it's an issue. And she made it an issue herself by taking the stand. I don't know how she can be the attorney on this and be a witness, but for these motions, we will see. Down the road, we will see. I don't like it. There's more there, and I don't know what it is, and I hate it. I'm not going to speculate. There's more here, and I hate it. We will see. So I'm going to go through, there's over 10 pages of emails. I'm going to go through them, not today. I'm going to go through them as we go through the response to this, because I'm very interested. Lena asked, didn't Sarah get immunity? Yes, Sarah did. But you know who didn't? Seth Kenney. Seth Kenney didn't get immunity. Seth Kenney didn't get charged. Excuse me. Give me 30 seconds. My throat has decided it's angry. So. Don't worry, chat. We will go through the emails later. We've got to get to the Tom and Ariana stuff. And I do have meetings today, so I can't stream for 4 hours like I did last night. We're not going to get to them. We're going to wait until we get to the prosecution's response. So we've got a plan. All right. So let's see. Let's see where we're at. Going through the Bowles motion for new trial or to dismiss, we learned a lot of new information. Not only are there 2 reports from one of the state's weapons experts, Mr. Haig, that weren't turned over, there is also an entire interview from Seth Kenney, the owner of PDQ Arm and Prop, that wasn't turned over. There's also 900 pages of information relating to state's witnesses that weren't turned over to the defense. Does that information leave room for the defense to further impeach witnesses? Yes. Does that information violate Brady? It seems to. Does that mean that the court must grant a new trial or dismissal? We will see. Some of the elements the court is going to have to balance is, would the jury or could the jury have come to a different outcome on this? Some of this information I actually think is bad for Hannah, especially when it comes to the weapon report. If there were modifications to the weapon as the armor, it's her job to find that. So would it further go to her not doing her job? Would it further go to her, acting without due caution or circumscription? It could. But as to the Seth Kenney stuff, can it further go to the defense position that what was going on at PDQ Arm and Prop and with Sarah Zachary kind of intervenes or does intervene in the job that Hannah Gutierrez was doing and making it impossible for her to do her job? What's hard for Hannah Gutierrez in all of this is that Hannah said to police repeatedly, and even in interview with her attorney, that she should have checked the ammo more, that it was her job to make sure the gun was in working order, that it was her job to make sure that there weren't live rounds in the gun. And if that is the ultimate decision, then we'll see how the court weighs this. Could the court, in the interest of justice, say that this behavior means that fundamentally Hannah Gutierrez did not get a fair trial? He didn't really raise those arguments on whether or not she had a fair trial in exactly that language, but is there room for the court to make some other decisions here? Absolutely there are. Absolutely there are. So we will see how the court weighs this. This is not an easy motion. Jody, Seth Kenney does not have immunity. He did not get immunity. He did not get charged. So we will see. Prosecutor Kari Morrissey is still on this case. Prosecutor Kari Morrissey also is kind of a witness to these motions because the things she said on the stand are brought up in these motions. The defense also asked that she be removed from the case. But for now, in the motions for the defense asking for extended page length, Kari Morrissey is the one they were talking with, and she had no objection to that, which is why it was a longer motion. But Kari Morrissey is still very much a part of this case. And that's going to be really weird. So, 900 more pages. 900 more pages of discovery. And it seems that even when discovered, some of this was turned over to Baldwin's team at in April, right after the sentencing of Hannah. And it seems that that wasn't turned over then either. Like, when did this get turned over? I've got so many questions. This is not good at all. And we will see what the court decides to do with it. What an absolute ongoing clusterfuck of fuckery. Completely unacceptable. Absolutely unacceptable. And I a week ago, I would have been like, I am stunned. Am I stunned at the moment? Not after everything we've seen, disappointed, horrified, but unfortunately at this point, not stunned. This is not okay. What the remedy for that will be is for the court to decide, and we will see. But we already know how mad the court is about this. We saw it on Friday last week. We're gonna move on to Scandoval, and we will come back to a lot of this when we get Kari Morrissey's response. Al Salt said, big disappointed energy. Big, huge disappointed energy. We will get back to this, and we will touch in on some other things in this motion when we get the state's response. That will probably be soon. When this hearing gets set, we will do the hearing together. Absolutely. So that's why I need to remind you that the Law & Order app is what you need. The Law & Order app is absolutely what you need, because whenever this hearing gets set, we are going to cover it. We're also going to be off schedule on Monday. So if you have not yet downloaded the Law & Order app, download the Law & Order app. We have a lot of exciting improvements. Some of them were rolled out last night to improve our notification delivery. The Law Nerds are like, we break shit and keep moving, but we have a lot of improvements on our delivery, and we are very exciting. Does Team Baker know how to make an app? Now we do. Did we ever assume as a group when we started making videos on YouTube that was information and knowledge that we needed? No, not at all. Have we learned things? Yes. And we had a really good call with all the heads of tech yesterday to make sure that we were working smoothly with the app and that delivery was improved and vastly improved. And I'm really excited about those updates. Some rolled out yesterday. Some are rolling out soon. So we've got a lot coming up. I get notifications from the app. We've got a lot happening in the app. It's great. It's great. So Danielle said, where are Kari's supervisors? She is the special prosecutor. She doesn't really have any. The point of the special prosecutor is that she is outside of the prosecutor's office. She's working independently. So it's her. And she's an experienced enough attorney that shouldn't be a problem. So as we are continuing to work, we will be moving on. So I'm going to change us back from Code Red because we might end up there again, honestly. Like, we might end up there again. So let's see. Sarah asked, can they dismiss Kari Morrissey and use Erlinda? Erlinda left. I don't think Erlinda would touch this. Could they? I don't even know if they can. So I'm going to answer just a few questions, and we're going to move into the Scandoval of it all. And then we will answer more questions at the end for Q&A. So we will get to more of the super chats then. Please make hot pink. I'm not sure what, Vicky, we need to make hot pink, but we do need to make the lights go back. So we do need to make the lights go back to hot pink. Jessica said, I am replay crew for the members only, but thank you for the NKOTB recap. I'm going tomorrow night in Tampa. I also ordered Lumi. Wear it to the show. It was so hot in Nashville. It was a lot of fun, though. It was really a good time. Marcel said, yay, EDB live on my birthday. Hey, Marcel. It's my birthday as well. Turning 30 isn't fun. Turning 30 is great. The less fucks you give. Look, man, the less fucks you give, the older you get, the more fun it can be. Yes, you have to work on like the body starting to hurt and the eyes getting a little tougher, but I'll take it. I'll take it to be here. So I'll absolutely take it to be here. Had surgery in a different country, caused wait times. Green 39, that makes sense. Fancy said, my dad is a surgeon and he hated going to court as a witness. He was called to jury duty once and he was so angry he was red. Thankfully, he was cut. Because they're like, how do I have to do this? I have things to do. Here's the funny thing about being an employee of the government. They can't tell you not to do jury duty. So there were occasions that DAs would end up on like civil trials that were lasting like 4 months, and everybody would have to cover their cases because they're DAs, and the DA's office can't be like, no, you can't go do jury duty. So they would be on jury duty for months and months and months and be like, I can't work. I just have to go sit in court for the next 4 months. I don't have to do the case. I'm not touching my files. I'm just on jury duty. I get a real lunch break. But this is the best. Bye, y'all. I was waiting. I was like, put me in. If I'm not in trial, put me in. I'll do it. You want me to do a grand jury? I'll do a grand jury. I'm down. Let's go. I'm down. Let's go. Jolene said, what about getting paid? No, you get paid. As a government employee, you get paid for your jury duty. You just get to go watch other people work. So nobody was mad. They're like, I'm just here to see what happens. I had DAs pop up in my jury panels. They couldn't be on my case because also same office, but I had DAs pop up in my jury panels and I was like, hey, the judge is like, does everyone stipulate to excuse the DA so-and-so? It's like, yeah, absolutely. So when work pays for jury duty, it's like, I'm out. See you later. Liddy said, cute pun. Her surgeon father was cut. Yep, absolutely. All right. Scandoval. Let's see. I'm going to put up a poll real quick. Miguelina, will you just let the app know we're changing topics? Let's do a Q&A real quick. Not a Q&A real quick. Let's do a poll real quick and see how many of you have our knowledge of Scandoval. Do you know? Let's see. Yes. Oh. No. So yes, no, a little bit, only. All right. Do you know Scandoval? The options are yes, follow VPR, all the things. No, what is that? A little bit, and only from watching here. Those are your options. So let us talk about the Scandoval of it all. I'm going to give you a swoop. We're going to do a quick road so far, and then we're going to get into all of this. Don't worry if you don't know what any of the surrounding drama is. The legal stuff I find to be very interesting. I hope you do too. Scandoval Lawsuits. So, on Bravo, there's a show called Vanderpump Rules. This show started, 11, 12 plus years ago, following the lives of the model actors that also worked at one of Lisa Vanderpump's restaurants. It followed their friend group. It was very Melrose Place, but reality show. People were quite intertwined and intermingled, hooked up with one another. I think everyone on the show, it felt like some people had hooked up with one another. People cheated on each other. Mess. And so as they have grown from their early 20s to their 30s, we have watched the cast of Vanderpump Rules go from being kind of messy and all working at the same bar, hooking up with each other, to getting married, getting divorced, having kids, building families, and trying to figure out what their life looks like as adults. And we've watched the show and them evolve in that way. Two individuals on the show, Ariana and Tom, were together for over 10 years. Tom and Ariana got together, it seems, while he was still with his previous ex, but that is water well under the bridge. Tom and Ariana lived together, shared a mortgage together, were building a life together. And it was very clear that they, or at least on the show, were building their life and future together as committed partners. Ariana was very clear she didn't want to get married, but they were just like, we're in it. We've got pets. We've got a mortgage. We've got a house. Let's go. I have covered the lawsuit over the house. There is a lawsuit going on over the house of Tom and Ariana because he wanted to buy her out. She didn't like the rate he was offering her. This played out last season on the show a bit. So they are in litigation over a forced sale of the home to split the house essentially in half because they own it 50-50. So she can't just sell it. He can't just sell it. They have to agree on how much it's being sold for, and they are asking for the court's help with that. So the house is contested. It is in litigation now. Separate and apart from that, at the end of last season, Ariana had become very close with another cast member, Rachel. At the time, she was going by Raquel. She has since asked to go by Rachel. I am going to call her by the name she asked to be called, as I do with everybody. So Rachel, if you watch the show, was then going by Raquel. Rachel was with one of the other cast members, DJ James Kennedy, and came onto the show dating DJ James Kennedy. DJ James Kennedy had also hooked up with Tom Sandoval's ex, Kristen, and then he and Kristen were dating, and it seems like that's what brought him onto the show. So DJ James Kennedy dates Kristen, gets onto the show, breaks up with Kristen, starts dating Rachel. That's how she gets onto the show. Rachel becomes super close with Ariana, and unbeknownst to us, with Tom Sandoval in a more sexual way. So Rachel starts having a intimate relationship with Tom Sandoval behind Ariana's back. The shocking part of some of this is that like Rachel had like location sharing with Ariana. Came out in the lawsuit. So Rachel knew where Ariana was. So when Rachel is hooking up with Tom at Ariana's home, when Ariana's at her grandmother's funeral, Rachel knows that Ariana is not around. So Rachel is hooking up with Tom. Ariana doesn't know. Ariana, this is 10 years in to her relationship with Tom. So as cameras go down, we start hearing rumblings that Ariana has found out. This all goes down in March while Sheena is at Watch What Happens Live with Rachel. Watch What Happens Live is Andy Cohen's after show that talks about the show, brings people on, talks about the season, talks about the reunions, the bravo of it all. They're at Watch What Happens Live in New York. Ariana's at a concert for Tom's cover band in LA. Tom's phone falls out of his pocket, according to the lawsuit and everything we've seen about this. So now I'm going with the facts alleged in the lawsuit. Tom's phone falls out of his pocket. It's given to Ariana because that's his woman, right? This is his partner. She, it seems from allegations in the suit, knows his passcode, has access to his phone, and sees in his phone a video recording of Rachel and him phone sexing over FaceTime. This lawsuit comes from that. So the lawsuit we're talking about today comes from Rachel and Tom on FaceTime, doing the adulty things, and Ariana seeing that video, sending that video to Rachel, essentially saying, "What the fuck?" and the ensuing fallout. Cameras go back up. Bravo. Cameras go back up, and Scandoval rocks the nation. It is everywhere. I think the New York Times called Tom Sandoval one of the most hated men in America. It comes up in this lawsuit and statements about the lawsuit. So with all of that, Ariana and Tom, in lawsuit over the house, are sued by Rachel and are sued by Rachel for what's going on with the video and for Ariana sharing the video back to Rachel, which may or may not count under the law. We'll get there. And for Tom recording the video. Tom alleges that Rachel made the video and sent it to him. We also have the sideshow of that where Sheena, who had been close with Tom and purported besties with Ariana, is on Watch What Happens Live with Rachel the night this goes down. Sheena gets called by Ariana, finds out what happened. Sheena and Rachel get into it. Rachel gets a restraining order against Sheena saying that Sheena punched her. Sheena says she pushed her. There was a confrontation. There was a restraining order. It was later dropped. That all has come up on the show in the reunions mess. Rachel did not return for season 11. Not surprised. Rachel checked herself into a mental health facility. Tom was mad that she didn't want to stay on the show. Tom seems to me, my impression, to be one of those people who is like, I know this really sucks to go through for life, but imagine the content. Like, I feel like Tom is, when creators talk about content brain, I feel like Tom is like, yeah, it sucks, but it's great for the content. But it's great for the content. And it seems that that is how Tom, to me, through all of this, views his life. But it's good for content. It seems to me that the women in Tom's life viewed their encounters and relationships with him as real and not as content. I don't know if Tom viewed his relationships as real or as content. Like, I wonder if Tom sees, and this is ponderance, I wonder if Tom saw his relationship with Ariana as a content house. We're better as a couple. We're more sellable as a couple. We're more profitable as a couple. We're Tom and Ariana. And that's our brand. He elbowed his way in to her first book on cocktails. And I think Tom sees everything in his life as content and as the brand. From everything we've seen, from the interviews he's done, from all of it, from the fake crying. His behavior is horrific. I think Ariana really saw this as her life. And they also are on a reality show. And I think there was a difference there. Since then, the fallout has been that Tom became maligned. Ariana had quite a lot of opportunity. The internet very much rallied around Ariana and saying, I can't believe we thought Tom had changed. We saw you for 10 years. We thought you had changed. We thought this was better. Ariana has since done Dancing with the Stars, has done Broadway, is the host of Love Island, has done like all of the things. Tom is struggling, it seems, with his bar getting, review bombed, people not wanting to go to Shorts and Sandy's, not having nearly the opportunities. And we've seen some on the cast be frustrated that Ariana, what were Lala's words? Got cheated on and became God. So some in the cast are just like, really? But they all also have podcasts and YouTube channels. And the cast, except for Ariana, has talked, and Katie, has talked about this at length on podcasts and YouTube. And on and on and on. Rachel sent out cease and desists early on about the video that was discussed, including to Lala, who was on live stream and was like, I don't give a fuck, send it to Daryl, and then made the send it to Daryl merch that bought her like a $3 million house. The only reason I bring it up is because she talked about it in multiple interviews. So the rest of the cast talked about this nonstop on their own stuff. Ariana stayed booked and busy. Tom, not as much. Rachel left the show. Rachel checked off of the internet and into mental health treatment for herself and seemed to try to take care of herself. And then ended up back in the conversation during this lawsuit. She sued with an attorney that is also working with other housewives to sue Bravo and others. So Mark Garagos, not Garagos, whose name you might recognize from things like being the defense attorney for Scott Peterson, has been working with other Bravo Lebs to sue regarding all of the Bravo, ducking Bravo of it all, the reality reckoning, as Bethany Frankel called it. So he has been working with a lot of those lawsuits. So he files the lawsuit from Rachel against Tom and Ariana. Let me see, where's my complaint? We're gonna peruse the complaint very, very briefly, just for context. I covered it. You guys have seen it. But I think it's helpful to go through because some of you follow it. And some of you are like, I only watch your coverage of it. And some of you are like, I have no idea what you're talking about. Hopefully you're up to speed now. So we're going to look at the claims in this lawsuit very, very briefly. I went over the entire thing. And this lawsuit is about the potential revenge porn, the alleged revenge porn. Has this gone to police? No. Is this illegal? Yes. Has it gone that route? No. Did it go that route? No. The causes of action here are eavesdropping, revenge porn, invasion of privacy, and IIED. We've also covered some of these in California and other cases. Rachel has said that the behavior of Tom and Ariana, they do not sue Bravo, and half of this lawsuit is throwing everyone else under the bus in a needless way, or in a non-legally relevant way. Maybe she felt that it was needed to have her say in a lawsuit where she can't be sued for defamation. But anyway, eavesdropping, revenge porn, invasion of privacy, IIED. And when we get to, I'm not going to scroll and make all of you nauseous. I'm going to get to the causes of action and go through briefly what they are because they become very relevant to what's happening now. Eavesdropping against Tom Sandoval only. Jen McEwen, I don't care. Thank you, Jen. Okay, that's going to sound rude if I don't read the whole question. Jen said, Emily, I don't know if you want to say revenge P or even revenge porn, or if you care about demonetization with serious issues. I don't care. I honestly, if we're demonetized, I'm not bothered, but I'm not going to talk about, or I'm not going to talk around what it is when we can't. It's a lawsuit. These are the legal charges. If it gets demonetized, it does, but it needs to be, I think it should be talked about. And I think as technology grows, this is a huge issue. So these are the original causes of action. Eavesdropping. Plaintiff incorporates by reference all the allegations. Levis and Sandoval engaged in numerous private and confidential video conference communications. Those are the FaceTime videos from 2022 to 2023. Unbeknownst to Rachel, and I'm going to try to go by first name when I can. Unbeknownst to Rachel, and without her consent, Sandoval surreptitiously recorded their communications. No. Like, I don't know what a bigger red flag there is. No. You do not surreptitiously record. And again, this is somebody he's chosen to enter into a relationship with. Though they are having a relationship behind Ariana's back, this is still a violation and a breach of trust in this situationship that he has chosen to get into. You do not surreptitiously record people. No. No. He's saying he didn't, by the way. Rachel had an objectively reasonable expectation that these communications were private and objectively believed that they were not being recorded. At no point prior to the confidential communications that was Rachel informed that Sandoval was recording their communications. Nor did Sandoval obtain consent from Rachel to record her. Rachel is informed and believes, and on such information and belief alleges that some of the unlawfully obtained recordings depict her in a state of undress and engaged in sexual acts or sex acts. Yeah, that seems to be what happened. And she would know because Ariana sent her that video from Tom's phone. So Tom recorded it. Tom says she made the video and sent it to him. She doesn't. And so, no. Should she be cheating with Tom on her friend's man? No. But does she still have a right to believe that the person she's sexually engaged with is not recording her without telling her that? Yeah, she has a right to believe that. So we're going to do two things are true at once. I know people have strong feelings about Rachel. I absolutely get it. This is not behavior that we engage in with our friends' partners. Don't do that. But you still don't get recorded against your consent. Don't do that. Don't do that. So multiple things true at once. Don't do this. This is a horrific violation of trust. This is illegal. Don't do this. Don't do this. So this is not okay. And what I would say to Rachel is it must have been difficult to choose to bring this lawsuit knowing how strongly people feel about her and about this affair. People have very, very strong feelings about her and about this affair. But that doesn't stop her from also being violated by Tom's behavior if her consent wasn't given. And often you see victims choosing not to speak up because they feel ashamed of any behavior of theirs. Rachel's behavior of cheating, not good. Not good at all. But it does not make Tom's behavior less deplorable, illegal, and something she can't sue over. This must have been a very difficult decision for her. And it can be for lots of individuals to say, I don't know how to stick up for myself because there's this other stuff. And so when we look at a takeaway from this, it can be that her behavior in choosing to engage in this relationship is not okay, but that Tom's behavior is also not okay. And Tom's behavior is illegal, and Tom should not have done this, and she has a right to stand up for herself and say no. She has the absolute right to do that, even though the situation she was in is not great. She consented to the behavior with him. She did not consent to the recording, and non-consensual recordings are not okay. So this must have been hard. And I know lots on the internet shit on her for doing this. Tom shouldn't have recorded her. Hands down, period. Should not have recorded her at all. This is not okay. And even if, I'm not saying that's the case here. I'm saying this as we talk about this topic. Even if there are consensual recordings, I'm not saying that's what happened here. You still can't share those and show them to people. You can have consensual photos that you send to someone, recordings that you send to someone. That can be a way that you engage in your relationship with someone. Don't send them if they don't ask. But if that's a way that you engage and want to engage, you can. It is illegal for the other person to share them, to show them to other people, to distribute them, even if there was consent in making them or sharing them. So when we're talking about these laws, you can't share things, even if they are given to you in the context of your relationship, made and given to you for your private situation, right? This gets harder and more complicated the more technology there is. And I wonder if when using FaceTime as opposed to recording a video, sending a picture or whatever, when there is a FaceTime, if the expectation is even more that when we hang up the call, this goes away. Just like when you're talking on the phone, unless you're on a recorded line, CEG yesterday's members only live stream. If you're on a call saying the things and it's recorded and you don't know, problem. But I just wonder if the choice of FaceTime is with the belief, understanding, and expectation that when you hang up that call, the FaceTime is gone, as opposed to sending a picture, as opposed to sending a video. So then recording that FaceTime becomes a problem. What's going to come up in this lawsuit is, do you know if a FaceTime is being recorded? That is going to come up. Are you aware? That is going to come up. But it can be hard to stick up for yourself in a situation like this, and I can't imagine this choice was easy. I will also say that Tom said on the reunion that he thought that Rachel going after Ariana was essentially despicable. So hopefully this helps. Some of you are saying, I did not know. Good. That's why we're talking about it, because you need to know. You need to know that because these things are done to people all of the time. And you need to know that it's not okay. And it's not on you. And if you have an expectation of privacy, that expectation is to be respected, and it is illegal in a lot of states. So I think it's an important topic to talk about, even though Rachel is definitely not beloved based on all of this behavior, still has a right to privacy, still has a right that the person she is engaging in these calls with is not recording her without her knowledge or consent. And even if, I'm not saying it's here, even if there was consent to record, like, you know, keep it for you for later, that still isn't consent to share it. So there's a lot of conversations here. So let's continue on with this, because this is the foundation of what comes next. And what comes next is Tom suing Ariana over this. Okay? So this count of eavesdropping is just against Sandoval for the recording of the FaceTime video wherein Rachel was naked and engaged in self-pleasuring sex acts. Accordingly, they say that Sandoval has violated California Penal Code, which is the criminal code, of the privacy rights conferred upon Rachel under California law as a result of Sandoval's illegal actions, and herein alleged she has been injured, including without limitation, by having her privacy invaded. Rachel is informed and believes, and on such alleges, that in performing the acts herein, Sandoval acted with oppression, fraud, and malice, and alternatively acted with such conscious disregard, and that's probably the one, conscious disregard of the right to privacy that as a direct and proximate result of the acts, she is entitled to punitive damages, the punishment ones. Second cause of action, revenge porn. Plaintiff incorporates by reference all of the allegations set forth. On or about March 1st, Ariana discovered sexually explicit videos of Rachel on the phone of Sandoval. This is the heart of the new lawsuit. So, Raising Heroes, thank you. Raising Heroes said in the chat, wow, this is important stuff to understand. That's why we're covering it. And when I said this goes beyond like reality TV drama, this goes beyond that and touches on bigger issues that people just aren't aware of. And these things are leveraged against people with shame. People who will share stuff that is not consented to be shared will also leverage the shame in the thing to keep people quiet, which is why I think it's important to talk about it, and why I'm not going to, though the chat is very protective and conscientious of me, and I appreciate it, I'm not going to mince words on it, because it needs to be discussed because people don't know. So we're going to talk about it because I think this case is legally A, significant, and B, important to understand. And we teach law through pop culture. On or about March 1st, Ariana discovered the sexually explicit videos of Rachel on Sandoval's phone. The videos depict Rachel in a state of undress, engaged in a sexual act within the meaning of the statute. Agreed. And we're not going to go through it. Yes, agreed. Tom recorded the videos without the knowledge or consent of Rachel, who had a reasonable expectation in privacy in their private communications not being recorded and would stay private. It's a FaceTime. And we know it's a FaceTime because all the cease and desist said don't talk about the FaceTime. So we know it's a FaceTime video. Rachel is informed and believes, and on such alleges, that Ariana obtained the videos of Rachel from Tom's phone without Tom's authorization. Tom is suing over this. We're going to get to it. Rachel is informed and believed, and on such alleges, that Ariana obtained the videos of Rachel from Tom's phone and distributed and disseminated them to others, including but not limited to Ariana and Rachel and other individuals whose identities are not known. That is going to be a critical part of this case. What Ariana has said is that she didn't send the video to herself. She sent it from Tom, or she did send it to herself and then sent it to Rachel with a what the fuck. And we're going to get to that. Rachel is informed and believes and alleges that Ariana displayed the videos or disclosed their contents to individuals who may or may not have received them directly, including but not limited to Bravo, Evolution, members of the cast, and other individuals whose names and identities are not known. Ariana fervently, strongly, and has always denied that part. Ariana said she told people, but that she did not send the video to anyone. Rachel was not aware that such illicit videos had been captured by Tom and thus could not have consented to their distribution. Ariana, they allege, distributed, disseminated, shared, and publicized the videos intentionally and knew or should have known that she did not have Rachel's consent to do so, which is going to be a big sticking point in this case about what Ariana knew or believed. Rachel suffered grave emotional, psychological, financial, and reputational harm as a result, they say, of Ariana's distribution of the video. This is going to be fought over in court, because was that harm over the video or was that harm over the cheating? I think a lot of that harm was over the cheating. But that's for another day. The videos were recorded when Rachel was in a private residence and the reasonable expectation was was of privacy. Like, she wasn't in a room of people, right? It's like when you think of attorney-client privilege between you and a lawyer talking is one thing. If there's 3 people in the room, there's no privilege there. There's other people there. So she's saying the video was different. I saw a couple questions, like 3 of you asked in the chat, back and forth, was the video made public? No, Nadine. The video did not surface publicly. Ariana says she sent the video to Rachel with a I know. Rachel says that Ariana sent the video from Tom's phone to her own phone and then to Rachel. They're also alleging that Ariana showed the video to others. Ariana denies that. Everyone else has denied that. Everyone else said Ariana told them about the video, but did not show them the video. Invasion of privacy goes to both Sandoval and Ariana. They say that Sandoval invaded her privacy by recording the video or recording the FaceTime call and should have known that illicit recording without consent would have been highly offensive to a reasonable person. Chat, I think any of you say being recorded without your consent when you believe it is a private, intimate sharing is highly offensive. That Rachel could not have consented to Tom's recording because she was unaware he was doing it, that the footage was captured during private, intimate communications, and she had every reason to believe they would remain private. The invasion of privacy was offensive and objectionable to Rachel and a reasonable person of ordinary sensibilities. And the chat is like, yeah, offensive. And they go on to talk about Ariana also obtaining the video and distributing the video. In the video where I break all this down, we talk about the law as to distribution. There are some legal issues here for Rachel. Those I've already discussed. 4th cause of action, IIED, the intentional infliction of emotional distress. I do think we saw the emotional distress from Rachel. She is saying that that is because of this video and that the acts of Tom and Ariana are extreme and outrageous beyond the bounds of human decency. Now, Ariana has said that Rachel's lawsuit against her is cruel and disgusting and beyond the bounds of decency. So from there, we are going to multiple motion. Tom made motions to strike a bunch of portions of the complaint. Some of those were granted because there's a lot of stuff in that complaint that didn't go to any of this. Ariana made a anti-SLAPP motion that was denied. If you want a breakdown of the anti-SLAPP motion, we can do that another day. I don't think we're gonna have time to do that today. Because of Tom's motion, there was an amended complaint. This is the amended complaint from June. That motion was talking about DJ James Kennedy being a terrible dog dad. I'm not fucking kidding. So they made the motion to strike a bunch of the irrelevant shit. That lawsuit spent pages throwing everyone under the bus. Everyone. So the amended complaint, just for clarity, this was from June 13th, 2024. Same causes of action, but trimming of the stuff in the preliminary statements per the motions from Tom. So taking out a lot of the irrelevant, I think, stuff written for media. It was juicy. I mean, it was all the tea. All the tea was in there. All of it. But irrelevant to this lawsuit, so that's come out of this. And it's pared down the lawsuit by a number of pages because of it. So let's see. One of the things I wanted to get to was something I have not seen covered. This is a first look. I don't know what's in this, but I wanted to give more context before we go to Tom's lawsuit. Ariana lost her anti-SLAPP motion. The court's like, this is illegal behavior. This is not protected speech, sending this video. So no, this is not what anti-SLAPP is for. In the course of the anti-SLAPP, which we cover the nitty-gritty day in, day out litigation of cases. Not everybody does. But in the nitty-gritty day in, day out of litigation, Rachel filed a 17-page declaration, and so did one of her, I think, parents in relation to the anti-SLAPP motion. So we're going to go through those declarations before we get to Tom suing Ariana. Okay? So this is not Rachel's declaration. I think is this her mom's? We're going to find out. Oh, father. This is her father's. It's Kari. I couldn't tell which Kari we were going with. This is her father's declaration. So let's see what in a anti-SLAPP declaration Rachel's father has to say, and then 17 pages of what Rachel has to say. So this is a declaration in support of the opposition to the anti-SLAPP motion that was denied. Declaration of Rachel's father. Plaintiff spent approximately 3 months at the Meadows receiving inpatient mental health treatment. The Meadows is a residential treatment center for substance abuse and mental health issues located in or around Wickenburg, Arizona. I caused approximately $115,000 to be paid on plaintiff's behalf in connection with her treatment at the Meadows as attached for Exhibit A, which are bank statements reflecting payments of $113,000 to the Meadows and the $399 required for therapy books. An additional $1,100 in costs were incurred in relation to Family Week of Therapy at the Meadows that are not reflected on the bank statements. $115,000 of inpatient treatment. So I don't know if they redacted these bank records. Oh, they did. Well done. So this shows what was paid. And again, in showing what was paid, they are establishing some of the actual damages here because they are alleging that there is intentional infliction of emotional distress and there are costs associated with all of this. And her family said, yeah, these are the costs. We paid $115,000 for her to go to mental health treatment because of how devastating all of this was. So, with that, we're going to go to her declaration. We are not going to go to the opposition because the motion's already been resolved. But we are going to her declaration because A, I haven't seen it reported on, and B, I'm curious as to what it says, and C, it's going to give context. This is from June 27th. The hearing was July 11th. So this was just recently denied. We were in trial. Rachel declares as follows and submits, this is under penalty of perjury. This is Rachel's testimony in this case at this point. From 2016 to 2023, I was a cast member on Vanderpump Rules, a Bravo reality television show. The show revolves around the personal and professional lives of the staff at the West Hollywood restaurants of Lisa Vanderpump, a British restaurateur and former Real Housewife of Beverly Hills. Well, that's very succinct. Yes. Vanderpump Rules has aired continuously since 2013. I made my first appearance on VPR in 2016 due to my relationship with another cast member, DJ James Kennedy. I met Kennedy at Sir, one of the Vanderpump restaurants, and began working there as a server. In that capacity, I became acquainted with defendants Tom and Ariana, both of whom were bartenders and cast members. After breaking off my engagement to Kennedy on the show, I became increasingly isolated. I began to confide in Sandoval, who had been in a relationship with Maddox since 2014 and lived with her in Valley Village, California. Over time, we became increasingly close, and I began to rely on him for emotional support. He, in turn, began to confide in me about the dire state of his relationship with Maddox, describing it as a business partnership and casting its end as foregone. Because if this hadn't been discovered, Sandoval would have spun this all on Ariana. You could see the groundwork. When you watch season 10 in hindsight, you can see Tom laying the groundwork for leaving Ariana to be with her and painting himself as not paid attention to, and not taken care of, and that Ariana didn't even buy batteries and toilet paper. She wasn't a good partner to me. She didn't want to go skydiving. He fucking said it. He fucking said it on the show. She didn't want to go skydiving with me. Dude, you have other friends. So he was laying the groundwork when you watch season 10 for him being the wronged party. Because it was so hard for him. So if you haven't watched the show, it's that. Sometimes in long partnerships, and my husband and I are going to be celebrating our, 24th wedding anniversary, 22nd wedding anniversary. Shit, I should figure out which. Our 22nd wedding anniversary this weekend. Sometimes we have different interests. And guess what? You go do those interests with people who love them. And then you are still loyal to your partner. Because I bet you can find someone who wants to go skydiving who's not your partner. Okay. So I think we're at 22 years. We're going to a concert. I'm so excited. Emily, how are you celebrating your wedding anniversary? Going to see Def Leppard and Journey, obviously. And food, there will be food. So this Sandoval saying this to her tracks with what we saw in the show as well. And when we watch the show go alongside real life, this absolutely tracks what we saw on the show. Thank you, Chris. One of my dear friends, also teammate on Team Baker, texted me, yes, 22 years, because we got married the same summer. Thanks, friend. I could have mathed, but it took me a moment. Thank you. I should have looked the same. My marriage is the same age as the Busted Stuff album from Dave Matthews Band. I should never forget this. But alas, we are celebrating our 22nd year wedding anniversaries this year. Thank you, Chris. You were the best. All right, back to Scandoval. This seems to be, I think what Tom was telling, I think this is a true recitation of what Tom was telling Rachel. And I think this is a true recitation of how Tom was starting to spin on the show. So, in turn, Tom began to confide in me about the dire state of his relationship with Ariana, describing it as a business partnership and casting its end as foregone. I viewed Tom as a close confidant, friend, and our relationship as platonic. It became increasingly clear, however, that Tom had different intentions. By the end of the summer 2022, Tom had worn down my defenses. We started sleeping together in August and continued doing so throughout the early months of 2023. Our sexual encounters were not filmed or recorded as part of Vanderpump Rules and did not take place in the presence of another person. That goes to the invasion of privacy counts and what have you. During this time, that's legally relevant, even though it's like weird. Why do you have to say that? It's legally relevant. During this time, Sandoval and I regularly communicated privately in real time via video conference on FaceTime and sometimes sexually. All of these communications were confidential, and I had every reason to believe they would remain confidential. Tom never asked my permission to record them, and I was not aware he was doing so. Had he asked, I would have said no. I mean, at that point, you are a public figure, and I can imagine she definitely didn't want that to be anywhere. If I had known he had done so anyway, I would have been furious and demanded he delete them. Under no circumstance would I have consented to being recorded naked and masturbating. On March 1st, we've mentioned it all. On March 1st at approximately 10:30 p.m. Eastern time, I received a series of text messages. Remember, she was in New York at this time, filming with one of Ariana's best friends at the time, Sheena. I have no idea the status of their relationship. That's why I couch. And, well, after this season, I have questions. I guess it's the right way to say that. So she was there. Emily, keep reading. At approximately 10:30 p.m. Eastern time, I received a series of text messages from Ariana. I was at a bar in New York with Sheena Shea, another Vanderpump Rules cast member and close friend of Ariana. We had finished taping Watch What Happens Live with Andy Cohen. Ariana sent me 3 messages. The first 2 were video recordings, and the third stated, "You are dead to me." Oh, that's right. What the fuck? Dead to me. Same. I use them synonymously. Immediately, I looked at the video recordings, which did not look familiar, and I saw that they depicted me undressed and masturbating with Sandoval's face visible in the corner of the screen. I realized those recordings depict my private, intimate video calls, FaceTime calls, with Sandoval, which he had evidently recorded without my knowledge or consent. Those recordings were captured in or around February 2023 while I was in a private residence. Given Tom's apparent practice of secretly recording me, I have every reason to believe that he captured additionally sexually compromising videos or images of me. Not okay. Not okay at all. None of these intimate conversations were part of Vanderpump Rules. They were private communications reflecting a clandestine affair. Neither their contents nor their existence were ever supposed to see the light of day. I had every expectation of privacy and remained appalled that Tom has put me in this position. Remember, Tom was disappointed she didn't come back to the show. And on this season of the show, you see Tom grappling at the point that she set a boundary, and that boundary was to not talk to him anymore. And he, on this show, this season of the show, seemed pissed at Rachel that she wasn't like riding it out with him as she was trying to deal with the breach of trust of being recorded and the fallout from Scandoval. So Tom on the show being like, I can't believe Rachel's mad at me. Are you fucking joking me? You recorded her without her consent. Her behavior tracks with what she has said. Her behavior was to cut him off 100%. Her behavior tracks was she didn't know. He says she knew. She says she didn't. Her behavior tells me that when she set that boundary, she didn't know. We'll see what happens. We'll see what happens. She said, I reacted to Ariana's messages with shock and alarm because the recordings were sent from her phone, not Sandoval's. And that's going to be a point of contention about Ariana sending them from Tom's phone to her phone. Is that going to be enough to count as distribution? That's a question in this case. That is a very real legal question and potentially a difficult one for Ariana. This hasn't been explored a ton in the courts in California. So it is a new question. What is meant by distribution? Is sending it from phone to phone and then to her enough? That is a legal question. But these facts seem to not be in dispute. These facts seem to be consistent with what everybody has said. Ariana said, I sent it and I sent it. Is that legally sufficient? We'll see. So I went over the legal definition of distribution. It is not super clear, but I went through the legal definition of distribution in the video where I broke down the original lawsuit on the Emily Show podcast. So I'm just pointing out that there are legal questions here and the legality of it, because when you're looking at Ariana discovering that her partner of 10 years has a video of her good friend, naked and involved in an activity with his face in the corner on a FaceTime, you look at that and you're like, I understand why Ariana is going, you're dead to me. This is why. Like, you met emotionally, you get it, right? But legally, this could be a problem. So Rachel says, I reacted to Ariana's messages with shock and alarm because the recordings were sent from her phone, not Tom's. I knew that she had somehow taken possession of the videos, and this made an already difficult situation decidedly worse. Rachel's behavior after this, before this lawsuit, I think is informing to that this is what she believed. Why do I say that? Rachel immediately sent out cease and desist to like the entire cast. So it seemed to me that in the real-time moment, Rachel was concerned that the cast would all have this, or that Ariana had sent it to everybody. That's where the send it to Daryl moment with Lala comes from. It's a cease and desist over this. Everyone in the cast said that that didn't happen, but in real time, she acted as if she was concerned that that happened. Went to a lawyer and said, I'm worried that they all have it. So that action in real time is consistent with this. So when we're looking for the, the context clues of it, Aaron said, who's the one with the black eye? Rachel. She says it's from Sheena. Sheena says she pushed her. That. And Vanderpump Robs makes a great point. After Sheena shared Stassi's video with everyone, I see why Rachel would do this, which was a plot point. I don't remember which season, because there was also a video like this of Stassi that Lisa Vanderpump actually paid to get back. This had come up with the cast before. So, Nadine said that was a good move by Rachel to get a lawyer ASAP. Yeah, she was worried. She was worried that this was going to become very, very public. And was right to worry because Sheena knew and confronted Rachel that night. And then Rachel came back and got a restraining order against Sheena, but Sheena knew that night. So of course Rachel's worried in context of all of this. I get it. Let's see. From the tone and tenor of Ariana's messages, it was clear that she was furiously angry. Yeah, no shit. No shit. Given the circumstances, I was not surprised at her anger, but I was extremely alarmed and fearful about her intentions given the course of conduct she had evidently embarked on. Ma'am, she sent it to you. It is not just that Ariana had discovered the recordings and confronted me about their context. If that were all that happened, Ariana would not have been named in this lawsuit. But that is not all that happened. In her sworn testimony, Ariana acknowledges that she stole and disseminated them. She distributed the recordings from their original source on Sandoval's phone to herself, to me, at a minimum. That. So, without conducting discovery, which hasn't happened yet, on third parties, it's difficult for me to determine whether Ariana distributed the videos more widely than she acknowledges. However, there is every reason to believe that she showed the recordings to others and may have sent them to others as well. It is undisputed, however, that as a result of Maddox's actions, the circle of possession widened from Sandoval alone to Sandoval, Maddox, and me. And that might be enough. That might be enough in this case. It's going to be enough to get past all these initial motions and go to a jury. It's going to be enough to get well past all of that. So, at the time, I did not know what Maddox intended to do with the videos, because Maddox is pissed. Maddox, to her credit, does not seem at this point to have distributed it to everybody. And keeping peace of mind while enraged, hurt, betrayed, nauseous, and all the things is hard. So, Marcy asked, didn't Tom chase Ariana and delete it from her phone? That's what Ariana said that he did. At the time, I did not know what Maddox intended to do with the videos, but her initial decision-making spoke volumes. Decision-making is an interesting word to use here from Rachel. The fact that it seems, from everything in this, it seems that she didn't. All of the cast says that she didn't. But decision-making, we'll see. Interesting choice. But her initial decision-making spoke volumes and suggested she was prepared to undertake drastic, reckless, and unlawful actions towards me. I believed then and continued to believe that Ariana was not in full control of her faculties at the time. Oh, ma'am, don't make it worse. And genuinely bent on revenge. I mean, she did tell Rachel to fuck herself with a cheese grater at the reunion. I mean, that did happen. She said she did say the mean things, but that doesn't mean she sent the video. She was fucking mad. Of course she was fucking mad. She has every right to be fucking mad. From my perspective, Maddox had telegraphed that she hated my guts. Well, she did say you were fucking dead to her. And now had sexually explicit footage of me that she could show to others, distribute more widely, leak on the internet. I understand the fear for Rachel here. I understand the fear here. I do. She's not wrong in her concern. The takeaway is that she could humiliate me at will and that I should not and could not sleep soundly. Making matters worse, I did not know exactly what Ariana had in her possession because I was unaware Tom had even been recording me. I find it difficult to believe that Tom did not capture additional explicit footage. So there was more of this and she knew there was more of this. I find it difficult to believe that Tom did not capture additional explicit footage, but I still do not know the full scope of the intrusion because they haven't done discovery yet, right? I also do not know what else beyond what she sent me Ariana stole from Tom's phone or what she did with it. What I do know is that I was utterly terrified. It caused me extreme emotional distress. That's part of why this is all being vetted, because they're talking about the damages as to the SLAPP lawsuit. While Ariana retained a computer forensics firm to image her phone, the outcome of their analysis lacks credibility. Ooh. It did not uncover even what Ariana acknowledged she did, the dissemination of the videos from Tom's phone to her own phone and then to me. The forensic analysis is apparently limited to what is currently on the image device and has not been previously deleted. A limitation of this magnitude greatly limits the utility of such analysis and affords me no reassurance that these videos or illicit content are not in the possession of her or others. The next day, I flew back to Los Angeles and told my family what was happening. Can you imagine? I confronted Tom about his gross violation of my privacy and trust. Tom admitted that he recorded me without my consent and apologized sheepishly for having done so. Not long after returning to Los Angeles, it became clear that I needed to retain legal counsel to mitigate the risk of wider leak of the videos. I hired Michael Holtz, the Holtz firm for the purpose, and incurred a total of $10,000 in legal fees. On March 7th, they sent cease and desist letters to Sandoval, Maddox, and others. Send it to Daryl. Attached as Exhibit A. Oh! They attached the cease and desist? I don't think I've ever seen the cease and desist in this case. Oh! Lawyer Emily is happy. I knew they existed, but we hadn't seen them. Emily, we can't stream for 4 hours. Also, Emily, we're doing all of this. We've done two 2-hour shows back to back. That's all. Two 2-hour shows back to back. Oh, we're getting into the cease and desist for sure. Yep. And then copies reflecting proof of payment to the lawyers. From the time of Ariana's disclosure, I've been battling dark and disturbing thoughts. My mental health was in absolute shambles. I mean, Ariana's disclosure based on Tom's illicit recording. I knew that I needed urgent psychological help. I decided, and good for her on this too. Good for her on this too. I mean, asking for help when it feels like the world is caving in is not easy. So no matter what you feel like you've done or been through, you deserve help no matter what. I'm glad she sought help for herself. I mean, not at without cost, but no matter what you have been through, you deserve help. If you need help. She said my mental health was in absolute shambles and I knew I needed urgent psychological help. I decided to immediately check myself into the Meadows. This is probably the best thing she could have done for herself, to put those boundaries up around Tom and to make sure that she was taking care of herself and gaining perspective. Checked herself into the Meadows, an intensive inpatient mental health facility located in Arizona. However, under pressure from Tom and production, I agreed to film the show's reunion episode on March 23rd. Following the reunion, I was checked into the Meadows and embarked on an intensive treatment of my rapidly deteriorating mental state. I remained at the Meadows from April 2nd to July 2nd, a 3-month duration, reflecting the magnitude of my mental health challenges and emotional distress. That's part of what's being sued for here. The cost associated is $115,000. She has not sued production. Keep that in mind. Maddox's implication that my mental health struggles were brief in duration or minor could not be further from the truth. I was in a state of extreme distress as a result of events described in the lawsuit, and I entered treatment in an extremely dark and scary place mentally. I mean, we're not talking about mental health on the internet if we don't say dark place. My symptoms included severe emotional distress, physical manifestations of such distress, anxiety, shock, embarrassment, loss of self-esteem, disgrace, humiliation, powerlessness, sleeplessness, nightmares, loss of enjoyment of life. I undertook various forms of psychological intervention and treatment and dedicated myself, and as directed by the professionals in charge, of my care. While I have come a long way since March 2023, my recovery remains very much a work in progress. I can state unequivocally that Ariana's actions, as described above, remember, this is going to Ariana's anti-SLAPP. This motion has nothing to do with Tom. Ariana's actions, as described above, were a principal contributor to the severity of my emotional distress. So she's pinning on Ariana that Tom's recorded video didn't come to her attention until Ariana did it. So she's like, so Ariana's actions are principally related to this. Tom's the one who recorded it, but this goes to Ariana's motion, so it has to focus on Ariana. It's interesting because in the reunion, Tom said Rachel going after Ariana was despicable, disgusting, something like that. The urgency and breadth of my need for treatment were necessitated in particular by Ariana's theft, dissemination, and continued possession of the illicit materials. Following discharge from the Meadows, I commenced outpatient therapy, incurring $4,000 in therapy bills. A true and correct copy is attached. Let's see the cease and desist, not the... Wait, where is it? Cease and desist. Damn it, it's just the bill for the cease and desist. I'm going to have to ask someone on the cast for this. I want to see the cease and desist. Honestly. But again, I think the cease and desist and getting the cease and desist in real time corroborates these allegations. So now that we've gone through the background, that is the longest road so far ever. The court denied Ariana's anti-SLAPP. The case is moving forward. Sandoval answered the complaint. And when Sandoval answered the complaint, he cross-claimed Ariana. So on July 16th, 2 days ago, Tom sued Ariana, apologies. Tom sued Ariana within this lawsuit as a cross complaint. That's where the fuck we're at. That's where the fuck we're at. So, bold strategy, Tom. Bold strategy. Bold strategy. And we're going to go through it right now. You guys ready? Tom sues Ariana in the complaint as a cross complaint where Rachel sues both of them. Tom is suing for indemnity, invasion of privacy into his phone, violation of Penal Code 502, and declaratory relief. We're going to go through this, but Tom is saying, look, indemnity, you will see, like, where's a context that's not this for indemnity? You will see indemnity lawsuits in, like, I don't know, construction. Well, it's in the Baldwin case too, in the civil cases, but construction, right? You have a contractor who's building a house. Something goes wrong with the plumbing. The contractor gets sued because, yo, fuck you with this plumbing. Sues the contractor. The contractor will often then countersue or cross-claim the plumber who installed all the plumbing and be like, look, if I'm responsible for this, you're responsible for this. I am not the problem. The plumber is the problem. So you're suing me, contractor. I'm suing plumber. So if contractor is responsible for the thing, plumber is responsible to me for the thing. So Tom is saying with indemnity, if I'm responsible for the thing, Ariana's responsible to the thing because Ariana did the thing. And based on Rachel's file, I'm so fucking glad that we went through Rachel's declaration, because legally you can see where Tom's lawyers are going, oh, Rachel is saying that the bulk of the damage to her is because of Ariana sharing the video. Well, Rachel also says that Ariana stole the video from Tom. So I can see Tom's lawyers going, this is not Tom's fault. He didn't distribute the revenge porn. Ariana did that. That's Ariana's fault. So Tom is saying, if I am responsible, you, Ariana, are responsible to me. So in indemnity, you can end up with a result where the other person owes you, and we're going to see what he's asking for. So he's saying, if this is a me problem, this is because of you. So Tom is suing Ariana after saying at the reunion that Rachel shouldn't be suing Ariana at all. Tom Sandoval, cross-complaint for Ariana. Cross-complaint simply means that it's in the same lawsuit. So if this goes to jury trial, the jury will decide both lawsuits together. It is bringing both lawsuits into the same thing. Rachel is suing Tom and Ariana, and then Tom is suing Ariana in the same lawsuit. So let's see what he has to say, shall we? I'm curious. Do we like that better? Do we like this better? We're going to leave it like this for the moment. General allegations. Cross-defendant Ariana is an individual resident of Los Angeles County. Tom, he doesn't even call himself by name. He just Sandoval. You're not Madonna, sir. What the fuck? Cross-complainant Sandoval. Okay. Is ignorant of the true names and capacities of the Roes. So instead of John Doe's, there are Roes because there are already Doe's as to Rachel's. So if Ariana distributed this to anybody else, they might get brought in here. He's leaving room for others. Tom is informed and believes and alleges that the Roes were agents and servants and blah, blah, blah. That's all foundational stuff. On or about March 1st, Ariana obtained access to Tom's cell phone and reviewed images, information, data, videos, or communications, including but not limited to FaceTime between Rachel and Tom without Tom's authorization or permission. Tom is informed and believes and alleges that Ariana made copies of the data, sure, the FaceTime video, and distributed the FaceTime video to Rachel and third parties without Tom's authorization or permission. This is a narrowly tailored cross complaint. Is his Instagram still down, by the way? I know he and his new girlfriend both deleted their Instagrams like yesterday. Comparative indemnity against all defendants. Ariana. On or about June 13th, Rachel filed the first amended complaint against Tom and Ariana seeking damages for personal injuries, legal fees, therapy expenses, medical and related expenses, civil penalties, and punitive damages. Rachel allegedly sustained as a result of Ariana's unauthorized and unpermitted access to, use of, and copying of the data video on Tom's cell phone and distribution of the same to Rachel and third parties as set forth. This all goes to what Rachel said in her declaration in the response to the anti-SLAPP. So he is using Rachel's anti-SLAPP declaration to go after Ariana. This isn't good. There are times where you might want to do something in court, but the court of public opinion is going to be so much worse that you just don't. This is not a situation as a lawyer I would look at it and go, hey, Tom, you don't have any option but to file this. This is going to suck, but you have to. This is not that. This is not that. This is not that. Why did lawyers decide to do this? Did Tom want to do this? Why did lawyers want to do this? He already ran his businesses through the mud. Doing this is not going to work. LH in the chat said unpopular opinion, but Ariana and Rachel are the victims, not Tom. I don't know if that's an unpopular opinion. There are things I think Tom did to Rachel that absolutely are a huge issue. There are things Tom did to Ariana that are absolutely a huge issue. So, I don't know if that's an unpopular opinion. Tom shouldn't have done any of this. So, second cause of action, invasion of privacy against Ariana. Ariana's going to say she had the code to his phone, right? That she was allowed to access his phone. Tom's going to say she stole it. How did she get into your phone if you didn't give her access to your phone? Tom, explain it to me. She's going to argue consent. That they have access to each other's phone. I can't say if my husband finds something on my phone that there's not consent there. He has access to my phone and my iCloud. Like, we've agreed to share those things. So, as everybody knows, with my Audible account. Oh, but when you've been married 22 years, every now and then you got to have the conversations and be like, no, this is the second Audible account. You have access to that one too. I've bookmarked things. That is too much conversation, Emily. Rein it back in. Rein it back in. Rein it back in. So, as we go forward with this, Tom is saying that Ariana invaded his privacy, that Ariana, without Tom's consent or authorization, invaded his privacy by accessing his phone. Look, I saw Sheena on Instagram yesterday say that Ariana had his passcode and that they shared those things. So Tom fucking Miss Me was saying that your partner of 10 years who you seem to have shared your cell phone password with invaded privacy while you're surreptitiously recording your mistress. Miss me. Miss me. He goes on to say the intrusion of Ariana getting into his phone. The intrusion of Ariana getting into his phone was offensive and objectionable to him and to a reasonable person of ordinary sensibilities. Chat, are you offended? You're reasonable people of ordinary sensibilities. Are you offended by Ariana's access to Tom's phone? Given the information that we know that he and she had shared passcodes? Miss me. Oh, I see your motion for code audacity. Yeah, chat granted. Code audacity is granted. Let's roll. All of it. All of the audacity. The reasonable jury of the chat has ruled against Tom Sandoval swiftly on this point. Because the audacity. So, Tom is saying Ariana's accessing his phone was offensive and objectionable to a reasonable person of ordinary sensibilities. That the intrusion was into a place or a thing that was private and entitled to be private. That it involved an unconsented and unauthorized invasion into Sandoval's cell phone and private data. Tell me more about consent, Tom? An authorization? Weird. Isn't it? In performing the acts herein alleged, Maddox was guilty of oppression, fraud, malice, because she acted with the intent to vex, injure, or annoy Tom, and with a willful and conscious disregard of his rights. Tom, therefore, seeks punitive damages against Ariana. Them sharing their cell phones is going to negate a lot of this. The fact that Ariana is going to have to defend against Rachel and also defend against Tom is going to fucking suck. But I think we will see her making motions to dismiss some of this, but she now has to defend on two fronts in this lawsuit. So is she going to feel ganged up on? That's me speculating. But now she's defending against her co-defendant and the plaintiff. This feels like Tom is real mad that she has come out on top of all of this. To me, this feels retaliatory and disgusting. Third cause of action, violation of Penal Code Section 502. Look, man, with law, just because you can doesn't mean you should. I get why Rachel brought the lawsuit. I do. I get it. Like, I get why Rachel brought the lawsuit. I understand. Do I love all of it? No. But do I understand that when you are violated in the ways she is alleging, that there is a point where you have to stand up for yourself and go, look, I will take ownership for my part in all the wrongdoing, but you cannot surreptitiously record someone to distribute it. I get it. This, I'm gonna take. We'll see if I get there. First look, nope, not there yet. As set forth in paragraph 4, Maddox, Ariana's unauthorized and unpermitted access to, use of, and copying of the data, or the revenge porn, as the plaintiff calls it, on Tom's phone, and her distribution of it to Rachel, and known or unknown third parties constitutes a violation of Penal Code Section 502, which is your privacy. In performing the acts herein alleged, Ariana was guilty of oppression, fraud, malice, and acted with intent to vex, injure, or annoy Tom. I don't think she had any intent towards Tom with any of that. I think her intent was to let Ariana's intent with this was to let Rachel know what the fuck she knew and say, you're dead to me because you're my friend and how fucking dare you. That's what I think. Fourth cause of action, declaratory relief. Okay, declaratory relief is interesting. This is not monetary damages. For those of you that have been around for quite a while, you know that this is asking the court, I do declare, this is asking the court to rule something or determine something without monetary damages. Hey, Your Honor, can you please solve this issue and give us relief on that issue? So what declaratory relief is Tom seeking? Tom wants, let's see, an actual controversy has arisen now and exists between Tom and Ariana. And so he's asking the court to declare that there is an actual controversy here to allow this to go forward. That Tom and Ariana's responsibility, if any, for the damages claimed by Rachel rest entirely or partially on Ariana. I read that awkwardly. Let me say it again. Tom wants the court to declare that the responsibility, if any, for damages claimed by Rachel rest entirely or partially on Ariana. And that as a result, Tom is obligated to partial or full indemnity by Ariana for any sums that Tom may be compelled to pay as the result of any damages, judgments, or awards recovered by Rachel against Tom. So Tom is saying, if Rachel wins in her lawsuit in any way, for him recording her without consent, which is what she's alleging, if Rachel wins and is granted damages, Tom is saying, then Ariana needs to pay because she is responsible, not me. We are going to go find the clip of what Tom said about Rachel's lawsuit at the reunion immediately after this, like so fucking fast, because I need to refresh my recollection needs to be refreshed. Immediately next. So Tom wants Ariana to either be partially or entirely responsible for any award that Rachel gets down the road. The shaggy defense isn't going to work here, Tom. Ariana can't send anything if you don't record it. The only way that shifts, putting these parties out of this, the only way that shifts is if Tom had consent to record. If Tom had consent to record, this could legally shift. But he's never said that. Well, he didn't say that in this. He did say that in his reply. We're going to look at his answer is just a boilerplate answer. If a jury finds that Tom had consent, then we might be in a different situation. So if Tom had consent and Ariana got it from his phone and sent it, is Tom responsible for those damages? So I don't know what his lawyers know. Exactly this. The foolish mortal in the chat said, EDB, I can't stream for 4 hours today. EDB, 4 hours and 8 minutes in. It's just happening. Because we had to go back through all of it. Like, there's no other way around it. We had to go back through all of it. So, Tom wants Ariana to pay. it goes on to say, Tom desires a judicial determination of the respective rights and duties of Tom and Ariana with respect to damages claimed by Rachel. In particular, Tom desires a declaration of the comparative liability of Tom and Ariana. So he wants the court to say, you're 10% responsible, you're 90% responsible. I don't know if we're going to get there, but this is going to be a whole separate litigation. So the comparative responsibility is if a jury comes back and says, hey, Rachel, you get $200,000 or whatever it is, sum of money. The comparative liability means that whatever percentage is determined, they pay that percentage. So who's what percent at fault on the comparative liability? That can also be determined by a jury. And we saw that in Depp v. Heard. So when you're looking at this, we're getting like deep into the world of civil, but comparative liability can be determined by a jury. He wants a judge to decide it. I want a jury to decide it. Can you imagine? Can you imagine going to a jury with this? Okay. He wants a declaration of Ariana's responsibility for comparative indemnity to Tom for any sums that Tom may be compelled to pay and for which Ariana is determined responsible entirely or in part. Such a declaration is necessary and appropriate at this time in order that Tom may ascertain his rights and duties with respect to, do you want to settle? With respect to Rachel's claims for damages. I wonder if Tom's thinking if the court will declare who's responsible, he can force settlement of the House lawsuit and of this lawsuit, because he can go to Rachel and try to say, look, I'm only 15% liable and I'm going to force the sale of the house and I'll pay you this amount and let me out of this. And you sue Ariana and get me out of here. I wonder if he's asking for declaratory relief early for that reason, to strategically try to get out of this. That's me speculating. That's me looking at this and looking at what we know and going, could this be? Because why the fuck do you choose to do this? Why the fuck do you choose to do this? This is, he had to know. He had to know. He had to know. He had to know the way this would be responded to. Okay, let's keep going. Just keep swimming. So he's saying it's necessary so that he can ascertain his rights and duties with respect to Rachel's claims for damages. Furthermore, the claims of Rachel and the claims of Tom arise out of the same transaction, and a determination of both in one proceeding is necessary and appropriate in order to avoid the multiplicity of actions. No, I think the cross-complaint's appropriate. Well, before I say that without an asterisk, I think the cross-complaint is legally appropriate in this lawsuit. Do I think that this is a bad idea? Yeah. But do I think it is legally appropriate in this lawsuit? Yes, this is where this belongs. These things should be decided together, not in separate lawsuits. So yes, this cross-complaint belongs in this lawsuit to be decided by one judge, and if it goes to jury, by one jury. How are these two going to film with each other? It's on pause for the summer. They'd normally be filming now. How do you film with each other after this? Like, where does everybody go from here? I don't know. Give Katie and Ariana their own show. Spin off Sheena and Lala into the Valley. And I don't know. Let Tom Schwartz figure out what he's going to do when he has to separate himself from Tom Sandoval. And then, let James Kennedy go DJ Coachella and follow him around. Give him a spinoff like Erica Jane got. Like, James Kennedy is like, from the beginning of Vanderpump Rules to now, he's like, look, I always wanted to do this. And now he's doing it. Like, give him a spinoff like Erica Jane got. Oh, my husband's working in the yard. Looking good, baby. He's looking at me like I'm taking my French drain trench very seriously. He's taking advantage of the weather being cooler. That's for sure. So, Tom wants the court to decide this. I think the court can to make declaratory relief that this is the appropriate place for the cross complaint. I don't know if they're going to determine the declaratory relief though on the liability, but we'll see. Prayer for relief, a judicial determination of comparative fault. I don't know if the court's going to do that. For a judicial determination of comparative fault of Ariana comparative fault of Tom and Ariana for the damages claimed by Rachel, if any are found to exist, for a declaration of the amount that Tom is obligated to, that Ariana is obligated to indemnify Tom if Tom is compelled to pay any sum of damages, judgment, or other awards recovered by Rachel. The reason I am trying to use their names is because when we start talking cross-defendant, cross-claimant, and plaintiff, it can get real confusing real fast. So I'm trying to unwind it because in law school, I would make charts and I would write names over it. So when we were dealing with cross complaints in a lot of parties, I would go in and have a highlighter color for each party. And then I would put names because in my brain, trying to sort out cross-defendant, cross-claimant, and plaintiff is wild. So I need the names. That's how I remember things. So Tom wants the judge to determine the amount that Ariana is obligated to indemnify him pay if he is responsible for any damages to Rachel. For a preliminary injunction, really? For a preliminary injunction and a permanent injunction enjoining Ariana and everyone else from continuing to publish the above described data. Really? Do you have any evidence that she's done that at all? Is there any evidence anywhere that she's done this, sir? For general damages. So he also wants damages from her. He also wants damages from her. Sure. For compensatory damages, you're going to sue her for your lawyer's fees? Oh, this is all her fault, really? Rachel, is Tom going with the shaggy defense? It wasn't me, but also Rachel wouldn't have known if Ariana hadn't sent it to her. So it's really all Ariana's fault. Is that what's happening here? Because if you hadn't recorded it, there's nothing not to. Just Raina said, hard not to name call. I think it's totally fair to say that the behavior is disgusting because there's no need to name call. With that, I think it's fair to say the behavior is gross. The behavior is gross. The behavior is not okay. Ariana's probably going to call him subhuman at some point. This is going to be worse. So he's continuing to sue for costs incurred. And what, legal fees? Not EDB objectifying Dr. B while reading a lawsuit about Revenge P. Look, Dr. B and I met at a time when we didn't even have cell phones. So, it makes it easy. And after 22 years, it's consensual. It's consensual catcalling. This is Matthew Garagos, brother of Rachel's lawyer, Mark Garagos. So it's interesting in all of this that Tom's attorney and Rachel's attorney are brothers. I don't know the nature of the relationship between the brothers and members. I know we had talked about me running into Mark Garagos while he was here in Nashville. The way I wish we had time to talk about this. But I need to move on because there are two things. One, we have statements by lawyers that I want to cover. And two, I want to go find the clip of Tom from the reunion. So give me one moment because I know where it is on Instagram and I might just have to go there. Give me 30 seconds. See if I can find the clip. We're going to do that later. Let's see. Not my video coming up as I'm searching to try to find this segment in the reunion. I do not easily see it. I'm just gonna go to Instagram and find it because I know exactly where it is on Instagram. So let's, I wish I hadn't opened up YouTube. There's other stuff happening today. All right, let's talk about the lawyer's statements to Law 360. Then we're going to pull it up. And then I think we need to look at something else. Joe, I saw that Chef Penny is suing them. I haven't pulled the lawsuit yet. I don't know if that just broke today. I didn't see it yesterday when I was prepping, but maybe we do need to do a food court. I'm going to have to start streaming more frequently so we don't do 4-hour live streams. I'm going to have to start doing 2-hour streams more consistently. We are so freaking busy. Hang tight, guys. I've got a little bit more time. Okay, hang tight. We've got other stuff going on too. Let's go to the lawyer statements. And then Miguelina, we're going to do that. So this is coming to us from Law 360 because Vanderpump Revenge Porn drama up as Sandoval sues. There's statements by the lawyers in here. Sandoval made allegations in the cross complaint filed in an ongoing... I should have swooped. I got distracted looking for the clip. Sandoval made the allegations in a cross complaint filed in an ongoing revenge porn lawsuit that Rachel brought against Tom and Ariana. According to the cross complaint, Ariana accessed the cell phone in early March and looked at videos, texts, and photos, including FaceTime of him and Rachel, with whom he'd been having an affair. Quote, Maddox made copies of the data and distributed the data to Rachel and third parties without authorization or consent. Let's see. There is Jordan Sussman of law firm who represents Ariana said in a statement Wednesday that Tom knows full well the privileges he and Ariana shared regarding each other's personal communication devices. If he, quote, if he or his mistress had their way, it would be illegal for someone to discover their spouse or significant other was having an affair, the attorney said. He stated Sandoval had gone from begging Ariana for forgiveness to blaming her for his wrongdoing, and that speaks for itself. Quote, even months after the New York Times branded Sandoval as the most hated man in America, he has clearly learned nothing. You know nothing, Jon Snow. He had clearly learned nothing and believes it is necessary to continue torturing Ariana in a vain effort to rehabilitate his image. Maddox is confident that a jury will see through his latest ploy and dismiss his frivolous claims. Counsel for Tom and Rachel did not immediately respond to comment. According to Rachel's suit, she was humiliated and villainized by Tom and Ariana and remains a shell of her former self. And we've gone through the rest of that today. So, Ariana's lawyers have responded and said that Tom has learned nothing and he believes it's necessary to continue torturing Ariana with this. Ariana and Rachel have been consistent in what they've said about this incident. Those recitations are conflicting, but they have been consistent. All right, we're going to go to what, let's see. Oh, actually, it'll be faster if I do it this way. We're going to go to, we're going to go to Instagram. We're going to go to a video of Tom, what Tom had to say at the reunion. And let's see if I can find this quickly. Because I think I know exactly where, it is. But I am not, yes. Okay, perfect. This, I need to, let's see. All right, we're going to copy the link. We're going to pull this up from Instagram. And we're going to test. Well, no, this is for commentary and it's part of a lawsuit. So, bravo, bravo, ducking, bravo. Don't make me reach out and say it's used for fair use, everybody. Emily, are you going to get demonetized for saying revenge porn? No, it's this. I think it is absolutely fair use. So this was posted by Face Reality over on Instagram, which is very helpful because I knew exactly where to find it because of that posting. So let me refresh this so we have the beginning of the post. This is Sandoval at the reunion of Vanderpump Rules talking about Rachel going after Ariana in his own words. So let's make sure we hear what Sandoval thought about this at the reunion loud and clear, shall we? Cute. It doesn't want to play? That's not helpful at all. We had this issue yesterday. Okay, it's playing, but we have no sound. Oh, we continue to have no sound. All right. Give me 30 seconds. Let me share this a different way and we will get there. So we learned yesterday what we needed to do to try to remedy the situation. It's the remedy. So let us try it one more time and see if we get our sound back. Nope, sure don't. Sure don't get our sound back. That's really frustrating. This has been an ongoing issue with StreamYard. So, Emily, what are we going to do? Play it from the phone into the microphone? That's exactly what we're going to do. So, Tom's own words. Let's see if we can do that and make it work.
Don't choke. Never done anything to her. Like, why?
That sounds good and loud. Megalina, remind me that I need to set up. I can Bluetooth my phone through the Rodecaster. I need to do that after this, if this is an ongoing problem. We're going to find all of the workarounds for this. So let us try to just
Don't choke. I don't care.
Adapt.
Never done anything to her. Like, why?
All right, hold on. Really? The second I hold it up to the screen, it ends? What magical powers does Bravo have?
To her. Like, why? I'm constantly being
brought back into this.
Yes.
It's one thing for her to come after me, but to come after Ariana, I'm questioning if she has a f***ing soul. Like, it's insane.
Well, she doesn't. Done anything to her. Like, why?
Tom says at the reunion that Rachel going after Ariana makes him question if Rachel even has a soul. I will also share this in my stories. Tom, does Rachel even have a soul? To be fair,
After Ariana, I'm questioning if she has a f***ing soul. Like, it's insane.
Don't choke. I don't care.
Katie's response.
Don't choke. I don't care. I don't know. Choke. I don't care.
Iconic. All right. So, Tom. It's a big about face. It's a big about face here to go from Rachel suing Ariana is akin to her not having a soul to you now seeking indemnity. We have definitely changed tune in the months following the reunion, haven't we? So there's that. But I will share those in my Instagram stories, and I'll put a link in the description to the video if you want to go check out all of those videos. I always appreciate the Bravo accounts like Face Reality that aggregate the key moments. Like, they are the Bravo, literally the Bravo historian accounts that make sure you know where to find what you find. And I always appreciate it because the way I would know that he said that and never be able to find it without going through 3 days of reunion, which we don't have time for because there is more happening in the world. So let me see. Okay. A lot of you mentioned in the chat briefly and I appreciate you. Let's shift topics real quick. So, Miguelina, we should probably let the app know for those that said, oh, she streams at 11 and then peaced out at the 4.5 hour mark, that we've got to talk about Karen Reed real quick because there is a new filing. So I appreciate you in the chat when you are like, hey girl, heads up, things are happening. I appreciate you. I also appreciate it when the mods are like, hey, can we stay on topic for here? Know that they see what's going on and they let me know. And when we have a day planned, I'm not going to break in the middle of the stories until we get to the end of the stories. So we are going to break this down based on what we've seen. I only see, let's see if it's any more. I see a 2-page filing. Let's see. From Ted Daniel. And we're going to go through that. So give me one moment to get, this isn't updating. That's so weird. Why isn't this updating? This is so strange. All right, but we're going to get exactly to that. Thank you for everybody who pointed it out. I appreciate you. Thank you to everybody who pointed it out earlier and were like, and the mods were like, we're staying on topic, and I appreciate you. Know that we will get to it if we can, when we can. We're going to get to this one quickly, and then I have got to go eat lunch because otherwise I'm not going to have time for the phone calls that I need to have after this today. So I appreciate you. You are the best, and we are going to cover this quickly because I only saw the one. Miguelina, if there's anything other than that one, let's see. Oh, there's two. Oh, there's two. Thank you, Miguelina. Mods, Miguelina, chat, you are the best. There are 2 motions in the Karen Reed case. Coming from Christina Rex on Twitter, a juror in the Karen Reed case has filed an affidavit with the court asking jurors' names remain private. The court has extended the order empowering names. The juror writes, I am in fear for my personal safety. The other one is a defense motion and a granting, it seems, of that motion. Do not fuck with jurors. Are you kidding me? I hate it so much. Okay. We are going to new filing updates in the Karen Reed case that were shared on social media during this live stream because a juror has filed a motion in the case and the defense has made another filing in the case. We are going to go to those directly from social media so we can break them down. This is a first look. I have not looked at them. The chat, thank you for letting us know that they were here. To the mods, thank you for letting us know that they were here and staying on topic until I got to it. I absolutely appreciate you. Here's where we're at with the Karen Reed case. It is Thursday, July 18th. This case is coming before the court on July 22nd, Monday. And right now it is set for a trial setting. That's what it was supposed to be. There was a mistrial, and this was supposed to be a trial setting date. But the defense has since filed a motion urging the court to allow for verdicts to be entered, or in the alternative, essentially dismiss counts 1 and 3 because the jury reached verdicts. The defense provided an affidavit for 2 jurors from Alan Jackson. Alan Jackson spoke to the jurors directly. There were affidavits filed by David Yannetti where the statements of 2 other jurors were relayed through multiple other parties. And with those statements being relayed by multiple other parties, we see a break between the 2. A lot of you are telling me that I am out of sync. This has been an ongoing issue with StreamYard when we play video, which is why I wasn't going to play video till the end of stream. And it's not the end of stream. If I refresh, do we think it will get better, Miguelino? It'll give the app a moment to get here, but if I refresh on my end, do you think it'll get better? I wonder if it will. So let me know your thoughts. I can always refresh me out of the stream and back and see if that helps. But this has been an issue. You can also refresh on your end, you guys, on YouTube, and see if that helps. And we will go from there. Let me try real quick to refresh myself, and it'll give everybody a chance to get in here from the app notification. So for all of you that are saying it's fine, great. For all of you who are saying it's not fine, I understand. Let's refresh it real quick and see if we get there. We've got a moment. YouTube has been having some issues, but StreamYard has also been having some issues. So try refreshing on your end while I refresh on my end. We're going to give you music for a second. I'll be right back. This will take me a moment. Hello, Law Nerds. All right. We're going to try this again. We're going to go take two. We're going to do a take two. We're going to do a take two on all of it. Hello. I'm really not trying to build suspense. I'm just trying to fix the tech that is fucking fighting with me. It's been so frustrating. So, so with all of that, let's take a quick refresher to the road so far to hopefully get us all back into where we're here. Thank you. So there are new filings in the Karen Reed case today. It's July 18th, 2024. Remember, there is a hearing in this case July 22nd, Monday. That hearing is supposed to be a trial setting because of the mistrial declared. After the mistrial was declared, Alan Jackson filed a motion and then supplementals stating that 2 jurors had reached out to him directly to say that they had reached verdicts on counts 1 and 3. Counts 1 and 3 did not have lesser includeds like count 2. Count 1 was the second-degree homicide. Count 2 was the hit and run causing death. The jury said that they couldn't decide the charges on count 2. That is the one that had the lesser includeds. So, Alan Jackson filed those, spoke to 2 jurors. David Yannetti filed a declaration that 2 jurors had spoken, but the information relayed to him came from intermediaries through someone speaking to him. So it was like friend of a friend conversation. And that took more of a minute, or was more, really is a less direct line of communication and more of a game of telephone. The Commonwealth responded. I broke that down. The Commonwealth responded and said, there's nothing the court can do. We're not violating Karen Reed's rights. We don't need to inquire into the jurors if they had reached verdicts. We don't need to do any of this. We can retry her on whatever we want to retry her on, and this is why. The defense filed what I thought was a very good reply to that and said, no, not only does justice and law demand that the court dismiss counts 1 and 3, but we should be allowed to inquire as of the jurors if they truly did reach verdicts and just didn't know. They couldn't fill out the verdict forms on counts 1 and 3 and really didn't know to ask. That's not justice. That's not right. And that's not what double jeopardy intended. It didn't intend that everyone does everything perfectly, and that's their argument. The nuance in the middle is that whether inquiring of the split or of the jurors of a verdict does that go into the improper grounds of asking about their deliberations? And the defense put some good case law in on point that said, this is not how they decided. This is not the nature of their deliberations. This is not the deliberative process. This is not the decision-making process. This is the result of that process. Did you reach a verdict on count 1? Yes or no? Did you reach a verdict on count 2? Yes or no? Did you read a verdict on count 3? Yes or no? And then what was that verdict? That's asking about results, not asking about the deliberative process. And that's the defense's argument. The prosecution is still arguing, I do what I want and we can retry it and it doesn't violate double jeopardy and it's all good. It doesn't matter what the jurors say now. They've been dismissed. It's done. So in that, when we first saw these motions, I said I wouldn't be surprised if additional jurors come forward now that one juror has spoken to Alan Jackson. And we have seen other jurors speak to the lawyers or to friends, and those friends disclosed it to the lawyers. So, because things are going to continue to move quickly ahead of a hearing on Monday, we now have 2 new filings that we are going to get to. One of them from the defense, one of them from a juror, directly to the court. I like that the best. The jurors going directly to the court and being like, how do we resolve this? So let us, no. So I apologize. I misspoke. This is why I don't cover breaking news. The motion from the juror, apologies. A motion from a juror and a ruling from the court on that motion from the juror. No, nothing from the defense. That's my understanding. And if it changes when I read it, we'll pick it up in post. It'll be way better on Quick Bits tomorrow, you guys, I promise. Real time, real time, real time, real time, real time, real time. Woof. So we're going to the Twitters to get into the affidavit of a juror to talk about what's going on. So I bumped it earlier. I'm going to bump it again. We got to do this one more time just because I never get to use this bumper anymore. And I love it. We have a new filing. Was I hoping that I would get my screen share up fast enough to do it dramatically? Yes, I was. Did I? No, I didn't. Is it okay? Yeah, it's all going to be fine. We're professionals. Streaming is dynamic. So, for all of you that got the app notification and came back to the stream, thank you. I appreciate you. This is why we have app notifications, because I know sometimes you're like, I'll catch up on Sandoval later, and then other shit happens and you want to know about it. Exactly. That's why we built the app. That's why we have been trying to make the app the best it can be. That is why we are working on the app, and that is why we wanted you to know, because I'm not going to stop a stream and start a new stream when there's breaking information that we are going to cover. That is why we have the app. Like, this is the moment. This is the moment, folks. And our tech app development team rolled out new updates yesterday to help that delivery process, and it's going to continue to get better. So for all of you that have helped us break the app so we can make it better, thank you. Sometimes you can't rebuild a thing until it's broken. We're like phoenixes, y'all, or butterflies. They literally digest themselves. We got to break it before we build something better. So thank you for helping me break shit and just disrupt it all so we can build something better. This is from today, Affidavit of Juror Doe. Now comes Juror Doe, a pseudonym, who on oath deposes and says as follow. I am of legal age and have personal knowledge of the facts set forth herein. I was a member of the jury that was seated in the recently concluded trial in the above captioned case. I just retained counsel to represent me. Okay. I have read the impounded order entered by the court. Remember, when Massachusetts talks about impoundment, they are talking about sealing. Like, not above you, but like sealing the case. So when they say impoundment, they mean sealed. I have read the impoundment order entered by the judge, Cannone, on July 8th, which found that, quote, good cause exists to impound the list identifying the names of impaneled jurors at this time in the trial of this case. As I read the court's order, it is scheduled to expire on July 18th, today, unless it is extended by the court. I submit this affidavit in support of my request to extend the impoundment order entered on July 8th. So a juror is asking to keep the names sealed. Let's continue on. I am asking that the impoundment order be extended indefinitely because I am in fear for my personal safety and the personal safety of my family if the names of the jury are made public. I hate that for this juror. I hate that for this juror. I hate that if the jurors feel this way. And sadly, it doesn't surprise me. I hate it though. I have read the impoundment order and noted on the very I've read the impoundment order and noted on the very first page that individuals associated with this case have been charged criminally with intimidation. I am frightened for my personal safety as a result of learning that someone associated with this case has been criminally charged with intimidation. That goes to the witness intimidation, not to anything else. Let's keep reading. I also recall testimony from at least one witness who described being harassed by individuals and her family being harassed because of their involvement in the case. There was testimony from a few witnesses like that. I do not know the specifics of any such harassment. I think it's admirable. This is a note from me. I think it's admirable that this juror has not gone seeking out that information. I think that's incredibly admirable. I do not know any of the specifics of such harassment, but I fear that my family and I will not only be harassed if the names of the jurors are made public, but that our personal safety will be seriously compromised. During jury deliberations, we could hear protesters outside screaming and yelling. During our jury service, members of the jury would meet. The deep breaths are me mitigating my own anger. During the jury service, the members of the jury would meet at what was supposed to be a secret location to be transported to and from the courthouse by bus. After being discharged from jury service on July 1st, we were taken by bus back to what was supposed to have been a secret location where we observed what appeared to be members of the media, including photographers. No. What case was it that the jury bus was followed by media? I don't remember what case it was, but there was a case sometime in the last 5 years where the jury bus was followed by media. No, leave it alone. Was it Murdaugh? Was it Rittenhouse? It might have been Rittenhouse. Murdaugh, I don't think the jurors had a bus. It might have been, I think it was, it might have been both, but I don't think the Murdaugh jurors had a bus. Leave the jury alone. And they had a zone to extend so the jury wasn't influenced by people yelling and screaming. The jury that's been left the most alone is the Depp v. Heard jury. So for all of the stuff on the internet that happened during that case, the jurors have never come forward and said that there were any problems at all. It can happen. During jury deliberations, we could hear protesters outside screaming and yelling. During our jury service, the members of the jury would meet. Okay, I'm rereading. I apologize. We observed what appeared to be members of the media, including photographers. I was so much in fear on my way home that I pulled over to the side of the road to see if I was being followed. Thankfully, I was not being followed, but that was and remains my mindset. If juror names are made public, we will be constantly threatened and harassed, and there will likely be a physical confrontation at some point. What are they not saying? I'm going to keep reading. What have they seen or what are they not saying? Because they are worried, and I worry for them that they are this worried. Since being discharged from jury service on July 1st, I have read multiple news articles about the case and the attention that this case garnered across Massachusetts, New England, and the country. And they are allowed to. There are clearly people who have very strong opinions about the case and about the jurors who deliberated over many days. I have seen articles, comments to articles, and postings about the verdict saying some very nasty and dangerous things. I have not seen that, but also we rolled right into Baldwin, so I was not engaging in reading any of the media on that case. I hate that. Some individuals have expressed outrage and anger that the jury did not acquit the defendant. Some individuals have expressed outrage and anger that the jury did not find the defendant guilty. Just yesterday, I read an article in the Boston Globe with the headline, Karen Reed case ended in mistrial, but the diehards haven't given up. See Exhibit 1. In approximately the 12th paragraph of the article, an administrator of the Karen Reed Focus Facebook group was quoted as saying, the people who were on the fringe of being interested in it are now engulfed. The anger level was at a 9 before, and now it's at an 11.5. The article characterized this increase as a rising rage. I can see why they're worried. Because given everything sitting here on July 18th, I can understand why people are concerned that internet vitriol can become dangerous. I can understand why people are concerned. And chat, I am not going to attribute that concern to any side pro or against Karen Reed. Unless they say it, I'm not going to. So I'm not going to speculate about that. They are concerned. And I wonder if they are concerned about both those that think she should have been acquitted and those that think she should have been convicted. Because if you were a juror, wouldn't you be concerned about both sides? Wouldn't you be concerned about both sides? And wouldn't you be concerned about both sides? So we're not going to speculate. I think they have, based on what they're reading, I think they have reasons to be concerned about both sides. So later in this July 15th Boston Globe article, another individual interviewed by the reporter said, people are insane about this case. If they don't agree with you, they'll try to dox you. I understand the term dox to mean that an individual will publicize someone's personal information. That's exactly what that means, including someone's residential address, occupation, business address, etc. Yes. Publicizing my personal information in this context exposes me and my family to unwanted, likely surprise encounters with strangers who likely will have an axe to grind with any juror. I think that's reasonable. Do you agree? I think that is a reasonable concern. The internet can be fucking wild. It shouldn't be. People shouldn't go real life with people. That should just, there should be no fly zones on that. But opinions are one thing. Trying to go real life and confront people is a completely different matter. I have seen social media posts that were very demeaning of and attacking the integrity of the trial judge. If someone is going to attack a sitting judge, I see no reason why they would not demean and attack verbally and physically a juror who sat on the jury. I understand their concern. And I'm going to finish and then I'll say what I have to say. No, I'm going to say what I have to say. And then I'll finish. When we talk in this chat, and I know I sound mad. I'm not mad at chat ever. I'm mad about this. This actually pisses me off. I've had a jury ask the judge, we are afraid for our safety. Can we please be escorted out of the building and escorted by sheriffs? And it hurts my heart because that's not how it should be. Because jurors do a civic duty. So I am mad. But when our chat has rules like no name calling, no attacking the judge, we're going to talk about the judge's rulings. We're going to talk about both sides. We're not going to name call people involved. We're not going to follow the fuckery around the internet that is unfounded. We're not going to speculate. We're not going to demean. We're not going to to do all these things. When we talk about that into the chat and I say people are watching, it's because people are watching. We can shift that, right? We can show that we can disagree with someone and that we can disagree with like a Tom Sandoval and not name call him, but call out his behavior. We can say this behavior is deplorable and leave it there. And when you focus on the behavior and the words and not the people, it dials down the temperature a notch. And that is why in this chat and on this channel, you will not see me do that. You will not see our chat do that, because these jurors are watching afterwards and seeing people attack the judge, and it is making them concerned for their own safety. And that is completely fucked. It's unacceptable and it's fuckery. And when we talk about that, this is why you do not know who's watching. It's okay to dislike people's behavior. It's okay to dislike people. It's okay to dislike how they're moving. But we can hold those opinions and not spit them out onto the internet in a way that can cause harm. Because you don't know who's watching. Family members of jurors watch. Family members of witnesses watch. Witnesses watch after. Better not be during. People rewatch what is said, and people that are brought into court under subpoena oftentimes don't want to be there. So you're like, I didn't even sign up for this. I'm getting dragged into this, and now I'm getting dragged by the internet. Great. And I have had people reach out to me who I have covered, whose family members I've covered, and I have never had them reach out and say that what happened in the chat was hard for them to watch. It has always been the opposite. People have reached out and said that they appreciated the kindness, the respectfulness, and even if people don't agree with my assessment of a situation, agreed that we were addressing and respected that we were addressing the situation and the actions and the legal filings and not the people involved. And that is what we have always done, and that is what we will continue to do. And this is why, in real time as much as Friday. Because on Friday, we redirected very quickly when the chat was just like, oh my God, is there going to be a plea? And I'm like, we need to hold on for one more day. We need to hold on and breathe, because it's uncomfortable to not know what's happening, but we don't know what's happening, and we're not going to guess at what's happening until we know what's happening. And we waited, and you know what happened? The hearing on Friday continued, and Erlinda walked off the case. That's what was happening at lunch, not a plea deal. So I wanted to take a moment to say why we have the rules and the mods that we do, why I appreciate you, and what sets these corners of the internet that still ask for people to be treated like people so special. It's what is so special about it. So we are going to go back to read the rest of this, but I wanted to interject before we got any further on because I needed to tell you how deeply and incredibly grateful I am for you for also, even when it's hard, being willing to say we will find a way to have conversations about things we disagree with without attacking people. You can disagree vehemently with people and attack the position that they've taken, why they are wrong, why they are mistaken, without attacking them. But it takes a bit of energy to do so, and it takes a little bit of awareness to do so. And too often people will, not this chat, too often people and our media will run to the bottom. And we are not going to do that. We will talk about behaviors. We are not going to run to the bottom to dehumanize people. We're not doing that. And that is why the law nerds are the best, and I appreciate you. Let's get back to this article where a juror is very clearly indicating why we do things the way we do things, because this juror is concerned because they saw people attacking the judge. They heard the media talk about a rising rage, and it caused them to be afraid. And I can't say that is an unfounded fear. It's not an unfounded fear. This is a real fear. And the way I'm fucking infuriated by it, that sitting jurors have to go for this. I'm so angry, because you know what this is going to do? Stuff like this is going to make people who are paying attention, who are thoughtful, kind humans say, I am never sitting on a jury, because it's not worth my family's safety. It's not worth me. And we need good, reasonable people to sit on juries. It's how we set our boundaries in this legal society. This is how we set our boundaries. Because sometimes jurors look at a case and go, no, we're not convicting. We're not granting money. We're not doing it. We have a jury system where members of the community decide when reasonable doubt has been proven in the criminal context. And we need people to do that. That's how it works. And you want, if it is your family member sitting there, if it's you sitting there, you want a jury that isn't afraid to listen to the facts and sometimes make very hard decisions. And when stuff like this happens, how much harder does it get for jurors to do that? In a moment in time when it feels like the temperature is rising on everything, what we need is our criminal justice system to function properly. God, this makes me so mad. Okay. I appreciate you. So thank you. How mad I am about this reminds me of the deep gratitude I have for all of you for being on this adventure with me and showing that I don't talk about this often, but I'm going to talk about it now, and then we're going to get back to this. We were number one channel for trial coverage on YouTube every single day of this trial. And the Murdaugh trial. And the Paltrow trial. And the Baldwin trial. This is the number one place to watch trials. And this chat is why. We have changed things. Not media companies, not companies that get bought by other companies for tens and tens of millions of dollars. Us. We have made a change. We have decided that we're going to do something different. Oh no, I wasn't always number one in Deputy Heard. I can't claim that. But since then, we have been. The most concurrent live viewers on any channel every single day for trial coverage. Every single day. For all of the cases I have covered live since Dep Heard. Because y'all are with me to do it differently. And that makes a difference. And you make a difference. And this is why we do things the way that we do things. Because it's like I've worked in the criminal justice system and we know how jurors feel. People should not be afraid to do their civic duty. Oh, I am so mad. Also, I'm sorry. A brief apology to the chat. My husband is putting stakes into the ground outside. Brian, we're having a moment. We're having a Lawnard moment. Leave people in cases alone. Leave people in cases alone. Leave people in cases alone. Dr. Kari got run off the internet. She talked about it on Lex Friedman's podcast. When are you going to get experts that want to be involved in cases that matter if they get run off the internet with harassment? You can't harass people this way. You can talk about it. You can disagree with them, but you cannot harass people. And we don't. And I appreciate you. We're not done. We're not done. I'm so mad. The juror continues to say, I have seen social media posts that were very demeaning of and attacking the integrity of the judge. If someone is going to attack a sitting judge, I see no reason why they would not demean and attack verbally and physically a juror who sat on this jury. They're not wrong in their fear. I'm outraged that they have to have this fear. Because they didn't choose it. When people are on jury duty, they don't choose it. They are summoned with criminal repercussions if they don't do their civic duty. They are summoned. They didn't choose to spend 9-10 weeks of their life on jury duty in a tiny ass hot courtroom to have people turn around and have vitriol for them. He goes on to say, I understand that there are individuals who are upset that an impoundment order was entered and that they are actively seeking the identity of all the jurors. What? No. For example, my attorneys have made me aware of a video posted by a blogger/journalist who I understand to be a person who has been charged with witness intimidation related to this case, speaking about the trial and the jury's inability to reach a unanimous verdict on all counts after the trial. In the video, the blogger initially states that he has identified the jury foreperson in this case. What? Not only, how does this keep getting fucking worse? Not only does the blogger state that he has identified the jury foreperson, but also where this person lives and what they do for a living. And then they linked it. I'm not hitting the link on that. We'll talk about it. We'll talk about it another day. I'm not hitting the link on that. In this same video, the blogger demands to know the identity of the expletive idiot on this jury who did not vote in his preferred manner. And further that, whoever did that subverted justice like they helped cover up for a murder. As far as I'm concerned, fuck them. That's what I think, and a link to the video. The individual states in another video posted to Twitter, who outed the Cessna juror? Remember that? The one woman who hung the Michael Cessna trial, footnote 1. The jury lists are public, so I got the jury list and I went down the list and I found the juror who hung the jury. And I shamed her, as I should, because it's shameful. What? I understand that the above mentioned individual has been accused of harassing witnesses to the case, including by organizing crowds of people to harass them outside their homes. And I am aware that he has made statements in a blog from 2023 to the effect of, what in the fuck is this? Oh, let me see where the next page is. Probably in a separate post. Let's see. I do not have the next post. Hold on, let me see if it's on my phone. Give me one moment. I didn't know there was a part 2 to this. This is real when it's real time. Emily, what's it like when it's real time? It's like this. That's good. I probably need a breath. It's just, we probably need a breath. Let's see. And chat, no, you can't post. I know you want to help and post links. It just, the Google will not allow. And so I appreciate you. I am going to try to find the next part of this post. Okay, cool. We found it. Oh, there's more. Because there's more. Okay, because there's more. All right. Give me a moment. I need the link to this post. And we will get there in just a second, chat, to get to the rest of this, affidavit. So the last page we were on said, let's see. The last page of this said, I understand that the above mentioned blogger has been accused of harassing witnesses in this case, including by organizing crowds of people to harass them outside their homes. And I am aware that he has made statements in a blog from 2023 to the effect of, that's where we were, quote, murderers and those who cover for them do not deserve to live a comfortable life, while Karen Reed suffers and fights for justice for John O'Keefe. See Exhibit 2, so there's an attached exhibit. If, as he has stated, this blogger believes that members of the jury on which I served, quote, helped cover up for a murderer, and he further believes that, quote, those who cover for murderers are legitimate targets of harassment, I fully expect that members of the jury will be subjected to efforts to harass and shame them with the very real probability of some physical confrontation, confrontation will inevitably occur. My concerns are not limited to a particular blogger or to a particular, quote, side of this case. I am aware that there are outspoken bloggers, commentators, and groups of people who wished for a guilty verdict on some or all of the charges against defendant. I am aware that there have been physical confrontations between the two sides of supporters. An example of this is from two recent postings by an individual who appears to be a reporter from New Bedford. In today's post, she stated that she was in court today defending against a harassment charge against her and her pursuit of a counter-harassment charge. Yesterday, this reporter posted about, quote, getting protection from another blogger, see Exhibit 4. While I do not know the facts concerning these court appearances, it is very evident that individuals on all sides of this case have acted irrationally and aggressively over the past few years, which has caused multiple court appearances by parties seeking protection of the courts from other individuals. In light of the mistrial, notice this doesn't say anything about a verdict. In light of the mistrial, there is no end in sight to this irrational behavior, which clearly continues today. Jurors will undoubtedly be the subject to harassment and likely physical confrontations if their names are made public. Let's get to the next page. It goes on to say, my affidavit and motions should not be interpreted as indicating how I or any other juror voted in this case. Well, that is clear as day. Or how I or any other juror felt about this case. Every member of the jury, regardless of how they voted, is likely to face backlash from a segment of the large portion of the public who intensely followed this case. I wish to remain anonymous, and I bring this motion on behalf of myself and any other juror who does not wish to be identified, regardless of whether or not we agreed during our deliberations. The jurors can choose to make themselves known. The court sealing the juror identities is, I think, appropriate. It was an honor to serve on the jury. It was also a significant sacrifice of time, which I understood and anticipated when I was selected. What I did not anticipate, however, Emily, you should have kept reading. The soliloquy was needed. I was really mad. What I did not anticipate, however, was the likelihood that I and other members of the jury would become targets of intense public scrutiny and likely harassment campaigns strictly due to the outcome of our private deliberations. If jury names are made public, I will be subject to nonstop requests for comment about jury deliberations. I would prefer not to have to respond to those inquiries. However, what I fear is not only will I be subject to requests for interviews, but that I will be targeted and harassed because of what I did or did not do on the jury. I fear that verbal harassment will likely lead to physical confrontation and physical harm. I am not prepared or equipped to anticipate and prepare for any surprise personal attack. More importantly, I fear that I will not be able to protect myself and my family, signed under penalty of perjury the 16th day of July. That's awful. Absolutely awful that the juror has to sign that. Their attorney sent it to all of the parties. So let's go to the judge's ruling, because the judge did exactly this and impounded the juror identities. So let us go to the judge's ruling real quick. This is not how this should be for these jurors. If the wording looks fuzzy on the screen, I apologize. These are being pulled directly from Twitter, so they are a little bit fuzzy. I apologize. That juror hired an attorney, and for those of you that are popping in, because we've now been streaming for 5 hours, for those of you that are popping in, the juror hired an attorney because the list was set to become public today. So the court impounded it for 10 days. Findings in order on Juror Doe's emergency motion to extend July 8th, 2024 impoundment order. This motion came before the court on the emergency motion of Juror Doe to extend the July 8th impoundment order entered by this court. Upon review of the motion and supporting documents, including the affidavit of the juror, the court makes the following finding in order. This case has garnered significant and divisive attention in Massachusetts and across the nation. Individuals associated with this case have been charged with intimidation, which charges remain pending. Juror Doe submitted a detailed affidavit, which I find to be credible. Juror Doe is in reasonable fear for their safety and the safety of their family if the list of jurors is made available to the public. Throughout their affidavit, the juror has established that publication of the list identifying the names of impaneled jurors will present a real and present risk of personal harm to the jurors and the integrity of their service. The judge goes on to say, through their affidavit, Juror Doe established that there is a continued risk of immediate and irreparable injury should the jury list be made available to the public at this time. Through their affidavit, Juror Doe has established good cause to extend the impoundment order dated July 8th, 2024, until and unless otherwise ordered by the court. So the judge is sealing this indefinitely. So the judge is sealing this until otherwise ordered. So that is a indefinite sealing at this point, or a permanent sealing at this point. This order shall not preclude any juror from identifying him or herself or from speaking to the public about his or her service. Good. Let the jurors choose. Let the jurors choose if they want to come forward. So the initial impoundment order was for 10 days. This impoundment order is indefinite until the court rules otherwise. And I think there is good cause. And I think that if jurors choose to come forward, they can. And if they don't, they shouldn't have to. This does not, just so we're clear, this does not in any way impede the lawyers in the motions that they are seeking. There are other avenues for the lawyers and court process to happen. This is from the public. So, Cherry Sour asks, is this to some jurors? This is to all jurors. So the judge's order is an indefinite impoundment or sealing of the jurors' identities from the public for all the jurors. But it does not prevent the jurors from choosing to come forward. So the jurors can, if they wish, speak to the media, speak to their friends, write a book, do whatever, but at their choice. So the jurors will not be identified, their list will not be disclosed, and they can choose to stay anonymous or not. It should be the choice. It should be the choice of the jurors. I agree. I do not have I see a lot of you asking, why would you ever release it? And Adam, I appreciate that. Adam Goals asks, why? I do not have the full bandwidth today to go into the potential rights of the public to have access to public trials because I am so focused on this. I cannot wrap my brain around it because there are and can be competing interests there. But I am so frustrated by everything that we have seen today. So frustrated. I am so frustrated by this. Absolutely unbelievable. Absolutely unbelievable fuckery. Okay. Let's see. There is another filing. Hold on. But wait, there's more, chat. Since we're here, there is more. So, but wait, there's more. And Miguelina's like, they were connected. Miguelina, the issue is I was not logged in on the computer because we changed our whole tech setup. So it's only pulling up the thing I have the link to. So it is, I got it on my phone, so that's not a problem. All right, but wait, there's more. So give me 1 second. We've got another new filing. This was posted less than an hour ago. Well, this was posted while we were talking about this. So the defense has a new filing as well with another juror. Give me 1 second. We're going to pull it up and then we're going to do a new filing. And then at some point we're going to have to wrap for the day. I need to text Dr. B real quick because we had plans. Give me 30 seconds. All right. We were the way I was supposed to be long done, and I'm gonna have to push calls till tomorrow. You guys, it's gonna be fine. The streaming comes first. Because I need to know. Don't you need to know? I need to know. Like, I need to know. 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 Come on, babe. I need to know. You need to know. We need to know. We need to know what's happening. We're going to have to change the thumbnail for this stream. We're going to have to change the title for this stream. So sorry, Tom. Your face is not going to remain in the thumbnail of this stream for very long. Goodbye, Tom. Ariana, yes. Goodbye, Tom. We have to know. So there is another new filing. Well, we're definitely getting into this. This is coming from Ted Daniel on Twitter an hour ago. It's 4:29 Central Time. So this was filed, it looks like at 2:40 something today from the defense. So the defense has filed another motion at 2:44. Oh, it might have been 12:44 Eastern time. So this afternoon, let's see. Defendant Karen Reed's second supplemental memorandum in support of her motion to dismiss. Now comes the defendant Karen Reed by and through counsel. As reflected in the attached affidavit, we're going to go there next. A fifth deliberating juror, Juror E, has confirmed that the jury was unanimous on 1 and 3 and that Karen Reed was not guilty on those charges. Alan Jackson's second supplemental affidavit. Based on the attached affidavit and all the reasons set forth in the opening motion, the first supplemental memorandum and the reply, the defense respectfully renews its contention that the jury acquit Karen Reed on counts 1 and 3, and alternatively, there was no manifest necessity for a mistrial on those counts. Therefore, double jeopardy protections attach, and those counts cannot be retried. If the court would prefer to rule on the basis of affidavits executed directly by jurors, the defense respectfully requests permission to initiate contact with jurors A, D, and E for the sole purpose of asking them to affirm the accuracy of the 3 affidavits of Alan Jackson. Let's go to Alan Jackson's affidavit. So we now have 3 jurors that have come forward directly, 2 whose information has been retold indirectly. 5 total. Second supplemental affidavit by Alan Jackson. Hold on. Yes. Sorry. Family. My family is like, we are supposed to be done. Second supplemental affidavit by Alan Jackson in support of Karen Reed's motion to dismiss. He's Alan Jackson. On this case, pro hoc vitae, yay. On Wednesday, July 17th, I was contacted by Juror E. Yesterday, based on my conversation with Juror E and that juror's physical description of themselves, where they were seated, name and occupation, I was able to positively identify Juror E as a seated deliberating juror in the trial of this matter. Juror E stated that they decided to contact me to provide information about the results of the jury's decision-making following deliberations. Juror E explained that the jury was unanimous on 1 and 3, that Karen Reed was not guilty on those charges. Juror E went on to state that the only count on which the jury was deadlocked was in relation to the lower charges on count 2, which makes sense given the case we saw. Like that, it logically makes sense. This isn't such a result that I'm sitting here going, none of this makes sense. This makes perfect sense. With everything we saw, this makes sense. Juror E went on to state the only count they were deadlocked on was the lower charges of count 2. I took that to mean the lesser included offenses associated with count 2, which were confusing, but those were the chain of events counts. Juror E indicated that they were happy to provide such information but wished to remain publicly anonymous. The foregoing is true and correct. Monday is going to be wild. So let's try to summarize where we're at. Because today has been a lot. Holy new filings, law nerds. There were 3 things we went over in the Karen Reed case unexpectedly this afternoon. First, a juror came forth with an affidavit because the court had sealed, in Massachusetts they call it impounded, but in my mind that just goes to vehicles, so sealed the jury list from July 8th to July 18th. July 18th is today. The juror, through their attorney, filed an affidavit stating that they are concerned for their own safety if the jury list were to become public on July 18th today. The juror indicated that that fear stems from articles they've seen in the media, videos they've seen posted on X, and statements they've seen of people maligning the judge, making strong and vitriolic statements about the jurors, about their deliberations, and they made clear that they have concerns for both those that think Karen Reed should be acquitted and those that think Karen Reed should be convicted, and that they were making no statement about any one side of the issue, but that they were afraid for their own safety, their family's safety, that they would be harassed, that they would be doxxed, that they would be confronted publicly for those who have very strong opinions on either side of this case, and that if their names become public, that they will not be able to adequately protect themselves or their families. And they cited quite a lot of examples. The court granted, it wasn't really a motion, it was an affidavit. The court considered that affidavit in granting a new impoundment sealing order and sealed the jury list indefinitely, saying that Until further order of the court, the jury list remains private and sealed. But that ruling makes clear that jurors are allowed to speak about the case and jurors are allowed to identify themselves to the media or whoever they wish. But it gives the choice to the jury, not to the public. They cited concern that people connected with the case had been charged with intimidation. They said that they were concerned that witnesses that testified in the case testified that they had been harassed, and the concern for seeing not only the media saying that there is rising rage in this case, but also that people were attacking a sitting judge made them feel vulnerable to also being attacked verbally and perhaps physically, or that a verbal confrontation leads to a physical confrontation. And the court found that that was credible and that those fears are founded. Then the defense filed a motion today with a fifth juror that has come forward, Juror E. This is the third juror that has spoken to Alan Jackson. And this juror confirmed that the jury had reached verdicts on counts 1 and counts 3. And that they were undecided as to the lesser included counts on count 2. Remember, those lesser included counts on count 2 include the chain of events counts. Did Karen Reed start the chain of events that led to the death of John O'Keefe? So it's understandable that when they're hung as to those lesser includeds don't necessarily say, did Karen Reed hit him with a car? Did she leave him there? There's a lot of room in those lesser included instructions for multiple possibilities, and the attorneys didn't address them in closing at all. They addressed other things. But it's clear in these affidavits from Alan Jackson that 3 jurors have reached out to him and said, no, we reached verdicts on counts 1 and 3. The court's back in court for a trial setting date on Monday, and the defense is going to continue to argue. The defense is going to continue to argue that the court must dismiss counts 1 and 3, that Karen Reed cannot be retried on those counts because the jury reached verdicts. And he offered in this filing that if the court wants to do that by affidavit, allow the jurors to submit affidavits instead of being questioned. So, with all of that, we have had a wild stream today. I am going to answer some questions, and then we are going to go. Mama Wolf said, you did not do another 4-hour stream. Fair. We're now at 5.5 hours. I'm going to answer a few questions, and then we're going to have to bounce because it has been a long, long, long day. Miguelina, after I stop stream, I'm going to answer some questions. So with that, I'm going to answer a few questions, and that I'll just record that afterwards because it's been a long one, and I am tired and hungry. Emily said, are we in court on Monday if it is streamed? Which it should be. Then we are in court. I do not know what time yet. I will let you know what time in the app. So just a reminder. Thank you for supporting me. One of the best ways you can support me is downloading our free app. Thank you. So yes, we will be in court Monday. That is my intention, which means I have to shuffle around my schedule for recording the podcast, but that's going to be fine. Are we going to probably talk about this more on the podcast? Yeah, probably. Can we watch Black Swan trial gavel to gavel? If that's going on now, no. I don't know when that's happening. I don't know that trial. But we are going to take a minute before we get to more gavel to gavel coverage because we have so much we need to cover. And it looks like Girardi might be going to trial. So I've got a lot of calendar things I need to take a look at. So we've got some stuff, and we've got a lot of stuff. Her chess pieces fell all at once. Checkmate. I'm not even sure what case that was referring to at this point, Colleen, but thank you. LJ Peach. Oh, I didn't do our fact around and find out. Can you tell my brain has stopped? LJ Peach said the crime scene tech and the officer both said she knew and approved putting the ammo under a different case file. I don't remember the crime scene tech saying it as specifically as that, but I remember the crime scene tech saying that it was decided. Yeah. Bella Brat said, so the poor jurors were dismissed. Once they were dismissed the case, did they just get on the phone and say to them, your services are no longer needed? And then the jury has to see all this on TV or YouTube. Wow. In the Baldwin case, yes, juror services would have called and said the case is resolved and your services are no longer needed. And probably that's it. And you're no longer bound by jury service. You're welcome to do what you will. Alex had questioned if she dismissed the case before the hearing, would she have ended up on the Brady list? The Brady violation was there whether or not there was a hearing. So Alex, possibly. And we'll talk about that. We can talk about that further later. I saw in the members only chat last night that Erlinda was added to that list. I think she will probably be able to be removed from that. I don't think she should have been. Nicole said, did you see Alan Jackson on the new season of Homicide talking about prosecuting Phil Spector? No, I haven't. Also, love you. I'm going to law school because of you. I hope it is an amazing experience. I have not watched TV since before the Karen retrial. I am so behind on Housewives, on everything. I haven't watched a lot of YouTube videos. It has been so busy doing this. So no, I haven't, but I will catch up. There's a lot that I'm not caught up on. Shara said, love EDB's document game. Thank you. We had to change the way that we stream like last night because of issues with StreamYard. So LG Peach said no, because you don't disassemble a firearm to where the sear and trigger assembly are located. LJ Peach, I get that. That's totally fair. As to the Baldwin case, if it was misfiring and not working properly, then that is the responsibility of Hannah, was my point to that. Stephen, good to see you. Morrissey thought these would be career advancing wins and ego took over, but actually torpedoed it along with public trust. Oh, the torpedoing goes back to your comment about competitiveness instead of what's right. Yes, it's hard when you're a competitive person to do what's right, but you have to be able to do what's right. We're adults. Two things can be true at once and we can check ourselves. Music to My Soul said even Spyro told Kari she didn't need to testify. Everybody did. Everybody told her not to testify. Colleen, thank you for the gift of memberships. Shazam, thank you for the gift of memberships. You know what, chat? We are 5.5 hours in. I need to gift some memberships. Y'all have been, why won't it let me gift memberships? Hold on. Am I logged in under the wrong YouTube account? What is going on? Why won't it let me gift? It's my channel. What is going on? I do what I want. Let me gift the memberships. Let me gift them, damn it. But you guys have been riding all day, so it is time for some gifted memberships. So those are coming into the chat. I'm going to answer a few more questions and then I'm going to have to eat. JT says, I feel attorney motivation comes from two places. Those whose brains work in terms of rules, guidelines, order. Tell me you're neurospicy without telling me you're neurospicy. And those whose brains works in terms of competition and winning. It's okay to be number one or both, but not only number two. And the thing is, with number two, there are still avenues of law in civil, in in-house counsel and stuff, where the duties are not the same as a prosecutor. Like the winning in civil is a whole different thing. The fight at all cost is a whole different thing. Yes, there are ethical rules, duties, and guidelines, but they are not that of what they are for the prosecutor. Not the same at all. So there's room, but not in that. Annie said if this case had been dismissed by the prosecution when Erlinda suggested, would it have been with or without prejudice? It would have been with prejudice. It would not have been allowed to be retried. One Vinted Watch said at 1:46 p.m. 3 hours ago, I missed the entire stream. Oh, no, you haven't. I was making chocolate chip brownies. I want some. Hope everyone's doing well. You only missed the introduction. I should also say now that we are almost 6 hours in, because I have no chill, like the stream, subscribe to the channel. I appreciate you. Do the YouTube-y things. Thank you. Thank you. And thank you. Loch Nessie said, I want to understand, how can he claim without authorization, Tom Sandoval, When it was said on camera, they have each other's passcodes. Isn't that authorization? Ding, ding. P.S. Did you see Chef Penny filed a lawsuit against Ariana today? Only in the chat because we prepped for stream today and then we streamed. Dana said, I worked with convicted YSOs in juvenile institutions. This has become more and more relevant in charges incarceration. Thank you for covering this. EDB consent is everything. This is something that was, even when I worked in juvenile, this was something that was becoming a known problem. And I would go into talks at high schools about this. This was before my kids were in high school. The thing that was staggering to me is the amount of young students that would come up to me and share that a friend or a partner had shared images of them without their consent. It is a large problem. So when I say talk to your kids about this, probably 5th grade and up. Talking to kids about consent starts, for us, it started very early. Like, hey, do you want to give someone a hug? You don't have to. Do you want to give a fist bump instead? Teaching kids that they have authority and agency over themselves is the way you start having those conversations. But then talking to your kids about, hey, it's okay to set a boundary if you don't like the way that person's talking to you. Hey, it's not okay if people do that to you. Hey, it's not okay if this happens. So those conversations can grow by the time they're in junior high and high school. And you need to have the conversations really like 5th grade about photos, about social media, about things not really being gone when they're gone, about agency, about nudity, and about sharing those photos by choice and what can happen, about people asking them to share those photos on the internet. There are lots of conversations that need to happen, but those start much younger with the conversations of boundaries and setting boundaries, and then they grow. So it's something that has to be discussed. And it is also a way that kids are ending up in juvenile incarceration when they think, funny, I'll share this with a friend. I'll share this with somebody. I'll show it to somebody. They don't always know the implications of that. Even if they're doing it to be funny and not to be bullying or mean, it's the implications. The law doesn't give a shit if you thought it was funny, right? So with all of that, it is something that I used to talk at high schools about and haven't since the pandemic. And it really did open my eyes, the amount of kids who came up and talked about the issue with images and with social media images. And I get it. My ass looked so much better at 15, 16 than it does now. Like, I get it. I get where the brain and the impulsivity is like, this is a great idea, because they just don't know. And they shouldn't know. And them not knowing is because they're trusting. And you want them to still be trusting, but they need to be cautious and trust but verify. And I get it. And the impulsivity is so hard. And the teenage brain is not done yet. And it is just so hard. But with teens, decisions can have very long ramifications, and we live in a very, very different world. And there are so many on the internet that would pretend to also be a teen that aren't. So they aren't always dealing with who they think they're dealing with. And those predators absolutely convince kids to do things that they shouldn't be doing. So we talked about that a lot in the Duggar case. We're going to leave that here for now. But yes, it is a huge ongoing problem, which is why I wanted to cover the Scandoval case, because even if you don't follow reality TV, the conversation and the topic is incredibly important. Diana said, EDB, even if Morrissey didn't see the rounds until court, CSI Popple did, right? Correct. And that is why Morrissey knew. She logged them in along with all the other rounds and evidence. Yes. Would it be fair to say Popple knew? Yes, Popple knew. She always seemed fishy to me. Popple knew, and Popple misrepresented that in testimony. Popple knew. And if Popple knew, then the law says Morrissey knew, because Popple knew. Stephen said, curious about the legality piece of Tom's suit, legality versus morality. I don't believe in sharing phone passcode. They can give anyone, including police, access to my phone. Obviously, don't cheat and don't do illegal things. If he shared it, it undermines his argument. You don't have to share, but if he did, it can undermine his argument. Shelly said, Mom and Dad married 62 years. For their 40th, he took her to see Tina Turner. Oh, that sounds amazing. Cass, your mama said, went to see Alanis and Joan Jett last night. That sounds fucking amazing as well. We're going to take a moment to say thank you to the gifters. Not just me, but Meg, thank you. Shanique, Floyd, thank you. It's good to see you. Melinda, thank you so much. Misty, Eddie, welcome. Katie, thank you for the gifted memberships. Thank you, everybody, and welcome. There's a lot in the members only spaces. Enjoy. Charlie, good to see you, Charlie. It's been a minute. I hope you're doing really, really well. Just finished my first year of law school. I hope you have recovered really well. It's good to see you. I hope surgery went well, and I hope that you are just absolutely thriving. Good to see you in the chat. Cassie said, I've been a ride or die since Tati. You educate and communicate with respect, and that's mirrored in the Law Nerd community. That's why you are #1 stream for live coverage. Thank you for being you. This is my Law Nerd tuition. Cassie, thank you so much for the generous super chat, and I appreciate everyone who's gifted memberships because we know this stream is going to have all of its own monetization issues, and we don't give a fuck. Why? Because we're Law Nerds. We don't have to give a fuck. Now we get to be Cartman. We get to do what we want. We get to do what we want. Music to My Soul said, wait, is the way I crave rules and structure related to neurospiciness. That has been my experience. Why? Because we don't have to read as many cues. If there are rules, then we just can follow the rule and then everybody's on the same page. And then we don't have to figure out what the rules are. If the rules are clear, then we know. Figuring out social norms, rules, and the rest of it can be very hard for the neurospicy brain. And having those rules and groundedness in those rules can just relax your brain a little bit because you know what's expected. Unspoken expectations. This came across my Instagram way too late last night, but unspoken expectations are secrets. They're not expectations. So when there are rules, you know what is communicated. Communicating expectations, rules, norms is so helpful. If it's not communicated, it is a secret and it is not your responsibility. Jamie said, so 3 actual jurors came forward and not just heard it from a friend, and not just heard it from a friend who, heard it from a friend who. Yes, 3 now. 3 jurors have come forward. Enchanted Wing says, Emily, could you cover Stuart McMillan? I don't know anything about that. Monet CEOs. Heard it was spicy and would be fun to cover. I don't know anything about that. Is it Monet, Monat, Mo something? I mean, I will try to put it on the docket and take a look. Spicy is always good. Civil is always also nice. It's been very murdery in the coverage lately, so it's civil. Civil. Melissa, thank you so much. We definitely need food court. We probably also need a pickle. I moved for code blackout. You need black lights and a dramatic curtain that drops down behind you with neon spray. I don't know. I don't know about that. So that is the place where I'm at a disadvantage in all of this truly is that I haven't followed everything that went on. And I told you guys going in, I haven't followed anything that went on in the sphere of the internet with relation to this case. I wanted to go in as a juror. Now the internet sphere of this case is impacting the jurors, but I'm definitely at a disadvantage because I do not know. Rhodes said it's impressive how eloquent you can be while in furious rage. Trial attorney. I was a trial attorney. And you have to. Sometimes rage makes you still. Actually, my most terrifying friends, all litigators, rage makes them still. And we saw that in Spyro in court, right? Like the more Morrissey talked, the calmer he got. It's either a trauma response or a skill or both. Shane, it's good to see you. Karen Reed Mistrial, fulfilling as Game of Thrones season 8. Hannah said, can we please go through Karen's pretrial motions? Yes, at some point. Do we have time now? No. Summer Love said, skipped out for Sandoval, ran back for Karen. This is why we have the app. This is why we have the app. Team Baker. Thank you. This is why we have the app. You know who suggested the app, chat? You want to know who suggested it? Y'all. Mebo said no attorney should have to hire an attorney. Attorneys are the ones who know that they should hire attorneys immediately. Immediately. And EDB, I don't have time to stream 4 hours today. We're covering all the things 5.5 hours later. Almost 6. Just ignore me when I say things. Well, no, not all the time. When I say I don't have time, things will get pushed and we will make it work. It will be fine. So Kelly Kell said, EDB, I've had an entire day since I saw you this morning. I hope it was productive. There's timestamps. SR said he regularly allowed Ariana to check his phone because she was getting suspicious. He said on air that he normally deleted that kind of stuff so Ariana wouldn't find it, but got busy and forgot. I had forgotten that. He did. He did. So him saying that on camera is gonna come up. It's just gonna come up. So it is hard. Gee Whiz Allison. Dyslexia. It's hard to parse words. Thank you. Allison shared, I've been a patient at the Meadows for severe PTSD. I'm sorry that was your experience. I am glad that you had support. I can tell you it's not some country club of a program for the rich and famous. It was incredibly hard, gut-wrenching work. Good for her. And yes, I think asking for help can be incredibly hard, no matter what the reason you need to ask for help is. Asking for help is incredibly hard and needed. And asking for it when you need it is hard, even when you feel like, why me? Which I think so many that have struggled with depression are like, why should I be feeling this way? It's not a should. The feelings are the feelings. You don't like earn it. It happens. So I think it really matters to talk about the fact that no matter what, asking for help when you need help, no matter what the reason is, no matter what the circumstances is, asking for help is hard. It should always be encouraged and supported. So with all of that, it is, let's see. My husband is asking how much longer this stream is. Dude, you know better. My husband immediately. My husband came home from work early and has spent the day with me and the lawyers, me and the law nerds. Absolutely. And my husband is like, are we going to dinner? Yeah. Yes. I promised Griffin shave ice. And I promised G shave ice. So I need to go and fulfill that promise because the thing that he will say to me is, you need a break. You have streamed for too long. So I'm going to go shave ice with the kiddo and the hubs while my oldest is doing the things. Law nerds, if I did not get to your question, I apologize. It has been a very long stream. For all of the member chats and Brady chats, I see them. I have them. We are going to be in court on Monday. So I will notify you in the app. I'm not sure what time I will start streaming yet. I have not had a chance to look that far ahead because our 2 hours members only stream last night was an hour of tech support and then 3 hours of talking. Because I have no chill and it's been a lot. And I miss talking to you for 8 hours a day. So we've just filled in the spaces. I will not be streaming tomorrow. We have things we have to do. We will be recording the podcast at some point, members. I will notify you. And probably talking about some of the same stuff, actually, depending on what happens. Monday, we will be in court, which means we might shift around the stream on Tuesday or do a shorter stream. Haven't decided yet. We'll talk about it. Julie said, EDB saying I can't do a 4-hour stream today is the equivalent of MedSaf saying, wow, it's really quiet today. Yeah, I did it to myself. I absolutely did it to myself. I jinxed it. It's okay. The conversations I need to have, I can have tomorrow, and that's going to be okay. I was supposed to be in trial this week, so we kind of backfilled to move things along. But that's what it is. So, law nerds, I appreciate you for riding with me for a wild and busy stream. Thank you for being here. Thank you for being a law nerd. We will be clipping stuff down from this stream onto QuickBits. If you are in the app, you will get all those notifications on the QuickBits channel. If you are not on the QuickBits channel yet, let me share it real quick, because that is where we put all of the clip downs if you did not get to hit everything or you need to stay in the loop. So the link will be in the chat, but our QuickBits channel rolls the QuickBits podcast, which is original recording on Monday. So we roll the Quick Bits podcast, and then we also do the breakdowns of the cases. So we've got all the clips. If you need to see just the moment of what happened and are trying to stay in the loop, all of that is on the Quick Bits channel. The podcast that goes out on Monday is on the audio feed. So that is there for you when these streams are to live. Fun fact about Quick Bits is, where is it? This video, this huge mistake video was my first video to reach 1 million views. So that was wild. And that's why I decided to start the Quick Bits channel, was to do quicker content during that trial so that we could have it there for you. The way I hate that YouTube won't allow me to pick the thumbnails on these, girl. So if you're not subscribed to Quick Bits, go subscribe. We also share this out in the app. This is where those quicker videos go. So if you need to stay in the loop and 6 hours of streaming doesn't always work for your life, I got you. Go subscribe to Quick Bits. Look at us. We're almost at 150,000 subs on Quick Bits. Hey-o. So if you need to stay in the loop and time is of the essence, that channel's got you. And then when you have time for the live streams, this channel's got you. Because you know what? Either way, law nerds, I've got you. Thank you for being here. Thank you for being a law nerd. Mods, thank you. I'm sorry. Thank you. And Team Baker, thank you. I'm sorry. Just apologies to everyone who we're going to talk about tomorrow too. Things need to happen. Stream comes first. Law nerds, thank you for being here. Thank you for being amazing. I appreciate you. You are the best community. Thank you for being what I do and why I do it. I appreciate you. I'm going to get all sappy. You guys are the best. And I'll see you in court on Monday. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with Quick Bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the Quick Bits. Thanks for being a Law Nerd.